ಸಿಗೋಣ ಇನ್ನು 5 ನಿಮಿಷ ಹೋಗ್ಲಲ್ಲ. ಅದು ಮಾಡ್ತೀವಿ.
Very good. Thank you. Election tomorrow, madam. Gram Panchayat election by single vote, the petition got elected. That was challenged before civil court. They have to set aside and within a month, in 15th, recounting are.
Recount idly bidding.
Recounting and recounting is not permissible under the law. Under the law, it is not permissible. Within 15-3 order ಮಾಡಿದ್ದಾರೆ within a month ಅಂತೇಳಿ ಬ್ಯಾಲೆಟ್ ಬಾಕ್ಸ್ ತರಿಸ್ಕೊಂತಾರೆ ಬ್ಯಾಲೆಟ್ ಬಾಕ್ಸ್ ಬಂದಿಲ್ಲ in the meantime ಏನಾಗಿದೆ the election of the petition is set aside
and recounting order.
ನಾವು recounting order ಮಾಡಿದ್ದಾರೆ at the same time set aside ಮಾಡಿ ತಪ್ಪು recounting ಆದ್ಮೇಲೆ set aside ಮಾಡೋದು ಅದಾಗಿಲ್ಲ set aside ಮಾಡಿದ್ದಾರೆ
That limited portion. Serve it on the other side.
Ground rent matters tomorrow.
Next matter, Respondent.
Even afternoon ga 2:30 ga illa regular ag barಬೇಕು.
Tomorrow. One submission. Maybe taken to 2:30 madam. The urgency is
What is the urgency for 2:30?
It is encroach the respondent encroach the public road madam, 30 feet road madam, and constructing the school. That is the only way to reach the petitioner property. Tomorrow madam.
Fresh matter. G+2 sanction has been granted. We are completing G+2.
Not for 2:30. You just give your memo. Give your memo. You'll see it when. Otherwise, it will be 170 matters. None of them will happen. They'll check when it will come.
And petition matter actually 3 times I visited matters, fresh matters. These 3 months is not coming. 5 times.
The number told you.
Tomorrow madam.
Register the record.
The bidding plan has been rejected. And similar matter is coming on Wednesday. I want to
Pretty good. Wednesday it can't be coming because Wednesday.
PS matter on Wednesday, you'll have to.
ಅದೆಲ್ಲ ಕೊಡ್ತಾ ಇರ್ರಿ. Only 2:30 mention.
Tomorrow. An election happening.
It will come.
13.
It will come on the basis of number of matters. Unless it's 2:30, don't mention.
Amendments. Number 1. Page number 7. Serial number 40 and 41. Page number 8. Serial number 42 to 49.
Serial number 42, my lord.
Yes.
I for petition.
Hmm.
I pray for week's accommodation. I have informed the other side.
Entry.
About 48 minutes.
48.
From
Yes.
the other side.
Okay, at the request of counsel for respondent released on 26th May.
Page number 9. Serial number 50 to 56.
Inform the respondent. The Siddhartha HM is for R6. Have you informed them? If you're not informed, please don't mention.
Serial number 54, my lord.
Hmm.
Informed the side counsel.
You informed all of them. 54 at the request of counsel for the petitioner released on 22nd May.
On behalf of Mr. P. N. Jaydev, some inconvenience today. I will inform Madam Sanchana as well as the other person for private response.
2. Ms. Sinchana MR has entered appearance for respondent number 1 and 2. Delete Sumangla Dechinmat as that appearance 1 and R2. At the request of counsel for the petitioner released on 22nd May.
Page number 10. Serial number 57 to 61.
Serial number
My lordship, sorry.
57.
Serial number 6.
I have informed other side. Take order.
57 at the request of the counsel for the petitioner released on 26/5.
Serial number 63, my lordship.
63, yes.
For the petitioner, my lordship.
Have you informed?
Please, I will inform the Putago, sir.
Have you informed?
Not at my lordship. Telephonically, I will call in. They are not present.
Informing, please
I will
don't.
inform them.
Without informing, please don't mention. Please see the
Please.
call, serial number 1. What does it say?
Sorry, I will.
Page number 11. Serial number 6. Page number 12. Serial number 7.
Lord, serial number 77. I've informed the petitioner's counsel. I appear for the respondent. I request a week's accommodation, my lord.
Have you informed the other respondent counsel also?
Yes, my lord, I've left a message for respondent 1 and 2, BJ Soumyaji. I have not received anything reply, my lord.
Then please wait.
Yes, my lord.
Soumyaji, adjourn madbada. 77 at the request of
Respondent for 4 and 5, my lord. Respondent 4 and
on 25th May.
please, my lord.
Page number 30. Serial number 78 to 83. Page number 40. Serial number 87 to 94. Page number 50. 95 to 150.
Yes, Mr. Raju. Inform madidira. 29 at the request of counsel for the petitioner released on 26th May.
Page number 16. Serial number 110. Page number 17. Serial number 18.
116. Counsel for the petitioner has filed a memo dated 10/4/2023 signed by the counsel for the petitioner to withdraw the above, accepting the submission and the memo. The petition is dismissed and withdrawn.
Page number 17. 18. 190 to 127.
Informed others.
120.
For petition.
Tail number
121.
121. Request for the counsel for 26th May.
28 to 133.
131.
Respondent. Respondent number 3 to 5. Everyone inform ಮಾಡುವ. Otherwise, they'll come and
Page number 20, serial number 134 to 140.
My lord, serial number 136, my lord.
Yes.
I am appearing for petitioner. I'll inform other side counsel, my lord.
Will inform Beda. Jagdishwara,
Yes, my lord.
130.
Both the counsel. I'll
136.
inform both the counsel.
Counsel for the petitioner released on 29th May.
Much obliged.
Page number 21, serial number 141 to 248. Page number 22, serial number 149 to 157.
That is serial number 157, my lord.
Yes.
I represent the respondent number 1 to 3. I informed the other side also. I needs to file the objections, my lord. Friday I have received the copies. I
157.
informed the other side.
Counsel for respond number 2, 3, and 5 seeks for and is granted 4 weeks time to file a statement of objection. Objections, if any, by 26th May, relist on 30th May.
Please.
152. I informed the other one.
You are for
Petitioner.
the NR Jagdish 152. Shri NR Jagdishwara has entered appearance for respond 1 and 2. Delete the name of Shri Manjunatha V. Rayappa as that appearing for respond number 1 and 2. Counsel for the petitioner seeks for and is granted short adjournment. Relist on 30th May. Interim order earlier granted is extended till next.
Page number 23, serial number 158 to 165. Page number 2. Page number 1, serial number 1.
Serial number, yeah, I have intimated the other side. Respondent number 6 also.
Serial number
50, my lord.
50. At the request of counsel for the petitioner, relist on 30th May.
Order serial number 1. K-Vani and connected matters.
I am appearing for the city municipality.
Who is to file the report?
But it is who I have to respond to the court.
So the commissioner, city municipality Chennapatna
Yes,
had to file a compliance affidavit. You
it
are
requires a week's time. Everything is collected. Only thing is it has to be put in the format.
Shri Gangadharpa learned counsel for respondent submit that the progress report is ready. Given a week's time, the same would be filed after serving a copy thereof on the other councils. Relist on 18th April.
Serial number 2.
18th April.
2 minutes, Narayan.
I'm appearing for
Indeed.
Indeed, has not been secured. I have written a letter to parties. Next week, any date, I'll.
Not, but concerned stated has been produced by me. Along with the statement of objections, my lords, the Panchayat has actually filed a statement of objections. In that, annexure R1 is a sale deed.
Annexure R1. Out.
4164.
When did you file your objections?
Objection statement, my lord.
R1. Sale deed of 15/6/2040.
Yes, my lord.
Then I said you wanted to produce.
They have to send. This is the sale.
Produce and file. This is the sale deed you wanted to produce.
Objection copy.
You had asked for time,
Please, my lord.
produce a sale deed.
Please,
Mr. Rohit says he has already produced it at annexure R1.
copy, they have not shown the copy. Have to verify, please, my lord.
You have to serve it on everybody.
We have served it, my lord, because they came lately. Initially, my lords, we had served. I'll serve now one more copy.
Counsel for respondent number 1 submit that the statement of objections filed by him would be served on the counsel for the petitioner and respondent number 2A. Submit that the sale deed executed by Sri Alagappa has been produced along with the statement of objection at Annexure R1. Counsels to verify, relist on 23rd May.
Serial number 3. Okay,
Respondent number 3.
Later list I will. 4.
Both reject.
Both.
On account of service not being effected on respondent number 2, petitioner had filed application IA number 1 of 2022 seeking for permission to take out notice by way of subservice in a newspaper. The same came to be allowed on 27/2/2023. Today, a memo with a copy of the newspaper has been filed in compliance with the said order dated 27/2/2023. Despite the said notice having been served, no wakalatnama has been entered and we have respondent number 2. Hence, service of notice in respect of respondent number 2 is held sufficient. Registry is directed to print the name of respondent number 2 with the endorsement served through paper publications. Objections Akidira?
For the respondent, only memo of retirement.
No, retirement.
Not representing, not giving proper instructions.
Who is respondent number 2?
Wait one.
Return agide.
Which is the last address known to me.
This is respondent number 3 you have sent it to. Yes. Counsel for respondent number 3 has filed a memo seeking permission to retire in the matter since he did not get any instructions from respondent number 3. Along with the memo, a letter dated 28/2/2023 issued by the Counsel for respondent number 3 is enclosed. The notice sent has been returned unserved with the endorsement left. In that view of the matter, when counsel for respondent number 3 is unable to secure instructions, the memo is required to be allowed. Memo is therefore allowed. Registry is directed to print the name of respondent number 3 in the cause list. There being no purpose, which will be served by issuing a fresh notice since the respondent number 3 has already left. No notice is issued. We list on 29th. The NK Shivaraju has entered appearance for the petitioner. We believe the name of Sri B.M. Alaswamy as that appeal.
serial number 4.
Petitioner in this matter. Your patients have directed the registry that service has already taken place. Last time I noted. Last time.
This agide.
Peace ಆಗಿದೆ acknowledgement ಆಗಿಲ್ಲ acknowledgement ಆಗಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬರ್ತಾರೆ.
Last time, 20.
On 27, 14 kindly see 27/2 order, 14/3 order, and 21/3 order.
27/2.
27/2 order. And then my lord,
Informs receipt of copy.
yes. Then 14/3 also it was repeated.
Yes.
Then on last date 21/3 also it was repeated. Despite that, my lord, 22/2 order repeat ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಎಷ್ಟು ಕಾಪಿ ಕೊಡಬೇಕು ಅಂತ registry wants. ನೀವಲ್ಲ, registry wants to give you so many copies.
ಅವರು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡೋದಿಲ್ಲ.
Despite it being noted in the orders dated 27/2/2023, 14/3/2023, and 21/3/2023, that Sri B.J. Somyaji has received copies of the petition along with copies of the annexure. Even today, endorsement is found on the cause list that the service is not effective. Registrar Judicial is directed to look into the matter and issue necessary instruction. the concerned case workers and place a report relating thereto on the file of this, on the file.
R3, I believe, has not filed his wakalat.
Actually,
That is what I find. R1, R3 was subsequently impleaded. But he entered appearance. Wakalat is not filed. I think.
Kannamangala Gram Panchayat.
Oh,
I filed today.
BJ Somaji for R1 and R3 ಅಂತಿದೆಲ್ಲ.
ಇದೆ ವಕಾಲತ್
ಇವರು ಅವ್ರಿಗೆ ಟೈಮ್ ಬೇಕು.
ಅಲ್ಲಲ್ಲ ಟೈಮ್ ಅಂತಲ್ಲ ಅವ್ರ ಹಂಗಂತ ಹೇಳ್ತಾರೆ.
ಟೈಮ್ ಕೊಡಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಅಂತೀವಿ. ನೀವು ರೆಡಿನಾ? ಟೈಮ್ ಕೇಳ್ತಾ ಇಲ್ಲ, ರೆಡಿ ಅಂತ ಇದ್ದಾರೆ.
Yes, to secure records also. I don't know whether records.
ಅವ್ರು ಹೇಳೋದು ಕರೆಕ್ಟ್ ಆಗಲ್ಲ.
Very short point. Whether earlier orders of this court is complied or not. That's all is the question.
You want to address the argument or you want time? What is it?
I leave it to this.
Address the argument. ನಮ್ಗೆ leave ಅಂದ್ರೆ argument. ಅಷ್ಟೇ.
Records versus counter. Records idre I can go on with the matter. Absolutely no.
Counsel for the petition submits that the records are required. Learned counsel for respond number 1 and 3. Submit that ಯಾವ್ದು ಬರುತ್ತೆ records. ಇದೆಯಾ? Records ಇದೆ.
Fine. I'll kindly take it. I am ready.
Both of you are ready or not ready?
If records are available, I am ready. If records are available, Lord, I wanted the records to be secured. Learned friend says he has secured it. I am ready.
Counsel for respond number 1 to 3 submit that the records have been secured. Counsel for the petitioner seeks for a week's time to go through the same and make a submission.
Please.
Released on 23rd May.
Number 5, Ravi Kumar.
Number 1 and 2.
For appellant, my lord. I thought R3 has refused to take the notice, can be posted as exporting,
Steps to be taken.
which come as the unclaimed.
Unclaimed is not refused. Be clear on what your submission is, unclaimed or refused.
Unclaimed.
You have been asked to take, that request has been rejected and you have been asked to make payment of process fee. And you still haven't made. Counsel for the petitioner once again seeks for short accommodation to make payment of process fee and furnish copies in respect of the person named in IA 1(3) of 2023. Needful is not done by 17th April. The petition shall stand dismissed against respondent number 3A to 3A and B. If process fee is paid by then, registry is directed to issue notice to R3A and B returnable by 5th June.
Serial number 6, Sayyid Zamir Pasha.
None appears for the petitioner and no steps have been taken to bring the legal representative deceased petitioner on record. It appears that the legal representative of the petitioner is not interested in prosecuting the matter as such.
Yes, Samir Pasha is no front. Last.
Deceased petitioner. The counsel for the petitioner is informed to be normal. Issue court notice to the petitioner, returnable by 6th June.
He cannot be located as the petitioner. ಹಾಗೆ.
The counsel for the petitioner is no more. Notice issued to the petitioner has been returned with the endorsement. Addressee cannot be located. In such a situation, I have no option but to dismiss the above petition for non-prosecution.
Serial number 7, Vinod Reddy.
Petitions for the
Lordship, for last time, the preliminary hearing was heard, Your Lordship, by Your Lordship. And
You have to take out notice on R4 because there is no such person and you have to give them proper address.
Lordship, I'm filing a memo for this, to report a proper address.
File it with the registry. Counsel for the petitioner submit that you would be furnishing the proper address of respondent number 4 along with process fee and copies. If the needful is done, registry is directed to issue notice to respondent number 4, returnable by. Yeah, is M. Narayanappa for respondent number 4.
No more.
Shri M. Narayanappa, the counsel for respondent number 4 is reported to have expired. The counsel for the petitioner seeks for 1 more week's time to furnish proper address of respondent number 4 for purposes of the needful is done. Registry to issue notice to respondent number 4, returnable by 12th June. Registry is directed to delete the name of Shri M. Narayanappa as that appearing for respondent number 4.
Figure number 8, Pawan Chandra Shetty.
Yes. So,
Figure number 9,
My lord, I appear for the proposed fifth respondent, my lord. I filed an application for impleading. I pray for weeks time to rectify objection. Though it says the petitioner has to comply, but actually I have to comply. I have filed this IAM.
I appear for the third respondent corporation.
I have to file.
proposed respondent number 5 seeks for a week's time to comply with the office objection raised on IA-1 of 2023, relist on 25th May.
figure number 10, Manjulata N.
Then
Kindly say page part 4, Mala.
clarification in ಆಗಿಲ್ಲ division bench ಅಲ್ಲಿ ಇನ್ನ pending ಇದೆಯಲ್ಲ ಮಿಸ್ ಕೋಟೆ
ಇಲ್ಲ dispose ಆಗಿ
dispose ಆಗಿದೆ
ಹೌದು page part 4. It commences part 2 operative force. The same place they are seeking permission. We cannot give permission because of PAL order.
None appears to the petitioner. Liberty having been reserved to the petitioner to seek for clarification from the division bench has also not been done. It appears that the petitioner is not interested in prosecuting the matter as such the petition. He is dismissed for non-prosecution, once again reserving liberty to the petitioner to approach the division bench for any crime.
Figure number 11, KV Narasimhan.
For respondent 1 to 5, my lord, as the disobedience application is concerned, I have served the copy, my lord, on the other side. I will file the application. The last occasion, your lordship was pleased to direct the chief commissioner to file his affidavit.
Affidavit.
What is the action taken against these concerned officers?
My lord,
What is the action taken against the concerned officer in this matter?
this matter, my lord, it is not clearly elicited as.
See, general ಆಗಿ ಹೇಳಿದೆ.
General ಆಗಿ ಹೇಳಿರೋದು, but whatever action, my lord, as far as this particular is concerned, my lord, the actions have been taken regarding issuance of letters and communications to the Registrar General of this Honorable Court, as well as.
What have you done? Have you filed your wakalat?
Please, my lord, I have
Have you
also,
filed-
I have also filed a memo, my lord, stating the actions which have been taken by the trial court counsel.
No,
Memo,
no.
my lord, has also been filed. Totally, there are 4 applications.
An affidavit of the, sorry. An affidavit of the Chief Commissioner of the BBMP has been filed, which reads as under. The rule of the same indicate that there are how many litigation conducting officers have been appointed?
My lord, there are 8 zonal officers. As far as the litigation officers are concerned, my lord, it's in document number 2. Around 27 litigation conducting officers, my lord, which is found at page number 30 and 31.
7 litigation conducting officers who have been nominated, who shall be primarily responsible to coordinate between the panel advocates of BBMP and the concerned officials by providing necessary details, information, parawise comments, or documents. Apart therefrom, 8 zonal officers have also been appointed to coordinate with the advocates for quick and efficacious disposal of the cases by providing necessary information. It is on that basis that it is submitted that henceforth all litigations pertaining to the BBMP will be handled diligently, monitored and defended diligently. The said submission is taken on record. In the affidavit, it is submitted that a communication has been sent to the Registrar General for obtaining login credentials to access online digital case diary. The Registrar General is directed to furnish the same to process the said application and furnish the necessary information at the earliest. A further submission has been made that a proposal has been sent to the Secretary Department of E-Governance, Government of Karnataka, to implement the CCMS platform and e-office software in the BBMP. The state party naidete.
State is not.
Wherein AGA the Secretary Department of E-Governance is directed to do the needful and provide and to get the CCMS platform and e-office software implemented in the BBMP at the earliest, not later than 6 weeks from today. A report of compliance to be filed in regard thereto. The learned AGA is directed to inform the Secretary E-Governance, Department of E-Governance about this order. The registry to print the name of the learned AGA, the Orno party madbekala.
I'll make.
The Secretary Department, the state of Karnataka represented by Secretary Department of E-Governance is brought on record as respondent number 22. And AG accepts notice thereof. Direction. Yes, now what is the status? Another memo has been filed by the Counsel for Respondent number 125. Stating that application under section 151 of the Code of Procedure has been filed for recalling the order, taking the written statement of BBMP as not filed in OS number 26373 of 2022. As also another application has been filed to reopen the stage and permit the BBMP to file its written statement. And a further application order 39 rule 4 for vacating the interim order passed, and an application order 7 rule 11 for rejection of the plaintiff. And the matter is now.
My lord, it was listed on the 7th, my lord, in all probability.
Called today.
It's in all probability, it will be called today, my lord. It was listed on the 7th.
Was listed on 7/4, but will be called out today. He seeks for and is granted 3 days time to place on record the further progress in the matter.
Please.
Relist on 17th April.
What is the objection? Any disorder by the
Well, my
My lord, a small clarification. It was mentioned as Registrar General, my lord. It can only be read as Registrar General of the High Court, my lord. In the affidavit, it was just mentioned as communicated to the Registrar General.
Karnataka High Court of.
Okay. On the 17th. 17th. Public. Okay.
Serial number 12.
My lords, I appear for the petitioner, my lord. I request for a week's accommodation. My lords, I was required to implead 350 people, my lords. They are not able to obtain the certified copies of the sale deeds. They have applied and they required some time and the problem, that is what I had explained on the last date also. What has happened is that 2 managements have changed and there are no records available. That is the difficulty that they're facing. Please give me another 10 days time, at least insofar as 4 or 5 people they're saying that they'll get the details today. And we've also asked them to apply to Muda to get the Khata details of all of those people. So Allinda Sikidra, Allinda Tokumbarta.
Given you 2 months time now, virtually.
I made the submission on the last date, 20th of March. 20th of March, I made the submission. Solpa accommodation.
Seeks for and is granted 1 more week's time.
Haddina Kodisam. Haddina.
Relist on 18th April.
I may request for 19th, so 19th if it's convenient. 19th.
20th April.
Serial number 13. Private party discussed on 29th March.
Notice to respond number 4 has been dispatched on 29th March, awaiting service, released on 23rd May.
Serial number 14. ST Vatan Kumar.
Petition is case, madam.
Kumar.
After filing the above petition, the complaint or consider my representative and form the board.
ನೀವೆಲ್ಲ ನಿಮ್ಮ ಆಫೀಸಲ್ಲಿ ಮಾಡಿ ಇದೆಲ್ಲ ಬರದೇ ಬೇಕಾಗಿಲ್ಲ. Counsel for Respondent number 124 has filed a memo enclosing with photographs to show that the repair work of the road has been completed. And counsel for the petitioner submit that indeed the work has been completed. In view thereof, nothing survives for consideration of our petition.
Dated 21. And that is the acknowledgement. The only happy subjection is also kindly.
First time, but order agidya.
Order agide.
Pawan Kumar for 6, Venkatesh Advati for 7. Service agidya.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ.
That counsel for. ಯಾರು ವಕಾಲತ್ ಹಾಕಿಲ್ಲ ಇನ್ನ. How long does it take to get wakalat?
In legal cell also, lot of hands are also.
Just 20 days.
No, the files come to me and bit late, not on the same day. I have given the copy to legal cell. Another 1 week we will file now.
All the counsels for the respondent seek for and are granted a week's time to file the respective wakalatnamas and make the submission as regards the status of the pending bills. See list on 18th April.
This objection is page 81. Yes, it is legible, maybe overruled.
81.
Page 81.
Office objection as regard legibility of annexure F3 is overruled.
What is it? The public.
Is to be conducted in respect of
Yes.
What is ready, my lord? Sir, a copy and file the report. Report one. Receive the report.
And if survey has been carried out, you will furnish copy of the survey report to the counsel for the petitioner and respond number 1, 3 and 4. Objections, if any, to the survey report to be filed on or before 23rd May, released on 29th May.
17 interim order.
Interim order earlier granted is extended.
Rajshekar.
They have not completed the interim order.
I have no submission.
The order dated 1/3/2023 has not been complied with by the petitioner. As such, the interim order passed on 1/3/2023 should automatically vacate on 29/3/2023. The respondent would therefore be free to take such action as may be necessary. By bringing the property for resale by way of an auction. Since the petitioner has not complied with the conditions, there are no merits and or equitable consideration available for the petitioner to be considered in the present matter. The petition therefore stands dismissed. Please.
Yeah, complied. So the endorsement already passed.
My lord, we have now issued a letter endorsement saying that furnish certain additional documents including plan layout and they will grant us 11B Kata. Just a vacant plot or vacant site over there. There's no development of the property or anything. Copy of that endorsement is just served on us this morning.
Saru kuda madide once kottidare.
Furnish these details. Furnish the details.
My lord, details have been furnished. The photograph application, after that, those details have been furnished.
Have you uploaded it on the website?
Yes, my lord. Only with respect to this plan layout, they are insisting on the plan layout. This is just a vacant site. We have not, there's no.
You have not obtained any plan.
Plan layout is required, master.
Plan building plan ತಗೊಂಡ್ರೆ ತಾನೇ ನಿಮ್ಗೆ.
No intention to develop the property as of.
3 acres of the conversion property. Single layout plan. As per the DC conversion action B ಪ್ರಕಾರ ಹೋದ್ರೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್
ಅಪ್ರೂವ್ಡ್ ಪ್ಲಾನ್ ಬರಲ್ಲ ಅದು ಬರೀ ರೆವೆನ್ಯೂ ಸ್ಕೆಚ್ ಅಂತ ಕೊಡಬಹುದು ಅಷ್ಟೇ.
ಇಲ್ಲ ಮಾಸ್ಟರ್ ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಇದೆ ಮಾಸ್ಟರ್. ಸೆಕ್ಷನ್ ಬಿ ಪೇಜ್ ನಂಬರ್ 17.
Yes.
ಥರ್ಡ್ ಒನ್ ಮಾಡಿ. ಈ ಜಮೀನಿನಲ್ಲಿ ಉದ್ದೇಶಿಸಿರುವ ಬಡಾವಣೆ ನಕ್ಷೆ ಹಾಗೂ ಪರವಾನಗಿ ಇತ್ಯಾದಿಗಳನ್ನು ಸದಸ್ಯ ಕಾರ್ಯದರ್ಶಿ ಬೆಂಗಳೂರು ಅಂತಾರಾಷ್ಟ್ರೀಯ ವಿಮಾನ ನಿಲ್ದಾಣ ಪ್ರದೇಶ ಯೋಜನಾ ಪ್ರಾಧಿಕಾರದಿಂದ ಅನುಮೋದಿಸಿಕೊಂಡು ಆ ನಂತರ ಅನುಮೋದನೆಗೊಂಡ
ಕನ್ವರ್ಷನ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನಾದ್ರು ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಿ ಪ್ಲಾನ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಲೇಔಟ್ ಮಾಡಬೇಕು ಅಂದ್ರೆ ಟೇಕ್ ಇಟ್ ಫ್ರಮ್ ದಿ ಪ್ಲಾನಿಂಗ್ ಅಥಾರಿಟಿ ಅಷ್ಟೇ.
ಹೌದು.
ದೇ ಆರ್ ನಾಟ್ ಡೆವಲಪಿಂಗ್ ದ ಲ್ಯಾಂಡ್, ದೇ ಆರ್ ಕೀಪಿಂಗ್ ಇಟ್ ಆಸ್ ಎ ಸಿಂಗಲ್ ಪೀಸ್.
ಕೂಡ ಬೇಕು ಅಂತ ಅಷ್ಟೇ.
ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡೋವಾಗ ಮಾಡ್ತಾರೆ, ಇವಾಗ ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ಆರ್ ಯು ಫೋರ್ಸಿಂಗ್ ದಮ್ ಟು ಫಾರ್ಮ್ ಎ ಲೇಔಟ್? Can you force them?
ಅಲ್ಲ, ನೆಸೆಸರಿ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ನೆಸೆಸರಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನು ಕೊಡ್ಲಿ ಮಲ, ದೆನ್ ಐ ಡಿಸೈಡ್.
ಕೊಡಕ್ಕಾಗಲ್ವಲ್ಲ, ಪ್ಲಾನ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡೋದು ಬೇಕಾ ಇಲ್ಲ, ಲೇಔಟ್ ಮಾಡೋದು ಬೇಡ ಅಂತ ಇದ್ದಾರೆ. They don't want to form a layout.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ, ಏನು ಸಿಂಗಲ್ ಈ ಜಾಗ ಇದೆ, ಈ ಲೇಔಟ್ ಅನ್ನ ನಾವು ಪ್ಲಾನ್ ಅಪ್ರೂವಲ್ ಮಾಡ್ಕೊಂಡು ಬಂದ್ರೆ ಮಾತ್ರ ಕೊಟ್ಟಕ್ಕಂತ. ಆಕ್ಚುಲಿ 11E ಖಾತೆ ಕೊಡಕ್ 11B ಖಾತೆ ಇಶ್ಯೂ ಮಾಡ್ಬೋದು. 11E ಕೊಡಕ್ ಬರಲ್ಲ. 11B ಕೊಡ್ತೀನಿ ಅಂತ ನಾನು ಹೇಳಿದ್ರಲ್ಲಿ 11E ಕೊಡಕ್ ಆಗುತ್ತೆ, ಯಾಕಂದ್ರೆ ಅದು ಸಿಸ್ಟಮ್ ಆಪ್ಷನ್ ತಗೊಳೋದಿಲ್ಲ ಅದು.
Then you have to change your system. You cannot force a person to develop a layout and sell it or keep plots and surrender roads and civic communities to you.
ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಸಿಂಗಲ್ ಲೇಔಟ್ ಮಾಡ್ಕೊಂಡ್ಬರ್ಬೋದು. ಸಿಂಗಲ್ ಲೇಔಟ್ ನ ಯಾಕಂದ್ರೆ ಟೋಟಲ್ ಏನ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಸಿಂಗಲ್ ಲೇಔಟ್ ಪ್ಲಾನ್ ಮಾಡ್ಕೊಂಬನೆ ಅಂತ ಕೆಲಸ. ನಾಟ್ ಫಾರ್ ದಿ
ಸಿಂಗಲ್ ಲೇಔಟ್. ಸಿಂಗಲ್ ಪ್ಲಾಟ್ ಲೇಔಟ್ ಹೆಂಗಾಗತ್ತಪ್ಪ? ಸೆಕ್ಷನ್ 38 ನೋಡಿ, ಆಗತ್ತಾ ಹಂಗೆ? It's not possible. It is only a condition that if they were to form a layout there, they have to take permission. If they don't want to form a layout, they can't.
ಈ ವಿಷಯದಲ್ಲಿ 11B ಖಾತೆ ಕಂಪ್ರೈಸ್ ಖಾತೆ ಇಶ್ಯೂಡ್ ನೋಡಲ್ಲ, ಅದನ್ನ ಇಶ್ಯೂ ಮಾಡ್ತೀವಿ. ಬಟ್ 11E ಕೊಡಕ್ 11B ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಸ್ಪೆಸಿಫಿಕಲಿ ಮೆನ್ಷನ್.
What is the problem? You give us a legal reason, we'll accept it.
Legal reason ಇದೆ.
This is not a legal reason.
That's why I'm given the endorsement.
That is not a legal reason. You can't force a person to develop a property. They may keep it vacant for another 50 years. You can't force. And if your software doesn't allow it, you will have to change your software. The memo has been filed by respondent number 3, stating that if the petitioner were to submit a photograph of the petitioner, identity card of the petitioner to the Gram Panchayat under the Iswatu software form number 11B, and under the Iswatu software, form 11B would be issued to the petitioner. And if the petitioner were to submit an approved plan and orders of the competent area development authority, form number 9 and 11A would be issued through the Iswatu software. In this regard, he places reliance on condition number 3 to the conversion order dated 22/8/2012 and submits that unless a development plan is obtained, unless a layout development plan is obtained, Tata in terms of 11A could not be issued. And further, that the software does not permit the same to be done. He said submission gives rise to a very anomalous situation, in as much as a citizen of the country who does not wish to develop the property into a layout would be forced to obtain a plan sanction for a layout in order to obtain 11A kata, which is
single layout.
Single
layout, single window, total property, single window layout.
Shows the provision where it can be done. KDCB Act ಅಲ್ಲಿ ಇಲ್ಲ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗಿದೆ, ಜಸ್ಟ್ ಕ್ಲಾರಿಫೈ ಮಾಡಿ
ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಅಂದ್ರಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್.
17 is my lord. KDCB Act, my lord. Once my lord, planning authority cannot release my lord, there cannot be a custom judgment. 17E ಅಲ್ಲಿ ಇದೆ.
17
E.
73 of the PCP Act.
Please.
When was it introduced?
And also subject matter ಅಲ್ಲಿ commercial ಗೆ ವಾಣಿಜ್ಯ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಅಂತ ಕೇಳಿದ್ರು ಸ್ಪೆಸಿಫಿಕ್ ಕಮರ್ಷಿಯಲ್ ಪ್ರಾಪರ್ಟಿ ಕಮರ್ಷಿಯಲ್ ಪರ್ಪಸ್.
Yes. 70. ಯಾವುದು? Okay. He is not there.
Lord, amended. Is amended.
2021 we had. Amended when?
Lord, 2021 alle ಆಗಿದೆ. 2021.
ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇದೆ. Lot.
(17(2)(e) na?
Last bottom.
Any building site which has not been released by the planning authority.
If my lord, the conversion order itself say that my lord, the single plot plan, my lord, regarding commercial uses. Application filed by the conversion regarding to my lord.
So develop a single plot is included under 17(1).
Also, my lord, there is one judgment is there, my lord, this honorable court.
Is one hanging amendment.
Lord.
Single plot has been added,
Please, my lord.
but rest of it all speaks of subdivision.
Respect of my lord, the subdivision also, my lord, in 17, my lord, clearly say that 2A's clearly say that, my lord, single plot, layout and my lord, subdivision.
So what is the application to be made for now?
My lord, is seeking for the single plot for the commercial.
Yes.
Commercial plot is concerned.
Yes.
If my lord, they given a commercial plan, my lord, before the authority, my lord, we have given NOC. Thereafter, my lord, issue the khata. Otherwise, my lord, they, my lord, without taking any plan, my lord, they will develop land. That is the object of the law, my lord.
The plan will come about for building plan later.
Conversion, not building plan, my lord, development plan. 17 is the development plan, my lord. 15 is the building plan.
Right, but now if the single plot is not to be subdivided, still a plan is to be submitted.
In respect of my lord, development is concerned. They seek permission, my lord.
So what does it have to have?
Development meaning, my lord, kindly say, my lord, 2(1)(b), my lord, in KTCP Act, my lord, clearly said, my lord, any changes in the land, my lord, it's clear to them, my lord, seeking for the development, the permission from the planning authority. One C, my lord, definition clause. The development itself, grammatical variation means carrying out of the building, engineering, mining, or other operation in or over or under the land or making any material changes.
The amendment which is come, madam.
Then we passed over.
It's passed. Pass.
the petition. Once the petition has been filed, announcing the action of the respondent in constructing the stormwater claim, and the petitioner without seeking permission, any prior permission from the petitioner or acquiescing their land. Minutes by order dated 7/3.
We had restrained them.
Restrained them. Minutes thereafter, the petition respondents have continued with the construction. We have also preferred a contempt petition, my lord. The contempt petition has been.
In fact, we approach because both are statutes of the government of India, IT Limited. The corporation approached the IT Limited, seeking permission to give permission to lay the drain, but because of the lake water is flowing out of in the property vicinity, they were only permitted to construct. We have started the construction, and we have a meeting with the petitioner, my lordship. Thereafterwards, they did not get the permission of the central government. Therefore, they filed petition. Now we are approaching the concerned authority, give a permission, take the compensation or instead of cash compensation or TDI. In the meantime, they approach this court, the interim order granted by this court. Immediately, my lordship, on 8/3/23, my lordship, the engineer has returned the letter to the concerned the developer to start the construction. By virtue of the letter issued by the corporation, but to the concerned engineer, the concerned developer, he stopped the construction. A week's accomplishment kindly granted by my objections.
My lord,
Yes, madam.
my submission, my lord. Is
In
that-
fact, 8/3 itself, we returned letter to the concerned developer, followed on 10/3 also. It is not that, my lord, we are not giving compensation, but because there is a threat of the entire locality is going to flooded. That is the reason we approach the petition, my lordship.
on this was
They have to get the
considered
permission from the central
on
government.
7/3, my lord. In light of that itself, my lord was need to observe that till that process is completed, without seeking consent, with or without oral discussions, my lords, no written consent has been taken from the petition, and hence respondents were restrained from proceeding with the construction. While this being the case, construction is going on day-to-day basis. In fact, now they are threatening us, my lords, that they will.
My lordship, the engineers are before the court, concerned engineers are before the court. See,
We'll appoint a commissioner now to visit the property and come back at.
your lordship can appreciate.
Tell us
They
if.
filed an application for police protection. Let the application, my lord, and let the.
Mr. Jagdishwara, look at the situation. One arm of the government making allegation against another arm of the government.
Yes.
If it is a private party, at
Like
least, you know,
that, it is not.
come out and go there.
It is not increase the corporation to violate the interim order by this court. Immediately after interim granted by the court, she has written letter to the concerned engineer.
That may be your instruction. But the here in categorical submission, this construction is going on even today.
Yes, even today.
Before the court, the work is being.
We'll appoint a commissioner, at their cost, obviously. Any young member wants to be a commissioner? Anybody wants to go and have a? Nobody wants to come.
I'll file a memo with the independent party's name, my lords.
In fact, my lord, even after filing the writ petition, my lordship, we approaching the concerned department to seek a permission to complete the construction activity. Take the compensation, you are not here to.
To Amel Bharat, whether they are permitting you to,
Yes.
whether acquisition has to happen, if they are saying that they have not permitted you.
Yes.
But when they have not permitted you, you can't go there and do this.
Yes. In fact, my lordship.
And if you have not done it, and there's a baseless allegation made, we'll take action against them.
In fact, my lord.
The deponent to this affidavit will have to face the music.
My lords, in fact, we had a joint meeting with the concerned department officials, and we had took the photographs of the concerned officials, and they gave a permission to complete the construction activity.
Where is it in writing?
I
I
highlighted
think my
right.
lords was highlighted on.
That is the reason, my lordship, I seek 1 week accommodation, so that I'll place all records before this court, my lordship.
You place it, but today we are concerned whether construction is going on in spite of the interim order.
The information, my lordship, as per the engineer, the work has been stopped. The present engineer
As
before
on
the-
the date of filing the application, my lords, it may be given in writing that they have not done anything. I have filed it on 5/4. Contempt was filed on 10th March, my lords.
No, you are saying today the construction is going on.
My lords, as per my instructions even today, and that's why in fact.
Because if it has stopped earlier, there is no point in appointing a commissioner. If it is going on today, we can appoint a commissioner. What is your submission?
It may be, commissioner may be kindly appointed. My lords.
Please be very clear. If construction is not going on, this deponent will face the music.
My lords, may kindly
If
pass.
it is going on, the engineer will face the music. Either of them will have to face the music.
Find this application on 5/4, my lords. I just seek instructions as on today.
Pass over, you get instructions and mention at 1:30.
Please.
And also see if both of you can arrive at a common thing.
Great.
Pass it.
Bill number 20.
ನಮ್ದು ಸೀಲ್ ನಂಬರ್ ಎಷ್ಟಪ್ಪ ನಮ್ದು
41, sir.
ಇರ್ಲಿ
20.
Yes, 20, Mr. Karegi. Survey report. Survey report. Survey report. ಆಗಿದೆಯಾ ಸರ್ವೆ ಆಗಿದೆಯಾ? Has the survey been carried out?
ಸರ್ವೆ ಆಗಿದೆ.
ಆಗಿದೆಯಾ?
ಆಗಿಲ್ಲ, ಸರ್ವೆ ಆಗಿದೆ.
ಆಗಿಲ್ವಾ?
ಆಗಿದೆ.
Pass.
21.
Petitioner. I have moved this report, my lord. So, elation. Report has been filed. Even before the report, my lord, the respondents have issued a notice which I have produced along with my IA, annexure G, my lord, which clearly indicates that he has violated. Annexure G, my lord, page number 4.
This report also indicates that there is a violation.
My lord, in this report, my lord, violation is the extent of 144%. In my side, he has not left an inch of setback. Moreover, he has obtained only sanction plan for one floor, my lord. He is constructing third floor now.
So what is the action being taken?
Notice, we have issued notice. Calling upon the third respondent to offer an explanation.
Caveat file ಮಾಡಿದೀರಾ?
Pardon?
Caveat file ಮಾಡಿದೀರಾ?
Even today, it's going on.
Caveat file ಮಾಡಿಲ್ಲ, there will be a suit filed. Ex parte injunction, you won't appear, confirmation. The report has been filed by counsel for respondent number 1 indicating that there is a FIR violation to 144.32% in the construction being carried on by respondent number 3. View thereof, respondent number 3 is restrained from putting up any further construction. The respondent number 1 further submits that necessary notices have been issued.
Yes,
So-called notice.
Even today, he has not appeared.
Notice order ಆಗಿದೆಯಾ?
ಆರ್ಡರ್ ಆಗಿದೆ, ಅವರಿಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಇನ್ಸ್ಪೆಕ್ಷನ್ ಆಗಿದೆ. 17ನೇ ತಾರೀಕಿಗೆ ಇನ್ಸ್ಪೆಕ್ಷನ್.
ಇಲ್ಲಿ ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
Kindly see, my lord, 40.
ಏನಾಗಿದೆಯಮ್ಮ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್
44 order.
ಸರ್ವಿಸ್ ಆಗಿದೆ.
Issue notice to respond number 3, returnable by on 17/4. 14/3 order ಮಾಡಿ.
17/4 ಇನ್ನ you mentioned you have moved the matter, is it?
I moved the matter.
Why have you moved?
The construction is going on, my lord.
And that will be brought down, that's okay.
My lord, your lordship can see, my lord. In fact, I have mentioned, my lord, thereafter your lordship has permitted me to.
He said we'll see it when.
Now, your lordship can see, my lord. On the date of inspection, he was present and writ petition was filed, he was also notified. In spite of that.
But there is a date already given for their appearance. We can't expect them to be present today. That would be a violation. We can't order once we have issued notice. 17/4 we'll take it up.
Further construction, my lord.
We can't do that.
Third floor is going on, my lord.
Let the 5th floor go on, it will be demolished. But once a notice has been given, principle of national justice cannot be violated by this court.
I have mentioned on the other day. My lord, I leave it to you.
That is why it has been listed. 144 point so and so. The counsel for respond number 1 said that a show cause notice has been issued to respond. As also a caveat petition is going to be filed by respond number 1 against respond number 3 in the jurisdictional courts. Notice having been issued to respond number 3, 17-4. The request now made by the counsel for the petitioner that respond number 3 would have to be restrained from putting up construction cannot be accepted today. Relist on 17-4-2023. Respond number 1 is however at liberty to take such action against respond number 3 as permissible under law.
22. Happy Sadash Gopal.
Only direction sought is for disposal of the case. It is pending long time.
The copy was not to be on Friday. Second instruction, what our people is saying that earlier as for the new act when it comes before, power transferred to zonal commissioner. Then again it was delegated to Judge Anam. That is why there is no order has been passed on their application under section.
When will you do that?
Some reasonable thing.
What is the reasonable?
Due to election till 13th May, the offices are not working at full strength. 13th May, 2 months.
Not working in full strength. And
all are
not working on their time. The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the proceedings in AAA bracket S PR 1636 of 2009-10.
the main event is regarding an application under section 20.
9-10, we are in 2023.
During that time, the hearings are done, they have appeared, they have participated. After year 2020, they have filed an application under section 20 to transfer the case to Karnataka land grabbing court. That
Have still not been disposed by respond number. Which respondent has to pass order? By the respondents.
Pawan Kumar orders as early as my lord in 2012.
Respondent number 3.
Pawan Kumar submits that earlier the power was vested with the respond number 2 and now it's been delegated to respond number 3. And the respond number 3 will pass necessary orders at the earliest. This is another shocking where a quasi-judicial authority has been sitting on a matter from the year 2009-10.
Between proceedings are held, they have participated, hearings are done. But due to the change of the powers.
How power change? When did it change? When did it change? 2021, after the new act came in.
My instruction, they have participated and hearings are done.
I am not disputing, I have not participated. Order that I said it was posted reserved for orders. Twice, thrice, 4 times, but no orders are passed.
When was it reserved for orders, Mr.
First time, my lord, wait. 19/4/2012, my lord.
And the second time?
Then 7/9/2012. Again reserved for orders on 18/11/2014. And finally, it was posted on 9/10/2015. Thereafter, no proceedings.
This is because of change in officers, or why was this reserved so many times? Was it because of the transfer of officers or change in officers?
Not at all.
Same officer. Same officers, why would you reserve matters 4 times?
Reserved for orders agide or orders madilla. Now ಎರಡು ಮೂರು ಸರಿ orally reminded.
ಅದೇ ಆಫೀಸರ್
ಅಲ್ಲ ಅದನ್ನ ನಾನು ಹೇಳಿದೆ.
ಅದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಏನಾದ್ರು ಆಯ್ತಾ?
2015, I don't know which officer was there and all that. I'm sorry, I'm not in a position to say that.
The submission of Shri R.D. Sadashivappa at consideration the petitioner is that the matter was initially reserved for orders on 19/4/2012, but orders were not passed, and again on 7/9/2012, it was reserved for orders. Again, orders were not passed, and the matter came to be again reserved for orders on 18/11/2014, when orders were not passed, and again on 9/10/2015, matter was reserved for orders. Thereafter, no proceedings have taken place till date. It is rather shocking that for the last nearly 8 years, no proceedings have taken place. So the submission of Kumar is that earlier the powers were vested with the second respondent, now delegated to the third respondent. The said delegation has occurred only after the BBMP Act came into force in the year 2021. There was no impediment for the matter to be taken up from 2015 to 2021. Quasi-judicial authorities are required to consider these kind of matters and pass necessary orders at the earliest, and not delay the matter from 2009 to 2023, when a simple matter like this has been pending for the last 14 years. The first respondent is directed to look into the same and ascertain if any other such matters are pending, and take appropriate action as regards all long pending matters. A report in connection thereto to be filed within a period of 6 weeks from today. Considering that the subject matter had been reserved for orders on 4 earlier occasions and no orders have been passed, and taking into account the possibility of the officers having changed and the matter being required to be reheard, I pass the following order. The petition is allowed. The mandamus is issued directing third respondent to hear the parties and pass suitable orders in case number so and so within a period of 8 weeks from the date of receipt of a copy of this order. If the order is passed in the presence of the counsel for the petitioner and the respondent, the petitioner shall remain present before respondent number 3 on 22nd May at 3:30 p.m. at 3 p.m. to address his arguments. Though the above petition is disposed of, relist on 12 June at 2:30 p.m. for reporting compliance with the above.
23, R.D. Sadashivappa.
This is regarding seeking NOC from the BDA. So BDA has approved the layout and layout is formed. Now they say, not for want of NOC, my lord finds it on page 16, annexure E. Not NOC from BDA. Atha is not being made.
Krishna. Password.
Yes.
24. Manjulata.
When the notices were issued from the AWA section earlier in the year 2022, now the files have been transferred to town planning because the jurisdiction comes for them only. I have received a copy of the notice where they have signed. The father of the petitioner has signed. I will produce the original records.
And counsel for respondent number 224 seeks for and is granted 1 more week's time to produce the original records. Relist on 18/4. Interim order earlier granted is extended till next day.
For dismissal, serial number 25.
I do apologize for the last occasion.
Prashant. Yes.
This is not before.
has held as unconstitutional some of the entries made based on the circular and demand petitioner. What I have questioned is the circular annexure A and B. They are issued in pursuance of Rule 3.5, the BBMP property tax rules. Based on that, they made changes to the classification of properties. In this judgment that my lord is seeing, is classification number 9 and 11 held to be unconstitutional. I come under item number 10, please. Similar situations where I have come before this honorable court to say that there is classification is unreasonable and there is no intelligible differentia in making the classification and saying star hotels irrespective of location and area that where the building is situated. My lord, can kindly see.
Have you framed new rules, madam, as directed?
Should I take a week's time to bring it on record?
They have challenged this before the Honorable Supreme Court, that matter is pending.
You have not framed new rules. 2014 order.
Literally, this judgment, we brought it to their notice after I got this notice. Then they say, "This judgment only 9 and 11 matra idagide, so you are not concerned, but you are under 10, so you have to pay." But the rationale, principle is the same.
Your Lordship, I seek to bring it on.
Counsel for the petitioner submit that though in the present matter what is concerned is category 10, this court in judgment reported in 2014, 1 Karnataka Law Journal 496 had quashed the categorization in category 9 and 13.
11.
9 and
13, I'm sorry.
13. 9 and 13. And the reasoning in the said judgment would be equally applicable to category 10. Learned counsel for respondent seeks for
Your Lordship, 2 weeks time.
vacation. Seeks for 2 weeks time to place on record. Why do you want 2 weeks time?
I don't believe there are no rules for it. Even now, the same.
Place on record the rules, or why do you want time?
Your Lordship, it was listed under dismissal. I do not have clear instructions.
Seeks for 2 weeks time to obtain instruction and make submission. Relist on 23rd May. If you place the new rules, then it will be.
The challenge date in 2019.
No new rules.
Showing as pending, no clear. Showing as pending before the Honorable Supreme Court.
26, DT Sukumar.
Despite the order dated 27/3/2023, none appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting.
27. Very good.
Apology.
Copies ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನ.
This petition, my lord, an interim order was granted. That interim order, my lord, the child writ appeal. Writ appeal got disposed of, I believe, my lord, the file also. So just take a copy and give 2 weeks time. Extremely sorry, my lord.
Today, the counsel for the petitioner appears and he seeks for a week's time to furnish copy of the petition along with annexes on the counsel for respondent. Objections, if any, by 26th, relist on 1st June.
Yes.
Hearing that I get.
Has to go to the respondent number 3, my lord. Have filed a pleading application in a strike party for the
IHP and amendment.
IA2 of
A 193 has been filed to impede proposed respond number 3. Issue notice. Proposed respond number 3 returnable by 12th June.
So for IA number 2 of 23 concern, my lord,
Comply with the.
to produce the legible copies of the annexes.
In the meanwhile,
Some of the
this
documents.
objection as regards IA2 of 2023 to be complied.
59. Deputy Srinivas.
Lord.
Yeah.
Lord, if I pay for a short accommodation, Lord, I have informed the concerned officer, Lord, they have stopped the work, Lord. Order is complied, Lord. Only thing is that there is some records has to be updated. They are not able to.
So when are you going to mark the boundaries?
Lord, short accommodation, Lord, I will.
Short ಅಂದ್ರೆ ಎಷ್ಟು short?
ಅಲ್ಲ, ಒಂದು ವಾರ time ಕೊಟ್ಟು.
ಒಂದು ವಾರನ?
Next week, kindly have it next week, Lord.
And Counsel for Respondent seeks for a week's time to make a submission as regards the boundaries being marked.
Lord, because, Lord, one more submission. On preliminary inquiry, I came to know that the surveyor from the revenue department has shown the land.
Shown ಆಗಲ್ಲ, mark ಮಾಡಬೇಕು.
Lord, because one more difficulty in this case, Lord, government is not a party. This case, Lord, and we have to follow their instructions, Lord. Now, because surveyor has come and shown the place, and because now BBMP will not conduct any survey, Lord. Only their duty is to clear the drainages. If there is any obstruction, they have to remove and make.
You have to clear it, but that's why we are giving you a short time before the rainy season starts.
Please, Lord.
If you have marked it, well and good. But if you have not marked it, mark it.
Lord, BBMP cannot mark it because only surveyor is the concerned authority, Lord. Surveyor has to mark the land. In other cases also, I am appearing, Lord, in Rajkalwe and stormwater drain. Only surveyor is conducting the.
You don't have surveyors in your.
Lord, even otherwise, what happens, Lord, because of the village map and survey department has the original documents, Lord. I cannot have I cannot imagine where it is existing, Lord.
The S.J. Puranik and Counsel for Respondent submits that the marking of the boundaries would have to be done by the jurisdictional ADLR, since the concerned revenue documents are not available with the BBM. You statement ಮಾಡ್ತಾ ಇದೀರಾ, we are recording it.
Lord, executive engineer.
Without that documents, how are you doing this?
Lord, now because of that reason only, Lord, I sought for a short accommodation. Before getting instructions, Lord, it is not proper.
In view of that submission, though for now it is not understood as to how the BBMP is forming the drain without clear marking of the boundaries.
No, Lord, they have marked and shown there. That is why, Lord,
come to you on that. The learned AGA is directed to instruct the concerned ADLR to carry out a survey of the property in question and earmark the boundaries of then Rajakash. What are you contending it to?
Kaluve. It's a
Kaluve,
Kaluve.
Primary, secondary, tertiary.
Secondary is what we told.
Lord, I'm not sure. I'm not sure, Lord, because of the surveyor has to say which class of drain.
How are you carrying out the construction?
Lord, only this, Lord, they have shown they have marked the land and we are doing it. That is the limited scope of the BBMP, Lord. That is the reason, Lord, and on instructions, Lord, on instructions of executive engineer who is present, I am submitting. See, that is the submission made by the concerned officer.
The S.J. Puranik submits on instructions that the drain, that the construction of the drain is being carried out on the basis of
marking done by the surveyor.
Which surveyor?
Revenue department. Revenue department surveyor.
Carried out on the basis of the marking madida.
They have shown the place, Lord. This is the land, Lord. They have shown the place, Lord.
On the basis of the area shown by the revenue surveyor.
Yes.
The same would require further explanation by respondent and an affidavit in that regard to be filed. Correct. In view of the above submissions made, and the impending monsoons, the learned AGA is directed to instruct the concerned ADLR to carry out a survey of the subject property and the existence from a location, from a width and length of the drain as claimed by the BBMP, commencing from 10:30 a.m. on 15th April 2023 and submit a report by 18th April 2023, released on 20th April. Since the order is passed in the presence of the counsel for the petitioner and the counsel for respondent, there is no further notice required to be issued by the ADLR to the petitioner or to the respondent. If the petitioner or respondent choose not to participate in the said survey, they would not be entitled to any equitable consideration.
I have one more. The survey should be conducted in accordance with the measurements contained in the Tiffany and the field measurement book, because it's not a random this thing.
This is a survey to be carried out, taking into account the concerned revenue document by using the total station methodology. Counsel for the petition, counsel for the petitioner to furnish a copy of the petition in all annexures on the learned AGA by end of day today. Interim order earlier granted is extended.
Serial number 30. Joseph Anthony.
Petitioner. Time, my lord, in this.
This matter was listed last week. I challenged a demand issued by Bangalore International Airport Planning Authority, my lord, under various overheads. My lord, whilst granting the interim order, and sanction was directed to be issued to me, my lord. Now, my lord, I have reached a stage where sites have to be released. On the last day, my lordship had made a submission that I will issue a continuing bank guarantee. My learned friend was to come back on.
Let them, my lord, my lord, they will deposit it to authority, my lord. Let them, my lord, they are under protest, my lord, they will deposit to authority, my lord.
Bank guarantee deposit and forget that. Because rare issues will come up.
Please, my lord, that is my concern.
My lord, have no instructions, my lord, regarding my lord election duty, my lord.
That cannot put everything. This is not a policy decision.
Lord, that is the reason, my lord, let them under protest, my lord, they will.
My lord, may I make this suggestion, my lord? If my learned friend says he has no, I will make a deposit with that without prejudice to my current writ petition, my lord. If that can be, and if they can issue the
time frame. Time frame early. And ಮತ್ತೆ election ಅಂತ ಹೇಳ್ಬಿಟ್ಟು June ಅಂತ ಹೇಳ್ಬೋದು.
Lord, have it on my lord Monday, my lord.
My lord, I have.
How long will you take? These are regular things to be done.
3 weeks, my lord.
3 weeks.
My lord, one more submission, my lord. They should not insist on some interest now payable, my lord, because this was challenged by me. That will be another issue, my lord.
Subject to other all conditions, my lord, they will comply. Subject to all other conditions, which is my lord, held in the.
Whatever conditions are there. Yogesh Nagler and cast for respondent number 3 and 4. Submit that a bank guarantee would not be acceptable. Faced with the above situation, and counsel for the petitioner submit that you would deposit the amounts demanded by respondent number 3 and 4 without prejudice to the rights of the petitioner and subject to the outcome of the above petition. If the application for release of sites made by the petitioner were to be considered by respondent number 3 and 4 in a time-bound manner. In view of the said submission, the submission of the counsel for the petitioner is accepted. The petitioner is permitted to deposit the amount demanded, bracket without interest or penalty, bracket close, within a period of?
My lord, within a period of 10 days.
10 days from today. The respondent number 3 and 4 are directed to consider the said, consider the application of the petitioner for release of the sites in accordance with law within a period of 3 weeks thereafter. Released on 6th June.
Okay.
31. Yes, right.
Return, my lord, was filed by me. Permission to give evidence with regard to the bank statement. That petition was allowed. But my lord, the condition number 4, my lord, unfortunately, I violated. The worships earlier on. What happened, my lord? On 30th, for the first time, case was listed, my lord, for production of court judgment. My learner, since I was not keeping well, madam, my learner, okay, filed a memo along with the your lordship's court order. After going through the court, that was accepted. But then, my lord, the case was to be proceeded further by leading evidence, by filing an affidavit for the limited purpose of explaining the bank statement. Unfortunately, it was not filed, therefore.
Your affidavit ready there?
Even today, my lord, is ready, and I'll file it in the court today itself in the afternoon. I'm ready, it is ready. Everything is ready. But only thing, my lord, problem is.
Homeshaker.
ಇದಾರೆ ಇವರು ಇರ್ಬೇಕು ಉದ್ಯೋಗ ಗೊತ್ತಿ ಹೇಳಿದ್ದೆ ನಾನು ಬೆಳಿಗ್ಗೆ ಅವ್ರಿಗೆ ಕಾಪಿ ಆಫ್ ದಿ ಆರ್ಡರ್ ಬೇಕಾಗಿತ್ತು ಅದನ್ನು ಕಳಿಸ್ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು ಇರ್ಬೇಕು ಅವ್ರು ಈ ನೋಟ್ಸ್ ಅಬೌಟ್ ಕೇಸ್ ಇಸ್ ಲಿಸ್ಟೆಡ್ ಬಿಫೋರ್ ದಿ ಲೇಬರ್ ಕೋರ್ಟ್ ಮೈ ಪ್ರಾಬ್ಲಮ್ ಈಸ್ ಮೆಲಾಡ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ನನ್ನ ಮೆಮೋ ಇದು ಅಫ್ಲೋಟ್ ತಪ್ಪು ಮಾಡ್ತಾರ ಇಲ್ವಾ
ಅದಕ್ಕೆ
ಅವ್ರ ಕನ್ಸೆಂಟ್ ಇದ್ರೆ ಆಗೋದು
I have one by way of order dated 12 June 2023, this court had permitted the petitioner to lead its evidence on the next date on which the matter was listed before the Labour Court. B.S. Naik, the counsel for the petitioner, submitted that the matter was listed on 30th March 2023, but however, due to certain personal inconvenience of the counsel, the affidavit could not be filed on that day, but the affidavit is ready and the matter is listed before the Labour Court today. He submits that if permitted by this court, he would file the affidavit in lieu of evidence before the Labour Court today. The said submission being fair and taking into consideration that there was an inconvenience on part of the counsel, IA 1 of 2023 is allowed. The petitioner is permitted to file the affidavit in lieu of evidence relating to the bank statement before the Labour Court today. The time granted under condition number 4 of the order dated 12 January 2023 is extended till today. IA 1 and IA 2 stand disposed.
This petition was filed not seeking action against the illegal construction in violation of sanction plan by the respondent number 4. And this honorable court also directed the state government to undertake an inspection of the property and file a report before this honorable court. The report is also produced before the Lordship, my lord. Report dated 30/11/2022, wherein it clearly says, my lord, in each and every floor, it was a residential license and he has constructed a lodge. And as far as third floor is concerned, no license is also obtained. I take my lordship to the report, my lord.
So it's a stilt and 2 floors.
Please, my lord, stilt and 2.
Now in stilt also there's a construction.
Please, my lord.
You are the respondent number 4.
I represent for the respondent. Lord, the report has been submitted. I have been interested recently, my lord. We will file our reply one submission. And if there is violation, my lord, we will satisfy your lordship, my lord, with regard to the contentions taken by us. Now, there is the respondent number 4, my lord, no, sorry, petitioner also, my lord, constructed the building, my lord, without obtaining license for demolition as well as for construction. We have also filed, my lord, one writ petition. Or that may be posted along with that, my lord. WP FR
mandamus done. Adu mandamus done.
After we filed,
we will give mandamus here. In that matter, we'll list it on Monday. We'll give mandamus there.
Both may be taken up.
Both. The The counsel for respondent number 4 submit that the above matter is connected to WP number.
ಫಾರ್ ನಂಬರ್ದಲ್ಲಿ ಇದೆ 8032 of 2000
Par 8032 of
2023.
registry that connect the said matters and relist on 17th April that 17th April. So ನಿಮ್ ಬಾಳ demolition ಮಾಡ್ಬೇಕು.
ಅಲ್ಲ ಅವರಿಗೂ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಲೈಸೆನ್ಸ್
ಎರಡು demolition.
In my objections, my lord, I demonstrate license ಇದೆ, renewal ಗೂ ಕೊಟ್ಟಿದೆ, ಎಲ್ಲ ಇದೆ. It will be a counter effect that they are doing it.
Anyway, it's a mandamus.
Please.
You know what will happen.
Please.
Both of you know.
Please. And as far as the new petition is concerned, may I request a copy?
I will, madam, if learned friend, my lord, takes notice.
Only beneficiary is Mr. Nagaraja first times.
But if that matter may come, Adisa notice model.
Yes.
Advance copy of serve model.
Please.
Ibargu ಕೊಟ್ಟು.
Please. Grateful.
Serial number 33.
One week time, sir. 40 seconds. One week, my colleague mother is dead. So ಹಾಗಾಗಿ ಅವ್ರು ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ ಸರ್.
Sorry.
ನಮ್ಮ colleague was mother was died. ಅವ್ರದ್ದು ಕೇಸ್ ಇದು ಅವ್ರು ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ. 1 week time ಕೊಟ್ಟರು.
Colleague ಅವ್ರ ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ. Pending consideration of IA 1 of 23, counsel for the petitioner is permitted to comply with the office objection. Relist on 30th May. I started to comply ಮಾಡಿ.
34.
Petition. As challenging the connection A, my lord. Page number 16, my lord. The access note, my lord, the petitioner has purchased the scheduled site number 3, measuring east to west 35 feet and north to 34 feet, my lord. Under the registered sale deed dated 28/10/2020 as per Annexure C, my lord. The fourth respondent is the none other is not concerned to the said property, my lord. On the alleged correction deed, my lord, executed after the execution of sale agreement in favor of the petitioner, my lord. Now she is trying to disperse the petitioner on the basis of alleged kata entered in favor of the fourth respondent by the third respondent, my lord. Without any boundary, my lord. There are different boundary, my lord.
Where is the sale deed in favor of respondent number?
Sale deed is Annexure B, my lord.
Annexure?
B, my lord.
B.
Hello, sorry.
C.
C, my lord. C.
ಯಾರ ಫೇವರ್ ಅಲ್ಲಿ ಇರೋದು?
Schedule, my lordship, kindly see number 24, my lord. Without verification of documents, my lord, BBMP.
This is in whose favor? Is this said?
The petitioner favor, my lord. She has purchased it under registered sale. East by Madeva property, west by Lokesh property, and north Lakshmana avara sottu, Dakshinaki raste. And my lord, correction deed, my lord, at page number.
Where is your name, madam?
Lakshmi,
Elli.
petitioner. Annexure C, Annexure C, starting page 18. Page number 18, my lord.
ಏನು ವೆಂಕಟಚಲಯ್ಯ? ವೆಂಕಟಾಚಲಯ್ಯ.
Venkatachala is our wife, husband, my lord. Lakshmi is the.
ಬಹಳ ಹೆಸರುಗಳಿದಾವೆ.
Lakshmi is
ಶ್ರೀ ಪೂರ್ವಕ್ಕೆ.
ಪೂರ್ವಕ್ಕೆ ಮಾದೇವಪ್ಪನವರ ಸ್ವತ್ತು, ಪಶ್ಚಿಮಕ್ಕೆ ಲೋಕೇಶ್ವರವರ ಸ್ವತ್ತು, ಉತ್ತರಕ್ಕೆ ಲಕ್ಷ್ಮಮ್ಮರವರ ಸ್ವತ್ತು, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ. Lordship, in their contention, respondent number 4 contention, my lord, earlier our father has executed a gift deed in favor of the respondent number 4, my lord. That is page number, my lord.
Yes, Ramanna is here. Vendor here.
My lordship schedule at page number 39, my lordship, kindly see.
Page number 39 of the
Yes.
ಪೂರ್ವಕ್ಕೆ ಬೇರೆಯವರ ಸೊತ್ತು. ರಾಶಿಕ. ಪಶ್ಚಿಮಕ್ಕೆ ಬೇರೆಯವರ ಸೊತ್ತು, ಉತ್ತರಕ್ಕೆ ಬೇರೆಯವರ ಸೊತ್ತು, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ.
But 133/1.
Sir, assessment number is same, my lord. Then the site number is not mentioned here.
ಇದೆ ಅಲ್ಲ 133/1 ಅಂತಿದೆ.
Assessment number is the site number. My site number is 3, my lord. My site number.
Assessment number will be the same thing for everything.
Same, my lord. My lordship, kindly see the boundary, my lord. Boundaries are different, my lord. Totally different.
How can we even, this registration without a number itself should not be allowed.
Oh, please, my lord. There.
We can't grant you this interim prayers.
My property is site number 3. In their gift deed and the will, my lord, there is no site number mentioned.
2021 order in 2023. So let us issue notice. And AG accept notice.
No, they are interfering with my portion, my lord. When I started to put up the construction.
Accepts notice for respond number 2 and 3. Issue notice for respond number 4. Returnable by 22/5.
Now they are interfering with my position.
Order of 2021, after 2 years you are coming.
Knowledge ಗೊತ್ತಾಗಿದ್ದು ಅವರು representation ಖಾತಾ ಬಿ ಖಾತಾ ಆಗ್ತಿದೆ. ಬಿ ಖಾತಾ ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ. And that basis they are trying to eliminate also, my lord. That's why
that gets set aside.
Not to interfere ante.
We can't grant that order without knowing who. Not like that. So next.
Court respondent is not having any right, my lord.
Right.
Petitioner, please. I have filed this writ of certiorari.
My lordship, I'm appealing for Mysore City Corporation. We have not received the copy. Our name is shown in the cause list. We have to file the.
You not received the copy.
And in the.
Yes.
So, what's the name?
In the connected matter, you appear for one.
So however, this is regarding the license matter. To license 31st expire.
In the connected matter, if Pallava R is appearing for Mysore City Corporation, kindly delete the name of Geeta Devi MP.
Direct them to take notice. Pallava R has entered appearance for respond number 1 and 2 in WP 24366 of 2022. Is directed to accept notice for respond number 1 and 2 in WP number 2152 of 2023. Registry is directed to print his name as such and delete the name of Ms. MP Geeta Devi as that appearing for respond number 1 and 2.
Lordship, and for the petitioner.
In which matter?
In the 2152 of 2023.
Yes.
Lordship, I have filed this writ of certiorari where I am challenging the trade license issued in favor of the
Sumant Bharadwaj.
Lordship.
Where is Mr. Sumant Bharadwaj?
I am appearing for petitioner.
You are appearing. Yes. Ready?
Only adjournment may be given.
Okay.
Counsel having some health issues.
At the request of Sumant L. Bharadwaj, released on 18th April.
Lordship, only after 22nd or 23rd.
Then it is vacation matter. Then it will go to May. It will go to May?
No.
Serial number 30. Raghunath CM.
And AGA accepts notice for respond number 1. Bangalore Urban Zilla Panchayat. Devraj accepts notice for respond number 2. Sulikere Gram Panchayat.
Gram Panchayat na tagotana. But CEO ge Mahesh Uppina.
Sulikere Gram Panchayat gyaro.
Nan tagot.
Nive na?
Mahesh Uppina.
CEO gu nive.
CEO Mahesh Uppina. CEO
Mahesh Uppina. Mahesh Uppina for respond number 2. Ashwi Devraj for respond number 3. Counsel for the petitioner serve a copy of the petition on the connection released on 30th May.
37.
None opposed.
Must be a representation and sanction.
Representation.
Initial A page. Only problem, your lordship may kindly,
Here for these matters.
your lordship may kindly, the only problem is 2021 application was given in 2023 month.
Exit notice for respond number 1. Baldare Gram Panchayat. Accept. The AG accept notice for respond number 1 and 3. Shri H. V. Devaraj accept notice for respond number 2. Counsel for the petition furnished copies. Relist on 20th April.
No, I am not taking any interim order.
Written give instruction.
38. K.V. Narasimhan.
Question, my lord, the notice, my lord, that has been issued at Annexure G, page number 56, my lord.
Page number?
56. By which, my lord, is stated by the Panchayat that there lies a road in the property which belongs to the petitioner. And on that premise, my lord, they call me an encroacher and has directed, my lord, to the stoppage of the work.
What is the inner road, outer road?
My lord, that's a road, my lord, that we have left for ourselves, well within our property, my lord, for our movement. We have left a road within our own property. My lord, what has happened in this matter, my lord, is the property, my lord, in survey number 130, survey number 278, measuring 1 acre 34 guntas, my lord, belongs to the petitioner. My lord, he has got it converted, my lord, for the non-residential purpose. My lord, Vide order at Annexure C, my lord, page number 24. The schedule may kindly be seen, my lord, at page number 26.
Very Dakshinak Raste.
Dakshinak Matra Raste. My lord, even a sketch, my lord, have been annexed to the said conversion order, which, my lord, depicts the topography of my property. Even there, my lord, to the south, my lord, the road is situated. My lord, it comes within the jurisdiction of the Panchayat. They issue me the license, and also, my lord, the sanction plan has been issued by the Panchayat. My lord, that I have produced, my lord, the license is at page number 30, Annexure D.
E. Begur Yaro. Accepts notice for Secretary and PDO Iburgu Tontira. Notice for respond number 1 and 2. Counsel for the petition furnish copies of the petition along with annexures on the said counsel. The operation and execution of the communication at Annexure G dated 27/3/2023, bearing number so and so is date till date of hearing, released on 5th June.
39. Rajat Khetri.
Mandate issues. Ground rate. Annexure C, my lord.
Annexure C. This is ground rent.
Ground rent.
Only ground rent. Huh?
Ground rent. All the labors. Ella check matter. Entire demand notice.
And AG accepts notice for respond number 1 and 2. Shri Pawan Kumar accepts notice for respond number 3, 4, and 5. Table order. Relist on
After list 2. This number.
Connect with WP 4561 of 2023 and relist on 5th June. I don't think we'll be able to take up that.
Interim order.
Accepting the reasons stated in support of IA 1 of 23, production of original certified copy of C, D, E, F, and G is dispensed.
Final hearing, serial number 40.
My lord, I pray for a week's time, my lord.
Why, Mr. Osman, 2013 matter?
Some inconvenience has put on I may not say that, but next week I will do it.
At the request of counsel, released on 30th May, it is made clear that no further adjournment would be granted if argument is not advanced on that date. The petition will be liable to be dismissed for non-substitution.
Please,
The old matter, please address the argument.
please, madam, I will do it on that day.
41. Jeta Nayak.
I appear for the petitioner, your lord.
My lord, R1, my lord.
My lord, I appear for respondent number 4 in this case, my lord.
Petitioner herein has brought.
My lord. My lord, a week's time may be granted, my lord, please, my lord. Yesterday, last week only served the copy of the additional document. I need to take instruction from the parties, my lord. Kindly have it next week, my lord.
What is the additional document?
Additional document, they have filed it, served it to me, my lord. I need to go through it, my lord. I take instruction from the parties on the document produced by them. So, it is technical problem me to submit, my lord, my arguments. Kindly have it next week, my lord.
We are not even present on last 2 dates.
Sorry, my lord, that day could not able to appear before, not intentionally, my lord.
It is not a technical problem. We are not present.
My lord, not
you would have received it earlier.
My lord, copy I received, my lord, last week. It's last week only, my lord. So that I need to take information, instruction from on the document produced by them.
What prevented you from taking instruction in last 1 week?
My lord, because of this holidays, we are not in station, my lord. Please.
Mr. Murthy, you are not appearing in the matter. You don't take instructions.
Sorry, my lord. Next week I don't.
2013 matter.
Nah. My lord, I agree, my lord. But next week I don't take seek any adjournment, my lord. I'll make submissions, my lord. Please, my lord.
In that case, a date may be fixed.
It will be fixed, but it cannot be fixed next week. That's the problem. Counsel for respondent number 1 seeks for and is granted a short accommodation to obtain instructions.
Please, my lord.
The perusal of the order sheet leads to a sorry state of affairs where respondent number 1 has not been appearing.
My lord, not intentionally, my lord. Please, my lord.
We observed that 5 times here, Mr. Murthy. The order sheet has been clear on that.
Let I agree.
Time again.
My lord, respondent commissioner is not has been changed. New commissioner has to be assumed to charge, my lord. Because of that reason, could not able to contact them.
That is not a thing for last 5 times that you did not appear.
Sorry, my lord. Please.
The 2013 matter. Later matter we would not have observed. 2013 matter, sorry, we can't.
Next time, my lord, without any default, will assist this court to dispose the matter, my lord. Please, my lord.
No such accommodation is granted in the interest of justice. One last opportunity is granted.
Please, my lord.
If irrespective of whether respondent number 1 obtains instructions or not, you will be required to address arguments on the next day.
Yes, much.
If are not advanced by respondent number 1, the matter would be taken up for consideration on the basis of the submissions made by the other counsels.
Please, my, please, my, definitely, please.
Second,
42 Arjun, 43. Parvati R. Nayak.
what returned with office objection? Something returned with office objection.
Signature of petition number. Not forthcoming in water.
First time. Well, here the second respondent auction sites in 1985. Now the deputy commissioner says you're not
You can appear only for petition number 1.
petition number 1.
2 AN matter.
Find out from the instructing Parvati is in the other court. I'll get it from her. See what has to be done. She may have it on
Raised
Monday.
objection as regards
It was
respondent.
not there last time.
Petition number 2. This is raised on 16/11/2016.
Nothing came in the order sheet. Last time I came before your lordship. Lordship, I have it on Monday, my lord. I'll have this out.
At least it's come now so that it.
I'll get it done.
Then Monday, we go after vacation.
Lord, 85 sites were auctioned. Now the deputy commissioner says you have not taken prior permission from the government under 72, so I can't give any order in your favor. One of
You will have to file wakalat. Raise the objection as regards petition number 2. not having signed the no objection wakalat form. Counsel for petition seeks for and is granted 2 weeks time to do the needful. You objections hakidira?
No objection.
Nothing is filed.
No objection. No objection to the petition. No?
Not filed objections, but prima facie, the petition itself would show that, would contain all our objections.
Counsel for respondent number 2 submits that he does not intend to file any written objection.
Not filed.
Ingo one ಹೇಳಿ, take a stand. What does it matter?
Say, I want time to file objections, other you want to have.
Very well.
What do you want to do?
We'll file.
Counsel for respondent number 2 seeks for and is granted 2 weeks time to file a statement of objection. Considering that the matter is of the year 2015, if objections are not filed by 22nd May, it will be taken as not filed. We list on 26th May. Then you actually learn and close it. You actually learn and close my. What Shetty?
Lords, may I please item 44, my lord? I'm sorry, my lord. I'm R. Shankarnarayan, ASDA South here, my lord.
Yes, Mr.
I'm sorry, my lord. I took a little time for me to connect.
Yes.
My lord, the matter is, I'm on a very, very narrow campus, my lord. I have finished several rounds. The matter relates to a land acquired for the purpose of DRDO, my lord. The acquisition was challenged by the landowners, went up to the Supreme Court. The acquisition was upheld. My lord, after the acquisition being upheld, the land acquisition officer gave up some land, and ultimately the fact remains, my lord, a settlement was arrived at in the Supreme Court, where Union of India relinquished its interest in respect of 50% of the land. It went back to the landowners. At that time, my lord, the idea was that the landowners would put up their small, their entire plea was, we are all small people. So if you give the land to us, we will have our own dwelling unit or our own place. And therefore, we entered into, and the Union of India said, please take you. We agree for a compromise. A joint memo of compromise was filed. At that time, my lord, an apprehension was raised by these landowners, saying that ultimately, no, you agree. Tomorrow, you should not rely on the Work on Defense Act 1903, where the DRDO is entitled to place restriction on the use and enjoyment of the land. Supreme Court said, my lord, that you should not invoke that provision. We also agree. Though we opposed it, ultimately the Supreme Court made an observation. You should not at a later date rely on Section 3 of the Works on Defense Act 1903. Lord, that became the final one. We filed a review and that was dismissed.
Mr. Shankaran, just a moment. You're saying something. What did you notice, Mr.?
I was about to, but
Not after arguments have started.
I told my learned friend also. Now I already told him also.
When last 2 times the matter had come up and the matter was adjourned, you should have brought it to our notice.
Sorry, my lord.
What happened? I'm sorry, my lord.
No, nothing to do with you, Mr. Shankaran.
No, I was just about to, I told him also.
Just now he
It was adjourned for the ASG's presence and the ASG has appeared. Now we have to do.
Sorry, my lord.
Post before a bench of which SGRJ is not a fact. We are disabled for this matter, Mr. Shankaran.
The
other side should have brought it to our notice.
Sorry, my lord.
I'm sorry. I'm sorry. Obligation.
I informed the other side also, my lord. In morning also I called him and then
you tell us.
Sorry.
I was not knowing. In fact,
why did it come up earlier?
It's my mistake, not sorry, my lord.
Sorry, madam.
Nothing to do with you. Only for Mr. Marthi.
Obliged, my lords. Privilege appearing before the lordship.
45 are open.
This cancellation of single site layout granted in the first petition without considering the objections. Lord, kindly see me, Lord, Annexure A, the 2 acres, 18.
Gopal, petition number 2, you have not brought.
Yes, Lord, petitioner number 2, Lord, he has purchased, Lord, the property, but petitioner number 1, notice was addressed and cancellation, the layout was granted in favor of petitioner number 1. Lord, I submitted on the last occasion before the other court that petition surveyed because what is done is, my lord, cancellation of layout granted in favor of the petitioner number 1. That is under challenge. Other things are consequential, my lord.
If you are not even the owner now, nothing.
No, my lord.
What is
Earlier, my
the
lord,
law?
I was granted. I have to make good the title in favor of second petitioner, my lord.
What is your locus today, Mr. Gopal?
That's, my lord, first petitioner is the owner of the property. He has formed layout. And layout granted in his favor, my lord, has been cancelled. My lord, he filed objection. Without considering, my lord, the objection, Annexure O, my lord, kindly see, my lord, layout has been cancelled, which is challenging, my lord, it is Annexure O, my lord, page 71. My lord, show cause notice was issued as per Annexure H. 2013, my lord, a single site, my lord, was permitted to be formed in a layout already sanctioned, my lord, in
Who appears for the respondent?
two.
Manjunath was here.
Manjunath is appearing for municipality, my lord. First respondent is the contesting respondent.
Nalini Venkatesh. No counsel for petitioner is present to address argument. None appears for the respondents. Relist on 30th May.
First week of May, June, my lord.
First week of June. 6th June. Ready? Ready? Michael ಮಾತಾಡಿ ಇಲ್ಲ ಜೋರಾಗಿ ಮಾತಾಡಿ ಏನ್ ಮಾಡ್ಬೇಕು ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ಬೇಕಾ ಪಾಸ್ವರ್ಡ್ ರೆಡಿನಾ
47.
Active for this. Taking 1 week time. 1 week, Monday.
Last time also you took time.
Regarding that example, we have to verify records from the 95 months. I have collected some documents in persons to the.
You will get it in 1 week or? What is the?
Radio is also present before the court. He is present.
M. Pradeep seeks for and is granted a week's time to obtain instruction and make a submission. Relist on 18. Afterwards. Seeks for and is granted 2 weeks time to verify requisite. It's on 5th June.
I'll be out of station.
Right.
Much obliged.
48 adjourned, 49. Which have been presented.
Matter was. We have produced, relied upon a judgment of this coordinate bench of this honorable court. And it was not, but it was told that there was an writ appeal pending and there's an interim order.
There's no interim order.
There's no interim. The reason it was came to Milot adjourned by 3 months, and after verification, there's no interim order.
Password. Yes. He believes the submission is made.
The group matters, serial number 50, adjourned 51. DJ Satisha.
Here is appearing through VC. Here is appearing through VC.
Who is appearing, madam? Who is your senior?
Satish. DJ Satish.
There is no Satish here. Nobody is here. Anyone Satish?
He's actually not keeping well, but somehow he's managed to appear through VC. Kindly urgent the matter, Your Lordship.
51, it is submitted that the arguing counsel is unwell. Relist on 5th June.
Much obliged.
52 adjourned, 53.
Lords, 52 is adjourned, my lords.
How's the madam?
52.
52 is adjourned, but you are not informed?
It's okay.
You were told you were informed.
No problem. I think that mistake. No.
satisfying 52. When the matter was not called out, Ms. Sanchana MR submits that she was not informed about the adjournment.
Yes.
53.
That Sumana Garching, but name may be deleted, my lord secretary.
That was deleted in the morning, madam.
My lord, in 353, my lord, second respondent counsel, MB Prabhakar, some inconveniences, taking 1 week's time, my lord.
On behalf of
MB
for
Prabhakar.
respond number 2, an adjournment is sought for released on 6 June.
54 adjourned, 55.
In this case, my lord, there was a talk between the petitioner and respondent for the settlement. In fact, the last occasion, the respondent himself submitted there is a settlement and all. He shared the terms of settlement. Unfortunately, it was not acceptable to my client. And therefore, I have filed a memo seeking direction for the enforcement of settlement. But I'm withdrawing that memo and then ultimately you will ask me to kindly fix the date for hearing, my lord.
For a moment, my lord, kindly see the draft.
Sri Hari Krishna as well as entered appearance for the petitioner. Delete Prakash M. Patil as that appearing for the petitioner. 55.1 only. The NR Jagdishwara has entered up R1 and R2. Delete M.A. Subramanian as that appearing for R1 and R2. Yes.
My respectful submission is this, my lord. They have sought direction to farm a road and
your property.
In my property. And my lord, ultimately a negotiation took place. And I have sent a draft. And my lord, the demarcation of my lord road survey has to be conducted. In the meanwhile, they have started sending notice to my client and me also. And draft, kindly see the draft. And ultimately, for a moment, now they immediately they have filed an application before this honorable court seeking direction.
I am withdrawing that application, my lord.
One second.
My learned friend need not argue that application.
No.
And let it be posted.
For a moment, my lord, kindly see our efforts. Since, my lord, there is no road, they have sought direction, which, my lord, this honorable court already observed that they have to approach civil court in case they have right. But ultimately, we have made a submission that they have elderly persons have sit together and in my office we have negotiated. We have agreed to relinquish. In the meanwhile, after sending the draft, instead of approving the draft, they have started sending notice. Then that application may be withdrawn. This also may be placed on record since, my lord, there should not be a blame on the respondent number 7 saying that, my lord, that we have not made efforts.
What do you want is a mandamus directing the respondent develop connect a road.
Yes.
In their property.
No. You will ask me kindly see. It actually have become a landlocked property. My property is adjacent to his property, and therefore he has formed till his property. So subsequently, the BBMP has undertaken that they will form a road. Only the Kacha road has been formed, and he has to complete the road. So therefore, you will ask me kindly fix a date for hearing, and I will argue the matter on merit.
16/1/2017 order is clear, my lord. Kindly see for a moment.
No, in fact, in the
there is a clear direction to the.
How can we give the issue this mandamuses, Mr. Rollo? These are mandamuses. You don't have a right for this. We can't determine your rights here.
BBMP has accepted, my lord. There is a lot of, in fact, there is a lot of records have to be gone into, and ultimately, you will ask to hear the matter, my lord.
And now that issue mandamuses for this.
Settlement is.
You can direct them to go into somebody else's.
No, that is I am. They themselves are relinquished. They formed a layout and they themselves are relinquished the land. So in that land, they are not formed the road.
You are yourself asking for issue a mandamus directing BBMP to obtain a relinquishment deed from them. How can we give this relief?
It's only particular road, not CH-18 and roads are such. It's a particular extension of land.
Call it next week, my lord. I will definitely argue the matter.
Argue the matter, but these kind of mandamuses cannot be issued.
No, I will definitely. I will go by the affidavit of the this thing BBMP, my lord, on the latest occasion they filed. You will ask in light of that affidavit. You will ask.
What is the memo that you are filing?
Kindly.
No, I have filed an application for seeking a direction to for this thing, and
1 or 23.
I am withdrawing that.
1 or 23, you are not going to press now.
Yes.
Counsel for the
that IA itself shows that there is no any relinquishment. Therefore, my lord, I am making that draft.
Yeah, just a minute.
Please,
Counsel for the petitioner submit that is filed IA-1 of 2023 by direction to respond number 7. Counsel for the petitioner submit that he does not press IA-1 of 2023 which had been filed, taking by direction to respond number 7 to take expeditious and appropriate action in pursuit of the joint compromise memo. Since the joint compromise has not been entered into.
Yes. Not been signed.
Submission is accepted. IA-1 of 2023 is dismissed as not pressed.
Much.
What are you?
Draft which we have finalized, both parties. They have said, my lord, we have to relinquish. Instead of that relinquishment is 7,000 square feet that they have agreed to give in their land. Ultimately, my lord, sketch has to be prepared. But sketch, since, my lord, we have to conduct survey sketch, they have started issuing notice to my party and me also. That draft has not been, my lord, finalized by them.
That is what he is saying, that
Yes,
there is no.
I have no issue, but since, my lord, there is a earlier, this honorable court recorded, that effort has to be made for settlement. Therefore, my lord, we have made all efforts and we have sent a draft also. That's what I have produced. Sorry.
Counsel for respondent number 7 has filed a memo enclosing a draft of the compromise petition, but submit that the compromise has not been agreed upon.
By the.
And the said memo is only filed to establish
that we have made efforts,
the
direction issue.
The efforts made.
Yes.
To try and resolve the matter. The said memo is taken on record. Relist on 17th.
Much.
Serial number 56. Here, Bharat sir.
Great license. There are great license.
Okay, Ramesh. Mr. A. Jagannath. Ashwin Aladi, who is appearing 56.2 now?
I am appealing.
You are appearing.
Petitioner.
56.2 only. Ms. Sarita Kulkarni has entered appearance for R1 and R2. Delete Ashwin Aladi as that appearing for R1 and R2. Where is Mr. N.K. Ramesh? Mr. Jagannath, you are not appearing, you are not showing your wakalat. You will appear. Wakalat has not been filed. Oh, NOC wakalat filed.
No, NOC wakalat has been filed.
Where is Mr. Ramesh? Both of you are there.
Yes.
To represent the corporation. What is this, Mr. Vijay?
Yeah, my lord, question of whether a clinic, my lord, that is being run in the portion of a residential premises requires a trade license under section 353 of the Municipal Corporation.
Ready? Jagannath, ready? Ready?
Please, my lord.
Lord, there's just one submission. After coming into the.
After all submissions, if all of you are ready. We don't want adjournment after argument starts.
The only submission is that after coming into effect, the new BBMP Act, certain categories have been tried to be included in the Act. Out of which one is medical, wherein even private clinics need to obtain trade license. Now that is the basis on which the writ petition has been filed. Now the rules and bylaws are being framed as to what all categories fall within the.
This is a petition of the year 2015. And you are saying still the rules are being framed?
No, this act has come into effect after the outfall of COVID. There are certain categories.
Interim orders are there in your.
Here in my case, the respondent is running a skincare clinic. And there are about 13 categories in which treatments are given, including surgeries. In this aspect of the matter, certain they have been framing the bylaws and rules as to what all falls within the obtaining license.
What will be exempted and what would require license? Both you are coming up. When will
The
it
rules
be?
are still being framed.
When will it be ready?
Hopefully, it will be done soon, my lord. There's a panel already which has been formed.
When will it be done?
It is not at least a year because the new government has to, rules have to be framed.
Let us put Mr. Jagannath.
Committee has been formed with the approval of the government.
When was it formed?
My lord, in view of the elections now,
When was it formed?
sometime after elections, my lord.
Inna madilla, form agilla.
It is being framed. It is being framed with the approval of.
When was the committee formed? Committee once formed, the elections will not come in the day of the committee. That won't come in the day.
Lord, I need to get certain details from the concerned NOH.
Limitation. Prasad Chandra is getting the committee.
Yes.
And 30th June is the time for running the rules.
Submission of the rules.
If the rules are not approved by the state government in 3 months, it will deem to be subsumed into the act.
CH Jagannath, there is counsel for the court. New Idira committee. Submit that committee has been formed subsequent to the BBMP Act coming into force to ascertain to formulate rules in respect of medical facilities which would require a trade license and which are exempt. And that the committee is likely to submit. Committee is required to submit its report by 30th. Relist on 30th April. Relist on 30th June. 30th June.
30th June.
30th June. Relist on 10th July. To enable the said council to place on record the rules formulated. Interim order earlier granted is extensive.
May please your lordships. My colleague is there, Milord. She will hand over a brief synopsis I had prepared in this matter.
Mr. Chandrasekhar. You, Chandrasekhar.
His role is minor, Milord. It's only BBMP and me, Milord. But Mr. Puttagoda is there, Milord, and
no role, minor role.
Minor role, virtually no role, Milord. Virtually no role, Milord. Your lordship, take it that also means. What has happened in this, Milord? Way back in 97, Milord, a public interest litigation had been filed before this honorable court, Milord, protesting for the establishment of this slaughterhouses in the city of Bangalore, Milord, saying that it's emitting a lot of foul smell, Milord. Then that was disposed of on 13/8/2002. The operative portion of the order is at page 8 of the writ petition, Milord.
Page number?
Page number 8, Milord.
8 of the petition.
Yes, of the writ petition. Last, Milord, I extracted in the last bottom of page 8, Milord. Slaughterhouses and abattoirs which are being run in the territorial limits of Bangalore City Corporation should be shifted to the outskirts of the city limits. After 6 months from today, no slaughterhouses, abattoirs should be maintained or run within the local limits of the Bangalore City Corporation. That was the order passed, Milord. Then, Milord, a government order was issued on 21/8/2007 as at Annexure A, Milord. Contract was given to the petitioner for setting up of an abattoir, Milord, at Igalur, Milord. The place is Igalur, please note, Milord. Then, Milord, on 2/11/2010, Annexure F was given, shifting from Igalur to Harohalli, the present place. That's at page 28, Millard.
Yes.
Then agreement was entered into on 15/2/2012. Page 10, Millard, is some of the relevant clause minutes. May I take your lordship to that minutes, bottom of page 10 minutes. Peaceful possession. BBMP hereby warrants that the site together with necessary right of way leaves has been acquired through the due process of law, belongs to or has been leased to BBMP and is vested in BBMP, and that BBMP has full powers to hold, dispose of and deal with same consistent inter alia with the provisions of this agreement, and that the concessionary shall, in respect of the site, have no liability regarding any compensation payment on account of land acquisition or rehabilitation, resettlement of any persons affected thereby. Then, in addition to and not in derogation or substitution of any of its other obligations under this agreement, BBMP shall have the following obligations. Within a period of 90 days from the appointed dates, at its cost, construct a compound wall around the periphery of the site. BBMP shall make necessary security arrangements outside the project site in consultation with the concessionary and shall review the adequacy of the same periodically. The security arrangements shall be provided during the period commencing from the appointed date till the first date. Then, Millard, there was no compliance with this order, Millard. Rest of the things I will not trouble your lordship at this. Then, Millard, I was forced to find that your lordship may kindly turn to next page of the brief synopsis, Millard.
You filed a writ petition for mandamus.
No, yes, Millard. 5416 of 2013 was filed, Millard. Page 37 may kindly be seen. Page 37, Millard.
Yes. You see, the operative portion is page 40.
Yes, minutes. No, 39 minutes. Page 39. The respondent number 6 is directed to put the respondent number 2 in physical possession of the plot number so and so, Haroldi second phase, by marking the boundaries within 10 days from the date on which a certified copy of this order is furnished to the respondent number 6. If there is any law and order problem with regard to handing over possession, the respondent number 2 as well as the respondent number 6 shall make a request to the respondent number 4 to provide protection in that regard. The respondent number 4 shall thereafter provide protection for the purpose of respondent number 2 taking possession of the respondent number 6, whereby respondent number 6 shall clearly mark the boundaries of the plots and put the respondent number 2 in possession of the property. The respondent number 2, on obtaining possession from the respondent number 6, shall hand over possession of the site to the petitioner within a week thereafter. Now, Millard, please turn to the final order at page 41.
Yes.
My lord will get the page 43 may kindly be seen. About 10 lines, 7 lines from the bottom. Out of 40 acres, my lord could get it, Millard, in page 43.
Yes.
Out of 40 acres, the available land is only to the extent of 36.234 acres, of which in respect of 2 acres 5 guntas, compensation has to be settled and thereafter possession to be handed over to the corporation and in turn to the petitioner. The learned counsel for the corporation submits that whatever undisputed area is to be handed over to the petitioner and remaining area is as it is submitted by KDB, 4 weeks time may be granted for handing over possession. The learned counsel for the petitioner has no objection in handing over possession of undisputed area and granting 4 weeks time to KDB for the aforesaid purpose. The submission of the KDB that 2 acres 5 guntas of out of 36.23 would be handed over after setting the compensation to the agreed party, and that would be done if 4 weeks time is granted. The learned counsel for corporation also submits that amount paid in excess of 36.234 acres may be directed to be refunded to the corporation. Writ petition is disposed of 36.234 acres, excluding 2 acres 5 guntas to be handed over by the KADB and to the BBMP forthwith. The BBMP is directed to fence it and hand it over to the petitioner as expeditiously as possible. 4 weeks time is granted to the KADB to settle the compensation in respect of 2 acres 5 guntas and handed over possession thereof to the corporation and in turn corporation to hand over possession to the petitioner. This order is dated June 14. Just now I read, Millard, the agreement. Agreement agreement is dated. I'll just give the date, miss. So in the agreement, what they said is that is on 15/2/2012. We have the possession, we are the owners, everything they say that that I have extracted in page 10, Millard, but they didn't have anything when the matter came up before this honorable court also, Millard. So that is in page 2014. Then, Millard, they agreed to do certain things pursuant to the order of this honorable court. Again, they did not do. We had to approach this honorable court. Now, Millard, please see the orders of this honorable court.
You have with you 5 crore of rupees.
Please, Your Worship.
5 crores has been received by you.
Yes, Millard, that's there. Millard, no, Millard, what we had to do is they had to give us possession with security. That they have not done.
What have you done with 5 crores? When did you receive?
Millard, we had done some job, Millard. They themselves they admit that.
Do
Without
you return that 5 crores to them with 24% interest. Let it happen whenever it happens.
No, Millard, but we have invested there, Millard. We have done our job, Millard. They have admitted that fact, Millard.
What have you done?
Millard, they have given the photos, Millard.
Where are the photographs?
They themselves have produced.
Page number?
Millard, there's an affidavit at page 7, Millard.
Which
their affidavit? Their affidavit, Millard, filed on 16/2/23, Millard.
16/2/23. This is the compound wall that they have built.
No, a page annexure R8 onwards, Millard. We have made all the investment, Millard. And we are not backing out, Millard. It's, the only prayer is let them complete the compound wall, Millard, and we'll proceed with the rest of the things.
Yes, Mr. Puttagowda, what has happened to the compound wall?
Kindly say the while the
Millard, before my Alfred could start, Millard, can I just make one submission, Millard?
Only 1,500 meters which was pending.
Yeah.
If that is completed, then
may I submit, Millard, just one submission, Millard? Page 1 of the affidavit may kindly be seen, Millard.
Yes.
Page 1, Millard.
Yes, we are seeing that.
Yes, I submit had handed over so and so. Then I submit paragraph 5, Millard, that immediately after approval of the budget, tender will be called for and we will take steps to complete the work within 6 months with the help of KDB and jurisdictional police. So that means even the budget is not there, Millard. Let them undertake, Millard, before your lordship, Millard. Then they are going to do date-wise, Millard. So everything, Millard, now they say.
That is exactly what we are asking, Mr. Ramesh.
Yes, yes. I'm sorry, Millard.
Budget also approved. 6 months is the vision.
So we are in April. So by October ready agata?
Yes.
Till that time, why don't you do the
the moment we do something, Millard, that is taken away by the local people, Millard. That's the reason, Millard. We cannot protect that, Millard. Because they were, the local MLA himself was against it. They had protested and they are aware of all those things, Millard. And they had filed a civil suit, that was we got it dismissed. His Lordship Justice Nagaprasanna has noticed that aspect, Millard.
K.N. Puttagowda submits that the budget has been approved.
Yes.
Tender has been called.
Not
and that tender will be called as soon as the elections, election process is completed.
Yeah.
And thereafter, the remaining part of the compound wall, measuring 1,500 meters, would be constructed by end of October 2023. Hence, released on 6th November 2023.
And in the meantime, they must also think of extending the period, because 15 days period is there, 15 years period is there. we had to do our business during that 15 years. They had to think on that also. Your Lordship may observe that, Minister.
Needless to say that the period would have to be taken into consideration after the
Appointed date is 15 years. That has to be extended, Minister.
the contract would have to be taken into consideration after the compound wall.
One request, kindly direct the police and KDP to
Some date may be given, Minister.
The third respondent and the fourth respondent shall cooperate with the second respondent and its contractor in completing the construction work of the compound wall.
Some date can be given, Minister.
The period of the term of the contract would have to be taken into consideration
For extension.
On the basis of the date of handover of the property after completion of the
No, we have already and
completion of the construction. ಅದುವರೆಗೂ ಏನು ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ವಲ್ಲ.
only compound our.
ಬೇಗ ಮುಗಿಸ್ಕೊಡಿ Mr. Patel. ಅದುವರೆಗೂ they have not started their business. They are unable to start their business.
They have to complete the construction.
Yes.
Of the factory.
On the date on which the construction of the entire compound wall is completed. Released on 6th November.
Grateful. Sorry, Milord, I came on the VC, Milord.
No problem. Please come on VC. That is why the facility is there.
Yes, grateful.
ಅದಕ್ಕೆ ಸಾರಿ ಅನ್ನೋದೇ ಬೇಕಾಗಿಲ್ಲ VC ಬಂದವರು.
Not for a issue of khata in respect to the property, where I have a registered document. Annexure A, my lord, an endorsement is given. But it's not a speaking order and nothing is considered insofar as rejection of my khata. Four sentences are stated. Of course, there is a civil suit pending.
The ಆಯುಕ್ತರ ಆದೇಶ ದಿನಾಂಕ 2/1/2007 ಏನದು?
But they have filed their objections. They say that civil suit is pending.
There is a order of the commissioner dated 2/1/2007 also referred to.
There is no order. Secure the order.
That is what it says.
Yeah, really.
Bangalore Mahanagar Palike ಆಯುಕ್ತರ ದಿನಾಂಕ 2/1/2007.
ಹೌದು, ಅದು ಇಲ್ಲ, order ಇಲ್ಲ. If he has got the order, he can give it. Certain that.
2016 matters.
Repeatedly not.
In our objections, what we have stated is a declaration suit pending. From the vendors, they have purchased. They have declaration suit.
So what has happened?
They have filed a suit for declaration.
What has happened to the suit?
It's pending.
And one suit is filed by the petitioner against them for injunction. So there is a civil dispute. So that is why we have.
Transfer it.
I can hold the khata, at least pay taxes, paying taxes.
Then we will have to put everybody's name into that. Subject to the result of the suit.
That would be a difficulty, but suit is not getting disposed of.
Suit of the year?
1999.
19?
90.
Yes. 1999.
1999.
1999. Even that is long. 24 years.
Yes, getting immensely difficult, but I can't develop the property. Neither I can get a sanction plan.
Why is it pending for 24 years?
But I don't know, Bladu. I've been promptly making all my.
You ignore the 24 years in pending.
I know, Amel Bande recording. Struggling to get a disposal.
New Bande is to try.
Unbandu 3 years in.
So there is a larger. Until that disposal, we can't give this direction.
That will definitely cause some inconvenience.
We'll only direct
property
suit to
is
be.
lying with lot of difficulties.
We'll direct the suit to be disposed of by the earliest.
Yes.
So that at least that will benefit all of us.
Yes.
The petitioner is before this court seeking for the following reliefs. The contention of learned counsel for the petitioner is that the petitioner, being the owner of the kata, has not been made out in the name of the petitioner, resulting in the petitioner not being able to utilize the property more effectively. The Pawan Kumar learned counsel for the corporation submits that the suit in OS 3585 of 1999, wherein declaration of ownership has been sought for, and since there are disputes as regards the property in question, the corporation is unable to take any action.
Another OS case for injunction that is filed.
Apart from that, he submits that the petitioner has also filed a suit in OS number
5808 of 2000.
5808 of
2012.
2012 for injunction filed by the petitioner, which is also pending. They are pending in the same court?
Yes, madam. Court all 19 is there.
They are clubbed?
Yes, madam. They are clubbed together.
The Vishnu Kumar, learned counsel for the petitioner, submit that both the said suits are pending before the same court and both of them have been clubbed. It is rather shocking that a suit of the year 1999 is pending for the last 24 years without resolution. Hence, the contention of learned counsel for the corporation that due to the pendency of the above suit, no action could be taken for transfer of kata is proper and reasonable. However, taking into account the long pendency of the suits, the concerned court, court
number 19, citizen.
20th additional law, 18th additional law.
Make it available.
The so and so bracket CCH-19 is directed to dispose OS number 3585 of 1919 and OS 58 so and so of 2012 as expeditiously as possible, preferably within a period of 1 year from the date of
year to 3 months or 4 months.
in stage getting
Arguments go first.
Within a period of 6 months from the date of receipt of a copy of this order.
And give that additional.
Yes, please.
Number 60. Okay, Suraj.
I'm sorry. Second response. By the second response for yes, my lord. Page number 320. Commissioner is the owner of the land bearing survey.
Next year.
Yes, my lord. Page 32320.
323. What is the reason?
Saying that Isottu Khate Model Karnataka Sarkara Adhisoochನೆ ಸಂಖ್ಯೆ ಗ್ರಾಮ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ 14/6/2003 ಸುತ್ತಲೆಯ ಪ್ರಕಾರ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶದ ಪ್ರತಿ ಗ್ರಾಮ ಪಂಚಾಯಿತಿಯ ಅನುಮೋದಿತ ನಕ್ಷೆ ಹಾಗೂ ನ್ಯಾಯಾಲಯದ ಡಿಗ್ರಿಯ ಮೇಲೆ ಈ ಸೊತ್ತು ಖಾತೆ ಮಾಡಲು 9 ಮತ್ತು 11 ರಾಹ ಇರುವುದರಿಂದ ಗವರ್ಮೆಂಟ್ ಆರ್ಡರ್ ಇಸ್ ದೇರ್ ಅಂತ ಹೇಳಿ
ಬಹಳ ರೀಸನ್ಸ್ ಇದೆ.
ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ಆನೇಕಲ್ ತಾಲೂಕು ಸರ್ಜಾಪುರ ಹೋಬಳಿ ಸರ್ಜಾಪುರ ಗ್ರಾಮ ಪಂಚಾಯತಿ ವ್ಯಾಪ್ತಿ ಸರ್ಜಾಪುರ ಗ್ರಾಮದ ವಾಸಿಯಾದ ಸರ್ ಅಮರೇಶ್ ಬಿನ್ ಎಸ್.ಎಂ. ರಾಮಯ್ಯದ ನೀವು ಸರ್ಜಾಪುರ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 322/1ರಲ್ಲಿ 1 ಎಕರೆ 25 ಗುಂಟೆ ಜಮೀನಲ್ಲಿ ನಿವೇಶನ ಸಂಖ್ಯೆ 1ರಿಂದ 44ರ ಖಾತೆ ಅಸೆಸ್ಮೆಂಟ್ ನಂಬರ್ 1423/1 ರಿಂದ 1423/44 ರವರೆಗೆ ನಿವೇಶನವರೆಗೂ ಸಂಬಂಧಿಸಿದ ಈ ಸೊತ್ತು ಖಾತೆ ಮಾಡಲು ನಮೂನೆ 9 ಮತ್ತು 11 ಗ್ರಾಮ ಪಂಚಾಯತಿಗೆ ಅರ್ಜಿ ನೀಡಿದ್ದು ದಾಖಲೆಗಳನ್ನು ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಲಾಗಿ ತಾವು ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ ಕಾರ್ಯಾಲಯ ಬೆಂಗಳೂರು ನಗರ ಜಿಲ್ಲೆ ರವರಿಂದ ದಿನಾಂಕ 26/6/2012ರಿಂದ 12 ವ್ಯವಸಾಯೇತರ ಜಮೀನನ್ನು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಸಂಖ್ಯೆ ALN ಸೋದಂತೆ ಮಾಡಿಸಿದ್ದು ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ 2012ನೇ ಸಾಲಿನ ನಿವೇಶನಗಳು ನಕ್ಷೆಯನ್ನು ಅನುಮೋದಿಸಿದ್ದು ಅದರ ಪ್ರಕಾರ ಗ್ರಾಮ ಪಂಚಾಯತಿಯಲ್ಲಿ ನಿಮ್ಮ ಹೆಸರಿಗೆ ನಿವೇಶನಗಳನ್ನು ಖಾತೆಯನ್ನು ಸಹ ಮಾಡಿಸಿರುತ್ತದೆ ಹಾಗೂ ಮಾನ್ಯ ಆನೇಕಲ್ ಹಿರಿಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದ OS ನಂಬರ್ 196/2016 ಈ ದಾವೆಯ ಪ್ರಕಾರ ಸತ್ಯ ನಿವೇಶನಗಳ ಪೈಕಿ ನಿಮ್ಮ ಖಾಸಾ ತಮ್ಮನವರಾದ SR ನಾಗೇಶ್ ಅವರಿಗೆ 3 ನಿವೇಶನ ನೀಡಿದ್ದು ಉಳಿದ ನಿವೇಶನಗಳು ನಿಮ್ಮ ಹೆಸರಿಗೆ ಡಿಗ್ರಿ ಸಹ ಆಗಿರುತ್ತದೆ. ಆದರೆ ನಿಮ್ಮ ಹೆಸರಿಗೆ ಈ ಸೊತ್ತು ಖಾತೆ ಮಾಡಲು ಕರ್ನಾಟಕ ಸರ್ಕಾರ ಅಧಿಸೂಚನೆಯ ಸಂಖ್ಯೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸೋನ್ಸೋ ದಿನಾಂಕ
14/2013 ಸುತ್ತಲೆಯ ಪ್ರಕಾರ ಭೂ ಪರಿವರ್ತನೆ ಆದೇಶದ ಪ್ರತಿ ಪಂಚಾಯತಿ ಅನುಮೋದಿತ ನಕ್ಷೆ ಹಾಗೂ ನ್ಯಾಯಾಲಯದ ಡಿಗ್ರಿಯ ಮೇಲೆ ಈ ಸ್ವತ್ತು ಖಾತೆ ಮಾಡಲು ನಮೂನೆ 9 ಮತ್ತು 11 ಸಹ ಇರುವುದರಿಂದ ಹಿಂಬಾಲನೆ ಇದೆ.
Did you take a, so decree ಆಯ್ತದು, so that dispute is no longer there.
There is no dispute.
3 ನಿವೇಶನಗಳು ಅವ್ರಿಗೆ ಹೋಯ್ತು 44.
ಈ ಖಾತೆ ಕೊಡಕ್ ಬರಲ್ಲ ನಿಮ್ಗೆ.
ಇದು ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಆಗಿದೆಯಾ ಲೇಔಟ್?
ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ ಪ್ಲಾನ್ ತಗೊಂಡಿದೆ.
ಎಲ್ಲಿದೆ? Who has sanctioned the layout plan?
Annexure email.
Page.
D approved layout plan page 28. Page 28.
ಯಾರು ಅಪ್ರೂವ್ ಮಾಡಿದ್ದಾರೆ? Gram Panchayat is not authorized to. Gram Panchayat is not authorized to give you a plan.
In use of Gram Panchayat is okay, our time Gram Panchayat is okay.
ಒಂದು ರೋಡ್ಗಳು ಹೆಂಗ್ ಮಾಡಿದೀರಾ ನೀವು? Look at the way you have formed the layout. You have not followed any of the rules applicable. Understand, you want to make as much money as possible on it, but you have to give civic amenities, you have to make parks and open spaces. The roads have to be straight at least.
50 feet road and
20 feet road, 25 feet road. Plan sanction ಆಗಲ್ಲ ಆಮೇಲೆ.
ಅವ್ರು ಅದ್ರ ಹೇಳಲ್ಲ, ಪಂಚಾಯತಿ ಗವರ್ಮೆಂಟ್ ಆಫೀಸ್ ಬೇರೆ saying that ಅವ್ರು ಇದ್ರ ಬಗ್ಗೆ any rise of
ಸುತ್ತುವರಿಯಲ್ಲಿ ಇರೋದು ಅದೇ. That you are, if the plan sanction is not been obtained from the town planning authority, you cannot take a kata ಅಂತ ಇದೆ ಸುತ್ತುವರಿಯಲ್ಲಿ. ತಗೊಳ್ಳಿ ಆಮೇಲೆ ಹೋಗಿ ಕೊಡ್ತಾರೆ. To comply with the applicable rules. We will reserve that liberty to you once you get that. Petitioner is before this court seeking for the following. The grievance of the petitioner is that though the petitioner has formed a layout in survey number 322/1 of Sarjapura village and Hubli Anekal Taluk Bangalore urban district, consisting of 44 sites having assessment number of 1423/1 and 1423/44. The e-Khata relating to the said properties have not been furnished. And while endorsement at Annexure H, the application has been rejected on the ground that the circular dated 14/6/2013 issued by the government order dated 14/6/2013 has not been complied with. On inquiry, learned counsel for the petitioner submits that the layout plan has been approved by the Gram Panchayat on date on 26/6/2012 in terms of Annexure D at page 28. A peril of the same indicates that the said approval is granted by the Gram Panchayat, which is not the planning authority, to sanction the layout plan. It is in that background that the respondents have rejected the application for e-Khata. Unless until the plan sanction is obtained by a landowner from the planning authority, the same cannot be recognized by the municipal authorities in terms of section 17 of the Karnataka Town and Country Planning Act. As such, I do not find any informative in Annexure H, the endorsement dated 21/3/2016 at Annexure H. I pass the following order. The petition stands dismissed. Liberty is however reserved to the petition to approach the local planning authority, obtain you plan sanction for the layout after complying with the applicable rules and regulations, and thereafter approach the respondent for issuance of the plan.
51.
For respondent number 2 now.
Appearing for respondent number 2.
Amit Deshpande has entered appearance for respondent number 2, delete Dr. R. Ramachandran, PM Venkatreddy is appearing for respondent number 2. R3R. Kiran CV has entered appearance for respondent number 2, delete MN Sudev Egde is appearing for respondent number 2. Yes.
Petition has been filed, my lord, seeking a writ of mandamus. First, consider representations dated 7th April 2015 and 22nd July 2015, my lord. First, the factual background in the context of which this petition has been filed is that the land, my lord, I represent, my lord, the Vailikaval House Building Cooperative Society Limited Welfare Association. So the Vailikaval House Building Cooperative Society Limited had acquired, my lord, 165 acres of land for development of a layout, my lord. Subsequently, my lord, what had happened on 7th Feb 2012 was multiple cases were filed, my lord, challenging this acquisition. And after several rounds of litigation, my lord, the Honorable Supreme Court, the judgment has been produced at Annexure A. The Supreme Court, my lord, Annexure A, page 26 and 27. My lord, page 25, para 26 and 27. Land to the extent of 52 acres, my lord, the acquisition was held to be improper. And my lord, at para 27, if I may read, if respondent number 1.
So you are the sites formed are in the area where the specially petition have been withdrawn.
Yeah, my lord, the petitioner's, my lord, sites are not within the 52 acres, which is held to be improper, my lords. The compliance report was filed, my lords. I produced that at Annexure B. And my lords, Annexure C, the Honorable Supreme Court, my lords, accepts my compliance report. Firstly, my lords, Annexure B, page number 26.
26.
Yes, my lord.
It starts.
Yes, my lord. Starts para 2, 27, page number. Consequently, it's my lord.
Yes.
7th line, my lords, from the top. Consequently, the first respondent society has not been put in possession of any of the said 52 acres, 17 guntas of land as detailed in the said notification. Under the circumstances, it is submitted that the question of restoration of possession to the landlord in relation to the aforesaid lands by the first respondent society does not arise. My lords, further, my lords, para 6. Sorry, my lords, para 7, page 31. It says it is reiterated that as far as the first respondent society is concerned, it is not in possession of any extent of the lands comprised in various survey numbers, totally measuring 52 acres, 17 guntas.
What is relevant is para 6.
Yes, sir.
If you assess them to tax and it comes under BBMP jurisdiction, so why don't you provide the service?
My lord, the initial sanction plan which was granted to them covered all these survey numbers, including this 52, my lord. Subsequently, they had filed writ petition before this honorable court, wherein the cancellation of the sanction layout plan was set aside by this honorable court, and matter was remanded back to BDA to issue a fresh layout plan, only excluding these 52 acres, which has been dropped from the acquisition. That has not been done, my lord. So without that new approved layout sanction plan, the representations of the petitioners cannot be considered.
For the BDA, Mr. Kiran. New plan has not been sanctioned.
No, my lord.
My lords, I don't have instructions in with respect to that aspect.
Thank
you. Please, I'll obtain instructions. However, my lords, even basic amenities are not being provided, my lords. In the representation details, my lords, at Annexure G, page number 99 to 100.
Direct them, you'll also have to do something.
Please, my lords.
Can't say I want this without doing.
Please, my lords.
The contention learned counsel for respondent number 2 is that after the entire layout plan had been quashed by this court, the layout plan insofar as the land which was not challenged, the acquisition of the land which was not challenged.
My lord,
page number 91, order passed by this honorable court, wherein the notification passed by BDA cancelling the layout sanction plan was set aside by this honorable court, reserving liberty to petitioners and BDA.
After this.
Para number 5, my lord.
Respondent number 2 is that after the entire the layout plan was cancelled by the BDA, this court had set aside the said cancellation and remitted the matter to the BDA, with liberty being reserved to the petitioner and other purchasers of the sites to obtain a plan sanction in respect of the lands which are not subject matter of the acquisition proceedings. Since the said layout plan has not been sanctioned and the common areas in terms of the roads and civic amenities not being transferred to the BBMP is unable to render the civic services. Faced with the above situation, the counsel for the petitioner seeks for and is granted 2 weeks' time to obtain instruction and make a submission. The counsel for the BDA is also directed to place on record the action taken by the BDA and if any plan sanction has been granted by the BDA. Released on 30th May.
Today, my friend has given the objection to me. Now, the statement of objection is given to me to the IA.
Yes.
I find one more document is to file. I will file it tomorrow. I will turn day after tomorrow.
One submission, the crux of this matter, your lordships.
One more document I have to file.
No,
You filed amendment application for which they have filed
She has given the objection
objections.
now.
we have filed it already in the court. It's been filed long back, 17/3/20.
Today, yes, she has furnished me.
Today, what I have given him is a formal statement of objections to this
the writ
writ petition, which may actually exist for the purpose that whatever I'm saying is in writing, that's all.
So what about this amendment? Any objection?
No, we have objections. It's changing the nature of the writ petition completely.
Iವಾಗ objections to IA ಕೊಟ್ಟಿದ್ದಾರೆ, objection to the main.
Objection to the main ಕೊಟ್ಟಿದ್ದಾರೆ.
IA ಮುಗ್ಸೋಣ.
IA ಜೊತೆಗೆ one more. I wanted to file a plain copy. The order of the authorities refer to a suit, OS 537, on the ground that.
Any interim order is there?
No interim order. Interim order is there. Interim order is there.
No.
One minute.
It's a rule missy has been already issued in this case. If he's going to keep seeking adjournment, then I'll object to the rule missy.
I am only.
Be withdrawn.
I am only filing.
Missy here.
And I will only file the plain copy and argue the matter day after tomorrow. I will play. By mistake, that plain copy is not put before the court. The order refers to the pendency of the suit.
There is no interim order.
Interim order there. The interim order there.
This was issued on 2016.
Yeah, Annexure A dated 1/4/2016. Issued by third respondent. That is interim order is made on.
On the first day when the matter came up, on 5/5/2016.
5th May 2016.
After that, you are not addressing any arguments.
By mistake. I was not filed the transfer brief to me. Thereafter, I filed the application. Filing the application.
Petitioner submit that he has received the statement of objections to the main pay, which he would like to go through. And also you would like to produce.
Place the copy of the plaint.
A copy of the plaint.
Which is referred to in the order of the authority.
In OS number?
5735.
5735 of?
2008. 2008.
Released on 13th, it is made clear that no further adjournment is granted. If arguments are not advanced on that, petition will be liable to dismiss for non-prosecution.
Number 63, Kumar.
My lordship, serial number 63, I'm for the petitioners, my lordship. My lordship, weeks time may kindly be granted, my lordship. Since the petitioner's family, his grandfather has been expired, we have to take a
Also, the petitioner submitted the agreement. Family of the petitioner and is granted to be released on 5th June.
grateful.
64.
My lords, appear for the petitioner in this case, my lords. My lords, seeks for week time in this case, my lords.
You are appearing. Sri A. Jagannath has entered appearance for respondent number 1 and 2. Delete M.N. Ramanjneya as that appearing for respondent 1 and 2. Counsel for the petitioner seeks for and is granted 2 weeks time to get ready and have his arguments. Relist on 5th June. If arguments are not advanced, you can not.
That's it, my lords.
The respondent Lordship, senior counsel is having some inconvenience. Ask some to post it next week.
Is against dismissal order by the CH-18.
Counsel for the petitioner seeks for and is granted 2 weeks time to get ready and address arguments. Relist on 5th. If arguments are not advanced, dismiss for non-counsel. Any mentioning?
Serial number 19.
Yes.
Passed over the client
What instruction?
is present. In fact, instructions that the construction is still going on even today.
Even today.
Yes, my lords. My lords, petition to appointment of commissioner, I would like to press upon the police protection application, my lords. Reason
We will
being.
get the details by tomorrow. Who is the?
I am for respondent. I am for respondent, my lords. In the morning, my lords, I make a submission. I need 3 days time to file objections. My friend, in the meantime, she wanted protection from this court. In fact, we written letter to the concerned developer not to proceed to the construction. We have not started, we have not completed the work.
At the new only appointing a commissioner.
Your lordship, list 2, your lordship.
Just a moment, please.
Serial number 20.
Who is the person? Who have you identified to go as visit the property?
Nobody, my lords.
He asked you to identify one
Yes.
common person.
That was the reason the matter was.
Okay,
also-
who wants to be a commissioner?
ITA.
Some payment will be made.
ITA. It's near the Kiarpuram.
Here we have. You'll have to take her and get her back.
Yes, definitely. I will. Parties.
Serial number
19.
19. The contention of the counsel for the petitioner is that even today the construction is going on despite the orders passed by this court restraining such construction. Sri N.R. Jagdishwara, learned counsel for the corporation, submit that instructions have already been given to the contractor to stop construction and that the contractor has stopped construction. Normally, this court would have accepted the submission made by the counsel for the corporation. But however, this is a strange case where one government entity is making serious allegation against another government entity. Therefore, I deem it fit to appoint a commissioner to visit the property in question and to submit a report on whether any construction is going on or not. Miss so and so is appointed as a court commissioner to visit the property, which shall be done during the course of the day, and a report submitted tomorrow along with photographs indicating whether any construction is going on or not. The transport, the petitioner shall provide all transport facilities to the commissioner to visit the premises, also the services of a photographer to take necessary photographs. Relist tomorrow.
Some submission. My lords, a report with respect to whether any construction has happened from 7/3.
That has happened, there's no dispute. Whether it's going on is a.
Please.
That's all.
As per the information given by the IAEE, Star Motor.
N.R. Jagdishwara on instructions of AEE subjects.
Malati. Serial number.
Just one minute.
Serial number 20.
Yes. 49. (49) at the request of counsel for the petitioner, relist on 18.
46.
Illinda Batti.
66.
66.
Take up next week.
We inform 66 at the request of counsel for the petition released on 6th June.
Serial number 20, my lord. ADLR appointed to conduct this survey, but 25-3 has not conducted the survey.
Copy is not been served, my lord.
Copy not served in matter.
Today I will serve the copy, my lord.
20.
One more copy.
Learned counsel for respond number, learned AGA submit that the survey could not be carried out since the petition and annexure copies were not furnished. Sri Chokkar undertakes to furnish the same by end of day today. In view thereof, the ADLR to carry out the survey commencing from 10:30 a.m. on 15th April 2023 and submit a report by 19th April, released on 20th April. 46.
So, and the interim order may be extended.
Interim order is extended.
46.
Really?
Kindly have next. I have intimated.
46 at the request of the counsel petitioner released on 6th June.
127 also.
Jumping that you matte hing band nenskondre. 127.
Yeah. That I have already filed.
127 at the request of counsel for respond number 2.
Connected matter. Both two.
127.1 Ali Shri TM Venkatreddy has entered up in, so I want to delete Ashwin as already. The request of counsel for respond number 1 and 2 released on 6th June. Interim order earlier granted is extended till next.
Till number 73, man.
73.
Appear for respondent and for petitioner counsel. Kindly have it after vacation.
73 at the request of counsel for respond number 4 released on 5th June.
After vacation, man.
5th June, ಯಾವ vacation? Summer or winter? 5th June.
Your lordship, list 2, your lordship, speaking, your lordship.
List 2 will be adjourned.
No, your lordship, memo for being spoken to in 2 matters, your lordship, 22 and.
List 2.
Yes, sir, serial number 22, 1.22, your lordship. 1.22, your lordship, it was for an occupancy certificate, your lordship, and there is a stay granted on the ground rent, your lordship. However, only the GST amount has been mentioned in the interim order. The main ground rent matter has not been mentioned, your lordship. One more subsequent, one more matter, your lordship, which matter for being spoken to is there.
We'll have to take up the matter, then only we can see what the order is.
Serial number 8.
It's not a matter that you can mention matter.
Number 155, my lord.
Yes.
I filing power for respond number 6, my lord. Kindly have it next week. 155.
So also submit that should be filing Vakalatama for respond number
6, my lord.
6.
Yes.
6. And she seeks a short accommodation released on 5th June.
Serial number 11.
Appears for response 1 to 3.
Yes.
Needs to file objections to that.
The MN Kumar submit that he is filed Vakalatama for respond number.
It is shown in the call this.
Registry is directed, delete the name of Shanti Bhushan as that appearing for respond number 1 to 3. He seeks for and is granted 2 weeks time to file his statement of objection released on 5th June.
Serial number 18. 18 pass or man.
18.
18 other some circular is man. Kindly have it active objection
Section number 17, all that it says is not accepted. Not even a single plot. If there's a development plan, not which you have to accept, not take, then not all this is needed. Otherwise, it's not.
Yes.
It has got nothing to do with this. You have not. I've got a kata. Ee kata ಮಾಡಬೇಕಂತ order ಮಾಡಿದ್ದೀವಿ.
Circular ಕೂಡ ಇದನ್ನ objection ಹಾಕಬೇಕಾಗುತ್ತೆ ಯಾಕಂದ್ರೆ we have issued the endorsement question ಮಾಡಬೇಕಾಗುತ್ತೆ. That's the main point. Second one is circular is there and another some more document is there. And
there seem to be a lot of it underlying this matter. Answer.
Kindly after 1 week time.
The way 4-year-old application.
ಅಲ್ಲ ಯಾಕಂದ್ರೆ circular is there. Circular.
78.
You'll have to tell us how you are complying with it. We'll take it up after we comply.
Next week.
My lord, serial number 78 in first place.
78. Yes, madam.
My lord, kindly have it after occasion, my lord. We will file the objection, my lord. I am for the respond number 4.
The K.R. Krishnamurthy has entered appearance with the petition delete Swami Shiv Prakash as that appearing petitioner. And counsel for respond number 4 seeks for and is granted 2 weeks time to file statement of objection. Released on 5th June.
With your lordship permission, 125.
Yes, Mr.
I undertake to appear for third respondent, Nelmangla Municipality,
Have you
They have
informed
been
Hegde? Have you informed Mr. Hegde?
No, my lord, I just saw the list. I contacted the officials and they said
That you would be entering appearance to respond number 3. He seeks for and is granted 2 weeks time to file a statement of objections. Relist on 6 June.
Lordship, 35.1, my lordship.
35.
Intimate is there, my lordship. Kindly maybe.
Done 18.
118, Mr. Rao. Yes. ಎಲ್ಲರಿಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? Is undertaking bad. 118 at the request of counsel for the petitioner relist on 6 June.
Serial number 83, ma'am.
83.
For the petitioner, my lord. Short date may be given.
At the request of counsel for the petitioner relist on 12 June.
Serial number 85, my lord. For the petitioner, regular counsel unwell.
Inform the response.
May be held after vacation, my lord.
For the petitioner relist on 12 June.
Madam, party day lene. Serial number 109. Madam, 105. Again 109. 140. 120. Madam, 120. One 140, madam. 123, madam. 120. 153. 153. 165.
162, madam.
Second list. 160. Second list. 567. Day after tomorrow. The day after tomorrow. Later, okay. Fresh matter is okay. Fresh matter is okay. 62. ವರೆಗೂ ಮುಗಿದಿದೆ ನೋಡಿ. 57 ಮುಗಿದಿದೆ. 67 ಜನ 57 56. ಈಗ ಬೆಳಗ್ಗೆ ಸಿಲ್ವರ್ 20 ಅಂತ 20 ನಿತ್ಯ ಅವರ ಇನ್ಶೂರೆನ್ಸ್ ಅದು ನನಗೆ ಹೇಳಿಲ್ಲ ಏನಂತ. ನಾನು ರಿಪೋರ್ಟ್ ಬಂದಿದೆ ನೋಡ್ತೀನಿ. ಅಂತ ಇಮಿಡಿಯೇಟ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್ ಅಂತ. ಅಲ್ಲ ಇನ್ನೊಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ ಸರ್ ಅಂತ. ಅವಾಗ ಇಂಥವ್ರಿಗೆ ಇಮಿಡಿಯೇಟ್ ಮೆಸೇಜ್ ಇದೆ, ಕಾಪಿನೇ ಕೊಟ್ಟಿಲ್ಲ ಅವ್ರೊಂದು. ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಇಮಿಡಿಯೇಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟಿರ್ತಾರೆ. ಕಾಪಿ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಇಮಿಡಿಯೇಟ್ ಮಾಡಿಸ್ಬಿಟ್ಟಿರ್ತಾರೆ ಅವ್ರು. ಏನೋ ಒಂದು ಮಾಡಿಸ್ಬಿಟ್ಟಿರ್ತಾರೆ, ಏನೂ ಇಲ್ಲ ಅವ್ರಲ್ಲಿ. ಅಯ್ಯೋ ಅದೇ ಕಷ್ಟ.
137. Yeah, was also good. Third constant. ఇక్కడ పెన్ను ఎలా ఎత్తుకుపోవడం స్పీకర్
Court officer. Court officer, number bench.
Seven, sir. Legal head dichu.
What officer?
Fast over.
What officer? Kalaburagi bench ಗಾಡಿ ಹೊಡೆ ಕ್ಲಿಯರ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್?
No difficulty, but ಬರ್ಬೇಕಷ್ಟೇ. Yes. Thank you.
Ma'am, good afternoon, ma'am. 112. Yeah.
160.
Entry model. Entry model.
81 ಏನಾದ್ರು adjournment ತಗೊಂಡವ್ರೆ 81 89 89 ಆಮೇಲೆ 100
ಡೌಟ್ ಇರ್ತದೆ.
ಅಲ್ಲಿ ಬರ್ದಿದಾರ ನೋಡ್ಕೊಂಡ್ಬಿಡೋಣ ಅಂತ.
Madam Code Officer 230 matters first ತಗೊಂತಾರಮ್ಮ.
ಫಸ್ಟ್ ಧಾರವಾಡ ಮ್ಯಾಟ್ರ್ ಇದೆ ಅದು ಫಸ್ಟ್.
Okay.
ಆಮೇಲೆ 230 ಮ್ಯಾಟರ್ಸ್.
Thank you.
Madam, serial number 170. Right? Yes, I will.
ಮ್ಯಾಟರ್ಸ್ ಬೇಗ ಮುಗಿತಾವ? ಇದಾವ? ಬೆಂಚ್ ಬೆಂಚು
ಸರಿ ಇದೆ, ಒಂದೇ ಒಂದು ಮ್ಯಾಟರ್ ಆಗೋದು.
ಮಾಡ್ಸಿ.
ಮೇಡಮ್, ಯಾವ್ದು ಮೇಡಮ್ ಎಕ್ಸ್ಟ್ರಾ ಬಾಕ್ಸ್ ಹಾಕಿದ್ದೀರಂತಲ್ಲ ನಿಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ? ಯಾವ್ದು ಹೇಳಿ? ಹೌದು, ಇನ್ಯಾವ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ, ಇದೊಂದೇ ಕೋರ್ಟ್. ಹೌದಾ, ಕ್ಲರ್ಕ್ ಕೇಳ್ಕೊಂಬಂದ.
ಹಿಂಗೆ ಎಲ್ಲ ಕೊಡ್ಲಿ.
ಎಲ್ಲ ಹೊಟ್ಟೋಗಿದೆ ಏನು ಇದು ಹೋಗಿದೆ.
ಇದು ಅಂತ ಕಂಟಿನ್ಯೂ ಆಯ್ತಾ?
Mission, my lord.
Let's finish Dharwad bench.
Dharwad bench.
Connected matters.
ಇದೆ ರಿಪೋರ್ಟ್.
Memo dated 9/3/2023 has been filed. Enclosing therewith the minutes of the various meetings conducted by technical committee. The same is taken on record. For further compliance, relist on 12 June at 2:30 p.m. 12 June, Basraj.
Yes.
Serial number 2. Mr. LPG.
Serial number 2. Mr. Bankar.
Millers. Serial number 2. I have not received any information, Millers. Kindly grant me 2 weeks time.
Taking too much time. Mr.
Yes.
Bankar. Cannot take this much time.
Because of the election, busy Millers, officers are engaging in election.
This is pending for much before the dates were announced. Not a reason. Which officer has to give you the instructions?
Yeah, office in the. My lordship. My lordship.
Mr. Bankar. Yaar kodbek instructions idralli?
My lord, Secretary to Government Department of Women and Child Welfare.
The VM Bankar, Leonard Ka, additional SPP seeks for a short accommodation compliance in view of the impending elections. Relist on 12th June at 2:30 p.m.
Please.
Instructions were not received by then. The Secretary and Child Welfare shall be present through video conferencing before this court.
Please, my lord. My lord, copy of the order may kindly be made available to me.
Upload agata.
Please.
Ivattu naale upload agata.
Please.
12th ಒಳಗೆ ಅವರು ಕೊಟ್ರೆ ಒಳ್ಳೇದಿಲ್ಲ, let them, so we'll tell them why it's urgent then.
Please.
Mr. Rajare, you can carry on with your Nimbere matters carry on.
Yes, please. 160, your lordship.
60.
160, 160.
260.
160 million. Request my lord by tomorrow, my lord, I am seeking.
Not tomorrow, after with it.
Some urgency is there, your lordship. It's coming the, that's why, my lord. Otherwise they would not.
2 ದಿನ ರಜಾ ಬಂದು ಎಲ್ಲ
I know.
ಆಗಿದೆ.
ಅದು ಹಂಗಾಗಿದೆ, ಇದು
Reach ಆಗುತ್ತೆ.
ಸ್ವಲ್ಪ ಸಮಸ್ಯೆ ಇದೆ ಅನ್ಕೊಂಡು. Otherwise, tomorrow.
60 at the request of counsel for the petition released on 13.
If it doesn't reach, my lord, I will make a mention.
It seems other side vote for
Yes.
military model.
164. You are not informed?
He informed me now.
Yes. 130 mention ಮಾಡಿ. Inform ಮಾಡಿದೀವಿ.
Solid.
Interim order 160.
Model.
Number 170, my lord. 2 weeks time I think and my lord. Petitioner has filed the counter, my lord.
ಒಂದು ನಿಮಿಷ reaching.
Pronouncement of order. Serial number 167. K.D. Narayana Swamy.
WP 31108 of 2011 filed by the employer is allowed. Writ of certiorari is issued. The award dated 30/10/2010 passed by Labour Court Mysore and IID 109 is set aside. The matter is remitted to the Labour Court for fresh consideration by affording an opportunity to the employer to lead evidence as regards the delinquency of the workwoman and the proportionality of the punishment. Needless to say, workwoman would have the right to cross-examine the witness of the employer as also to lead her own evidence. In view of the orders passed in WP number 31108 of 2011, the writ petition WP 17167 of 2012 filed by the workwoman does not survive for consideration and stands disposed.
168. K.R. Anand.
The respondents, my lord.
The writ petition filed by the employer in WP 31261 of 2016 challenging the impugned award dated 18/2/2016 passed by the Principal Labour Court Bangalore in reference number 14 of 2012 stands dismissed. The writ petition filed by the workmen in WP number 57652 of 2017 seeking for modification of the award by granting full back wages is also dismissed.
169.
I appear for the I appear for the respondent in this matter, my lord.
The writ petition is allowed. The order dated 24/8/2022 bearing number so and so passed by respondent number 2 is hereby quashed.
Obliged, my lord.
230 matter.
Yes.
Serial number 166. Reddy.
Further development. With regarding to the 20th February order, my lord, it is not uploaded. Even I have applied for certified copy. And
Upload again. 20th February.
even I applied for also not made available.
Upload ಆಗಿದೆ ಅನ್ಕೋಸ್ತಾ
February ಒಂದು order ಆಗಿದೆ. E2 ಆಗಿದೆ.
Main items ಏನಿಲ್ಲ.
ಇವಾಗ ಕಮಿಟಿ ಕಾಸ್ಟ್ ಇದು ಮಾಡಿದ್ದಾರೆ.
5, 6, 11 and 12 are the important items.
5, 6.
5, 6, 11, 12 and 17. ಅದಕ್ಕೆ ಟೈಮ್ ಲೈನ್ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ.
ಮಾಡಿಲ್ಲ ಅದು.
ಬಾಕಿ ಎಲ್ಲ ಸ್ಮಾಲರ್ ಐಟಮ್ಸ್ ಮಾಡಿದ್ದಾರೆ.
ಸ್ಮಾಲರ್ ಅಲ್ಲ, ಕಮಿಷನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಗುಡ್ ಪ್ರೋಗ್ರೆಸ್, ಒಳ್ಳೆ ಪ್ರೋಗ್ರೆಸ್. A memo has been filed by the counsel for respondent, enclosing therewith the minutes of the meeting dated 23rd March 2023, as also the status of digitization of records of the Bangalore Development Authority. A perusal of the minutes of the meeting indicates that no dates have been fixed for deployment of the modules at serial number 1, 5, 6, 11, 12, 17 and 22. The counsel for respondent is directed to
ERP ಅಂತ ಏನೋ ಮಾಡಿದ್ದಾರೆ. Regular bidding.
What is the date? Date ಯಾವಾಗ ಬರುತ್ತೆ ಅಂತ. ಬಿಟ್ಟು ಫೈನಲೈಸ್ ಆಗಿದೆ ಅಲ್ಲ.
ಅವಾಗ ಕರೆದಾಗ, ಯಾಕಂದ್ರೆ ರೆಗ್ಯುಲರ್ ಇರಲ್ಲ, ಯಾವಾಗ ಆಕ್ಷನ್ಗೆ ಹಾಕಿದಾಗ.
ಇದು ಒಂದು ಸಾಫ್ಟ್ವೇರ್ ಡೆವಲಪ್ಮೆಂಟ್ ಅಲ್ಲ.
ಅದು ಆಕ್ಷನ್ ಯಾವಾಗಲೂ ನೋಟಿಫಿಕೇಶನ್.
ಆಕ್ಷನ್ ಅದಲ್ಲ, ಸಕ್ಸಸ್ಫುಲ್ ಬಿಡ್ಡರ್ ಫಾರ್ ERP. ಅವ್ರು ಯಾವಾಗ ಕೊಡ್ಬೇಕು ನಿಮ್ಗೆ? Just to finish the software sometime. Counsel for respondent is directed to place on record as to when the successful bidder would be completing those modules and the modules would be deployed at the BDA. Insofar as the digitization of records, it is seen that 10,405 files have been digitized. The total number of available files have still not been placed on record. And counsel for respondent is directed to place on record the total physical files, total number of physical files available with the BDA, requiring digital, available with the BDA. Relist on 29/5.
ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಸರ್. ಫೆಬ್ರವರಿ ಆರ್ಡರ್ ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಇಲ್ಲಿ ಎಲ್ಲ ತೋರಿಸ್ತಾ ಇಲ್ಲ. ಮೊನ್ನೆ ಚೆಕ್ ಮಾಡಿ ಯಾವುದು ಪೆಂಡಿಂಗ್ ಇಲ್ಲ.
Further hearing, period number 170. First year and practical.
2 weeks time. I filed the replay for the filed by the petitioners. 2 weeks. Because the report has not been completed yet.
2 weeks only after vacation.
Yes. Immediately after vacation, I will file.
That will be 6 weeks.
Hello?
That will be 6 weeks time.
No.
Can I make one request, Manoj? Let him go through it, Manoj. By chance any defect is there, let him tell us, we'll comply, so that let it not again come for objection. It's taking time. If we, because our cases, we are not going to go contrary to what they're saying. Let them give us, tell, and we will comply it so that we can report compliance rather than report objections, Manoj.
And counsel for respond number 1, 2, 3 submit 6 for and is granted 2 weeks time to file the objections to the report submitted by the counsel for the petitioner. Said objections to be filed on or before 28 April 2023 after serving a copy thereof on the counsel for the petitioner. Counsel for the petitioner to go through the same and make his
Can I make one request, Manoj? Let them call for a meeting before they give the objection so that we can comply with it, with that objections, and then we can file a report.
You file your compliance, then
Please.
you have a meeting.
Please, we'll do that.
Before 12th May 2023, after serving a copy thereof on the counsel for the respondents. In the meanwhile, if there are any other issues to be ironed out, the petitioner and the respondent will have a meeting in the week commencing 15th May 2023.
Please,
It is the matter on 29th May at 2:30 p.m.
that will help us, Manoj, to iron out. If you have a meeting, Manoj, so that whatever the objection that will iron out. Please. Please.
Final hearing, serial number 171. Kumar Shetty.
Last time they were directed, sir, to submit regarding the sales made by them.
Annexure Q, your lordship.
Annexure Q.
Your lordship had asked us to verify if
At page 231. Yes. Now, these are the sites which have been allotted to these persons. Is that a
that's what their claim was. We have absolutely nothing to do with any of their sales, and post HMT. No objection. Absolutely. We have no objection to file an affidavit. Your lordship, it is even impossible for us to have even made those sales. This arises out of a layout.
This is why we asked you, because it's a very serious allegation.
Please. And we have, in fact, if they are able to take out the sale deed itself, it would be evident that we have nothing to do with it. In fact,
We'll ask them to file an affidavit, but you are also making a serious allegation if you found false.
Before the original
Even registration number, etc.
Yes, ma'am.
So if you have got the registration number, you should be having the sale deeds. Sale deed copy irubekala nimge.
ಇಲ್ಲ ನಮ್ಮ ಹತ್ರ ಇದೆ.
But the number ಎಲ್ಲಿಂದ ಬಂತು?
That we have collected from the.
How did you collect without copy? Either you should have the encumbrance certificate that reflects it, or you should have the sale deed copy.
Probably from the encumbrance certificate they have.
Produce the encumbrance certificate. Either of those two.
But even before the original authority.
Where will you get these numbers?
pass on, your lordship, the order. This was connected with the other matter wherein your lordship had sought those apartment details, your lordship. This was connected with that. And this is the order. Last time I was mentioning, your lordship said it's not available in the order sheet. This was the order. My learned friend was directed where.
Which order sheet do you want? Which order do you want us to see?
Your lordship, this is the order dated 5/7/2022. It is not in this file since it was recorded in the other file. And that is why your lordship, last time when I mentioned, lordship said it's not in the file. In fact,
5/7/2022.
please. This is the identical matter where writ appeals already been disposed of, only with respect to the interest component. And therefore, Mr. Sankumar said, no, I have not read this judgment. And therefore, this Honorable Court directed him, kindly read this judgment and come back to us as to what you have to say about the interest component.
You were given this, is there, Mr. Shetty?
Yes.
It's been recorded that you were to get back on
Yes.
division bench order.
Yes.
What is your say on the division? Now you have the copy of the division bench.
Yes.
So what is your submission on that?
My lord, the Honorable Court was not called upon to decide as to whether they should allot a right to us. My lord, the only question that was involved was the question of interest.
Here is the order of division.
The division bench order copy. That's good. Rising out of matters, very same date of order, your lordship.
This number, this number alarm.
అదే Madam.
Here, there was no allotment of these sites to a third party. That has not been considered in this. That is what we are, in this matter, we have to consider.
In this matter, Your Lordship, what happens is in his matter also, twice we have sent his amount, but twice he has rejected stating I'm not accepting. What happened before the law court was that they ordered that either you give them a site if you have, or return the amount with interest.
Correct.
We had gone on an appeal on that aspect stating that interest component would not be paid. KT order, that is the impugned order herein held that interest component is not payable, refund their initial amount. That came up before the single bench. Single bench held in our favor stating interest is also not payable, return the amount. Division bench ultimately said under the interest act, whatever, you would have to pay that also and therefore pay them. We have that attained finality, we have now paid all of them. He has not challenged that initial order and our order, the KT order, Your Lordship, that is before this honorable court. Now, what even the division bench observed is that order of the law court was never challenged by them, and therefore that with respect to alternative site attains finality because it's either or. And therefore, at this
What
point,
was the challenge before the KAT?
the KT order, Your Lordship, the consumer.
Page 83 of the original authority's order. Kindly be seen. Last paragraph, page 83. ವಾದಿ ಹಾಗೂ ಪ್ರತಿವಾದಿಗಳು ತಮ್ಮ ಪರ ಲಿಖಿತವಾದ ಮಂಡಿಸಿರುತ್ತಾರೆ, ಅದನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿದೆ. ವಾದಿಯು ಪ್ರತಿವಾದ ಸಂಘದಿಂದ 50x80 ಅಡಿ ಅಳತೆಯ ನಿವೇಶನವನ್ನು ಹಂಚಿಕೆ ಮಾಡಿ ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ಪ್ರತಿವಾದಿ ಸಂಘಕ್ಕೆ ನಿವೇಶನ ಠೇವಣಿ ಹಣ 1,72,592 ಪಾವತಿ ಮಾಡಿರುವುದು ಉಭಯ ಪಕ್ಷಗಾರರು ಸಲ್ಲಿಸಿರುವ ದಾಖಲೆ ಮತ್ತು ಹೇಳಿಕೆಯಿಂದ ದೃಢಪಟ್ಟಿದೆ. ಪ್ರತಿವಾದಿ ಸಂಘವು ವಾದಿಗೆ ನಿವೇಶನ ಹಂಚಿಕೆ ಮಾಡದೆ ಬೇರೆಯವರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿರುವ ಕ್ರಮ ಸರಿಯಲ್ಲವೆಂದು ನ್ಯಾಯಾಲಯ ಪರಿಗಣಿಸಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ರಿಟ್ ಅರ್ಜಿ ನಂಬರ್ ಸೋ ಅಂಡ್ ಸೋ ನ್ಯಾಯಾಲಯವು ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಿಕೊಳ್ಳಲು ನಿರ್ದೇಶನ ಮಾಡಿದ್ದರು ಅದರಂತೆ ನಡೆಯದೆ ಕೊತ್ತನೂರು ಗ್ರಾಮದಲ್ಲಿ 55 ಎಕರೆಯಲ್ಲಿ ರಚಿಸಿರುವ ನಿವೇಶನಗಳನ್ನು ವಾದಿ ಮತ್ತು ಮತ್ತಿತರ ಅರ್ಹ ಸದಸ್ಯರಿಗೆ ಹಂಚಿಕೆ ಮಾಡದೆ ಅದನ್ನು ಮಾರಾಟ ಮಾಡಿ ಬಂದ ಹಣದಿಂದ ನಿವೇಶನ ಠೇವಣಿ ಹಿಂತಿರುಗಿಸಲು ಕೈಗೊಂಡಿರುವ ತೀರ್ಮಾನ ಸರಿಯಾದ ಕ್ರಮವಾಗಿಲ್ಲ. This is what the original authority has observed. 50, they had promised me to give a site at Kotanuru as per annexure E2. Alternative site E3.
This 1,72,000 is the entire consideration.
Yes, ma'am. Entire consideration.
Entire consideration.
Yes, ma'am.
There's nothing remaining to be.
Nothing remaining. My lord, E3 may kindly be seen. Page 106. That is in the year 2000.
This we have seen.
Yes, that is what
was that
they had promised me to give a site.
submission made as regard this order, which was not found. Now they're placed, and we have seen the writ appeal order also. But in the writ appeal, the issue about transferring the property to somebody else was not the issue.
No, that was not an issue. And
But in this matter, it's an issue.
It's an issue.
So you will have to satisfy us.
order at page 63, your lordship, that is the Adesha, your lordship, may kindly see.
Yes, madam, but that also goes back to the original order also. The original claim made by the petitioner is that instead of allotting a site to him, they sold it to somebody else who was not entitled to. And in pursuance thereof, he has produced these documents at Annexure Q, list of details.
Annexure Q,
So
your lordship.
we had asked both of you, one as regard division bench and two as regards this allotment.
Your lordship, with respect to Annexure Q. No, that's okay. I'll read it. I'll convince your lordship. Lordship, Annexure Q is with respect to certain registrations and several, one name, several plots, your lordship felt that we had sold.
Yes.
We had never even got the entire the layout. Your lordship, post HMT Khader, we have not, everything went back to the erstwhile landowners. In fact, the society did not have any land in its possession. Therefore, all these are individual sales that have taken place.
By whom?
Not by us, your lordship. That if they are able to place the EC or whatever he said with respect to his claim.
So according to you, these sales have not been affected by this
Absolutely not.
society or its office bearers?
Please.
The observation of the original authority, my lord. 55
You have to
acres.
place this document, Mr. Shetty. You are the one who is making the allegation.
My lord,
You can't go by this statement only.
my lord, the original authority makes an observation. 55 acres of land have been transferred.
Mr. Shetty, if you want to place it, you can place it. Otherwise, we'll have to say you're not.
I will try to place it. I will try to place it.
You have given all these details.
I will try to place
The
it.
categorical submission made by
My
them.
client is an old man, therefore.
The categorical submission.
85.
If it's a false submission, they'll face the music. But if your submission is also false,
My lord, what
and giving all these details,
My lord,
given cycle measurement,
original authority.
date of registration, registration number, everything you have given.
Original authority, I have placed it. And after
And
this, my lord, original authority makes an observation.
Counsel for respond number 1, by relying on the order dated 5/7/2022, passed in WP number 34366 of 2020, submits that the order of the division bench in WA number 2829 of 2011 would be equally applicable to the present matter. Having perused the order passed by the learned division bench, it is seen that in that matter, there was no contention which had been raised by the petitioner as regards the sites which had been applied for by the petitioner being transferred to third parties. As such, I am of the considered opinion that the said order in WA number 2829 of 2011 would not be applicable to the present matter. Insofar as Annexure Q at page 231 to 234 are concerned, where the petitioner has given details of the sites sold in favor of certain person, as also details of site number, date of registration, title measurement, sale consideration, registration number. That Counsel for respond number 1 submits that the respond number 1 society and or its office bearers have not executed any such sale, and the sales referred to in Annexure Q cannot be attributed to respond number 1. Faced with the above situation, the Counsel for the petitioner seeks for and is granted
After vacation.
4 weeks' time to place on record the sale deeds. ECL ಯಾರು ಸೇಲ್ ಮಾಡಿದಾರೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
Right.
ಸೇಲ್ ಡೀಡ್ಸ್ ಬೇಕಾಗುತ್ತೆ. ಎಲ್ಲಿಂದನೋ ತಂದಿದ್ದೀರಾ, ಬಟ್ ಯು ನೀಡ್ ದ ಸೇಲ್ ಡೀಡ್ಸ್. Sale deeds referred to in Annexure Q, if not all, at least a few of them. Released on 30th May.
Your Lordship, might I request, since the origination, there's some difficulty. The Adesha portion, Your Lordship, that was conveniently overlooked. That portion is looked, Your Lordship. This is already, he's the one who supposedly produced that book for the lower court.
Adesha could be anything. Here, the contentions which have been raised, the issue is you have sold it and he has given details, which has not been considered. It's a.
And if that has not been considered, he should have approached the CH-18 appeal. When we had appealed, it could have been a counterclaim also. There could have been cross appeals, in fact. Therefore, even the division bench holds that when they have not challenged this order, it attains finality. And therefore, at this point of time, they cannot come. Therefore, Your Lordship, the portion where Your Lordship says it might not be applicable would be incorrect, Your Lordship.
You have not challenged this order.
Yes.
I have not challenged.
What remains, Mr. Shuk?
My lord, what I beg to submit, my lord, is that, my lord, it is a society. It is established.
If you haven't challenged,
allotting.
if you haven't challenged it, how would it?
My lord, there is an order, my lord, which remains, my lord, that they will have to allot the site. If they fail to allot, my lord, they will have to return the amount. My lord, they had the sites.
But if an order goes against you, you have to challenge it.
Should have.
If you haven't challenged it, can it be taken up now?
Lord,
you read the earlier portion, but the other.
Yes, he did not.
Last time we had argued on that point. After observing that only, Your Lordship directed the.
No.
Yes, ma'am. Yes, ma'am.
Was never.
Yes, ma'am. It was, entire order was read.
No.
And this order is taken into consideration.
But if it was read or not read, now when we are reading this, yes, you not challenge it.
I have not challenged. Last time also I have said, my lord, clearly I have said, my lord, that it was not challenged.
It would be a problem.
The order was to be dictated against them, and then he said, I've not seen the division bench order.
That issue was still pending consideration, you could have directed them. That is no longer pending because you're not challenging. Only issue pending is the interest.
Not interest.
Yes.
Yes, my lord. Yes.
On their appeal.
They are liable
Not on their appeal, on their appeal.
Their liability to allot the site will not go away.
That's attained finality.
Lord, if they have sold the properties, then say, my lord, that we have no sites.
No, it can't be. Can't be.
My lord, during the pendency of the matter, my lord.
You have not challenged this order even till today. You have accepted this order. When was this order passed? On 3/3/2006. You accepted the order. Only issue which has gone about till now is the interest.
My lord, society is meant for allotting the site to its members.
If you had challenged it, yes, you accepted this.
My lord, the order is, my lord, you allot the sites. If you don't allot, my lord, you refund it. Their first portion of the order is, my lord, to allot the sites. My lord, if
It's or.
not or.
Athava.
Tappidalli. Not or.
In the event of not so and so, then the same aspect has been dealt with already by the division bench. So now he can't try a new interpretation.
This aspect has not been considered by the division bench. Yes, a point.
Your Lordship, the very same issue.
It is not that there's no direction for allotment of site. There is a direction for allotment of site.
In the alternative.
You cannot take what is convenient to you.
If there is no site, Your Lordship, there would be
So
absolutely.
what is it that you could have challenged in this order?
Your Lordship,
What should he have challenged? If he were to challenge this order, what should he have challenged?
he should challenge that there cannot be an alternative that in the event of no site, then he would have to be given. Your Lordship,
You
para 3 of the division bench already deals with it.
You produce the same.
Please.
Number 8. Chandrasetti.
AGA. Madam, compliance. We pass over, madam. Nikananda is not there. ಬಂದಿಲ್ವಾ ನಿತ್ಯಾನಂದ ಇವತ್ತು? State Council is you only. There can't be anybody else.
That's true.
Nityananda was handling this matter. ಬಂದಿಲ್ವಾ ಇವತ್ತು? And AGA seeks fund is granted 3 more weeks to comply with the orders dated 8/2/2023. Released on 29/5 at 2:30 p.m. This is the same matter that you had appeared here and we had given direction.
Sir, our Kata is in my name. E Kata Madadaki. Citizens are virtually.
Now you are finding something else.
Permission of the court, my lord, I am representing the Devaraj, my lord. My lord, under the my lord, Town and Country Planning Act, and it requires, my lord, the prior approval from the town urban development authority. And apart from that, under budget and account rules of the Panchayat Raj Act frame, because for this reason, my lord, it has got a cascading effect on other, my lord, the panchayats. That's the reason I'm seeking your lordship's, my lord.
Please tell us, can you force a person to develop his property by taking a development plan? And in that development plan, you will put a condition that if you don't develop it within 2 years, it will lapse. He doesn't want to develop it. He only wants a kata.
That's the reason your lordship will place.
They will always take that permission. Even if that amendment has happened, that amendment is standing in
Single plot also, my lord. It's a defined single plot as well as the development. It's also defined under my lord.
Section itself, section 17.
ಅದು ಆವಾಗಿಲ್ಲ.
ಇಲ್ವಾ?
2022 amendment.
I'll pass.
Adರಲ್ಲಿ, my lord, what has happened is, if there is a development plan that I'm thinking, please have a look at section 17.
Intends to develop a single plot.
Intending to develop. Kata is already there in my name.
Even if the definition of the lordship may not be the development. I see. It is grammatical, my lord, variation means the carrying out a building, engineering, mining or other operation or over under a land or making any of the material change in any building or land. Not includes my lord land. Or in the use of any building or land, it includes subdivision of any land. It's a Ekaniveshana. Then your lordship may kindly go to my lord.
Again, development again in terms of 1C. What is the development that he is saying is going to happen or has happened or is going to happen?
That's for a commercial purpose and carried on.
Commercial purpose is the
conversion. Not
conversion.
Conversion is already made long back.
You can convert the land and keep it for 20 years without developing. Is it required to be developed now?
That's further, your lordship, my lord. Section 17, subsection 2E, your lordship, for a moment.
Yes.
2E.
2E.
Please, man. Any building site which has not been released by the planning authority under this act shall not be issued any kata or given property index number under the Karnataka Municipalities Act and the Karnataka Municipal Corporation Act, the Karnataka Gram Swaraj and Panchayat Raj Act.
Any building site.
Please, my lord.
Not
Panchayat
planning authority. Release ಎಲ್ಲಿ ಬರುತ್ತೆ? Release comes in when you come under 2A.
Please, my lord. Now you are
plan ಮಾಡಿದ್ಮೇಲೆ you have to after all.
They are ground by not there. They are ground by my lord the budget and accounts rules framed under the Panchayat Raj Act.
where my lord form number 9 and 11 issued under this rules, your lordship, my lord. Budget and budget and account rules. That's the reason, my lord, I will file a detailed objection if lordship account come with all, my lord, the materials and the law which is governs the.
Just told you, it was only a magnanimous which we have issued.
Please, my lord.
Now they have issued the endorsement.
My lord, please have
The challenge.
subject to my being corrected by your lord. Khata is already there in my name, my lord. Conversion was in the year 2000.
This matter is already disposed, only to report compliance. Now
Yes,
that report
that's right.
is
That is true, my lord.
right or wrong, put that in.
Very well.
Do you do one thing, you file your objection, then they'll.
Right.
When will you file?
My lord, 1 week, your lord.
So that they can treat your contentions. The name contentions are.
I don't know.
Because of
17 my lord, I'll be trigger. 17 on the building.
Defies.
Meanwhile, let my lord, the learned senior counsel question, my lord, the endorsement which you have
The
issued.
objections act
Please.
defies logic and it.
Please, my lord, we will file along with the objection. Please, my lord.
Allah, endorsement, Allah, I'll file a contempt. It's a case of contempt. All right. Limit, my lord, to which harassment of the citizens. That's all I can
You
say.
can't do like this. You are forcing a person to take up development of the property because of your budget rules. Because you want money. Is that what your submission, Mr. Nandari?
Require, my lord, the prior approval as for the latest.
Is that your submission? Because
Budget
you want
and-
money, you want people to do all these things. If that is your submission, then God help our country. Can't do this. You are forcing a person to go into a development.
That's not, my lord, where it is in, my lord, in and around Bangalore, your lordship, my lord.
Wherever it may be.
So, your lordship, my lord, I'll come with all, my lord.
We are not concerned with the value of the property, extent of the property, who owns the property. We are not looking at any of that. We are only looking at what the legal proposition.
Please, my lord.
If the legal proposition is that he is not developing a property, you cannot force a person to avail of a development plan. He is entitled to keep it for 100 years. Let my grandchildren use it antanu irbodu. He is entitled to grow mango plants or mango season, mango plants. Entitled to anything in that land, as long as there is no development. It is his land. Why are you forcing a person to do this and pay you money? Is this not extortion? Very simply put, legal extortion.
ಇಲ್ಲ ಮತ್ತೆ ಹೇಳಲ್ಲ ಅಷ್ಟೇ ಐ ಲೀವ್ ಇಟ್ ಅಟ್ ದಟ್ ಒನ್
ಇದು ಲೀಗಲ್ ಅಷ್ಟೇ ಹೇಳಕ್ಕಾಗತ್ತೆ ನಾವು.
I'll file a detailed application.
There seems to be a lot more. You are taking a big risk. You may change your mind and say inquiry to be ordered.
Yes, I will find, my lord. Just I'll go through, my lord. Just grandparent told me in the afternoon. Just I'll find out, my lord.
ಅವ್ರಿಗೂ ಗೊತ್ತು ನೀವೇನು ಹೇಳೋದು ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲದೆ ಇರೋದ. The MS Devraj seeks for and is granted a week's time. Relist on 18.
18. Great.
Yes, Mr. Krishna.
My lord, the PDS concern, my annexure C is the.
Again, everybody keeps on blaming BDN.
No, my lord.
Corporation is blaming.
No, if it is this is a private layout, my lord. Once we have released the site, my lord, there is no need to give the NOC.
Why don't you educate BBMP?
No, my lord, I inquired with him. If it is BDA layout, my lord, then we have to give the first kata, then they have to apply for the BBMP. This is the private layout, my lord. We are only approved, and thereafter the annexure C, my lord, sites are all released from the
ಅದ್ರಲ್ಲಿ ಅದು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ. ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಅಲ್ಲಿ where Mr. Krishna was invited, where we had released the sites and you are not transferring the data. Now here,
Their computer generated endorsement is issued that NOC is required. Now things are clarified that we won't ask for NOC. I instructed the concerned officer also. But one point I would like to say also, the application is given by one Manoj Janardhan, whereas the petition is filed by BK Manjunath. So the khata is the name of Primus Life Private Limited.
the representative, anybody can
The
represent.
authorization should also be there.
And authorization will be there.
And the one thing,
We cannot say Pawan Kumar is there and Mr. Reddy cannot appear for BBMP and Telecast.
one point is, second, the layout plans is not legible. Let them file a layout plan fresh
Copy that.
and let them apply because the earlier application is rejected. So we cannot process the same application online. Let them give a one new application and we will.
Due to your mistake.
So,
Why should people come to court for this? Mr. Olivia?
but by the system, because the system thing, we cannot process on the same application. That is the only problem.
Look at the psychological impact. You'll have to look at.
Yes, I understand. Because
Ashok ಅವರು is ಏನು ಹೇಳಲ್ಲ ಅವರು. But a person, if he gets deprived of this, what all will go in his mind?
I understand that point of view. But
He's losing out the right to use his own property.
once they apply.
And you blame it on computer. The petitioner is before this court seeking for the following relief. The grievance of the petitioner is that despite the petitioner being the owner of the property bearing survey number 56/2, old survey number 7/7, measuring 1 acre 25 acres, which had been converted for residential use. The said property having come into a layout having been formed on the said property after taking due approval from the BDA. And the property coming within the territorial jurisdiction of BBMP. The BBMP has rejected an application for making out katas in respect of the opposite land on the ground that the NOC from the BDA has not been enclosed along with the application. It is in that background that the Bangalore Development Authority was made a party to these proceedings. Shri K. Krishna, learned counsel for respondent number 3, Bangalore Development Authority submits that what has been sanctioned by the BDA is a private layout. And once a private layout is sanctioned by the BDA
Sites are released.
and sites are formed,
Sites are released. Sites are released from the BD.
sites are formed, comma, the other civic amenities, the civic amenities provided in the layout, the BDA would release the sites in favor of the developer. And it is for the developer to approach the jurisdictional municipal corporation. In this case, for number 2, to seek for issuance of kata in respect of the individual site. He submits that it is only when a layout is formed by the BDA by itself, the BDA issues kata in respect of the sites formed by the BDA. In respect of a private layout, the BDA does not issue any kata. This submission is placed on record.
Annexure C, Miller sites are all, there is a order by the BDA, their sites are all released.
ಇವಾಗ ನೀವೇನ್ ಹೇಳ್ತೀರಾ?
And
Shri Pawan Kumar, learned counsel for respondent number 1 and 2, submit that taking into consideration the submission of Shri K. Krishna, learned counsel for the BDA submit that the BBMP will process the application submitted by the petitioner.
new application. New application.
Provided a new application.
We will not reject on this.
Provided a new application is submitted by the petitioner, since the earlier application has already been rejected and the computer system does not allow the rejected application to be reconsidered by the BBMP. The entire issue having arisen on account of a computer-generated rejection order, it is required of the BBMP to rectify the software to take into consideration the actual applicable law and not reject the application filed by a citizen for reasons not provided under law. The rejection in the present case being on account of NOC from the BDA not being enclosed with the application, the same is not sustainable in as much as it's a private layout. The BDA, by way of its order dated 24/5/2022 of Annexure C, has released the sites in favor of the developer after taking into consideration the due compliance with the conditions of the layout, condition imposed while sanctioning the layout plan. This aspect is required to be incorporated into the software of the BBMP while considering an application for CATA submitted by a developer or a site owner of a private layout. In view of the above, I pass the following order. A certiorari, writ petition is allowed, a certiorari is issued. The endorsement dated online endorsement dated 4/3/2023 at Annexure E is hereby quashed. The respondent number 2 is directed to the petitioner is directed to submit a fresh application.
The fresh application again process takes, and now the code of conduct also is being.
Code of conduct was again submitted.
Officers.
Now,
My lord, I don't mind, of course, submitting. It's not a big thing. But
the software doesn't allow it. Then until they rectify the software, we will be issuing direction for rectification. But until then, you are stuck. ಅದಕ್ಕೆ ಬದಲು application ಹಾಕಿದ್ರೆ ಒಳ್ಳೆಯದಲ್ಲ.
My lord may fix some time.
We are fixed time. When will you file?
When ಮಾಡ್ತೀರಾ? Within a week, my lord. Within 2-3 days, we'll file it. But my lord may say
Counsel, the petitioner is directed to file a fresh application, relevant documents within a week from today, which shall be considered by respondent number 2 within a period of 3 weeks thereafter. 4 weeks thereafter. Though the above petition is disposed, relist on 29/5 at 2:30 p.m. for reporting compliance with the rectification of the software in view of the above observations.
Great.
If you rectify it, everything will get sorted.
Serial number 67. CH-18. None appear.
None appears for the petitioner today also. It appears that the petitioner is not interested in prosecuting the matter. The petition is dismissed for non-prosecution.
Serial number 68. Prabhu Gaud Kumbigi. Batalis.
None appears for the petitioner. Relist on 2/6. Raju.
My lord, I appear for the respondent. Lord, it is like there was a direction to serve copies, my lord. It is not served. There are 3 directions, my lord.
None of.
29/11/2021, I was directed to take notice. After that, my lord, there are 2 orders on 26/8/22 and 23/2/23.
None appears also. The perusal of the that has been appearing. None appears. Rule of the order. No, none has been. Last. Last several. Copies of the petition also not been. It appears that petition.
Obliged.
Yeah,
70. None appears for the petitioner. We list on 2226.
71. Yeah, Ligaraju.
Same order.
72. Ashok GG. Petition.
In this case, from a nationalized bank, I had purchased the property from respondent number 4. The sale deed was executed and registered in the year 1998. Ever since then, I have also been paying property taxes on time, my lord. The sale deed is available in Annexure A. The property tax receipts have been produced as Annexure C and D, my lord. The fact that sale deed has been executed in my favor, the fact that I have title over the property is not in dispute. Sale deed has not been challenged or cancelled either. Subsequently, my lord, with the intention of building training colleges, I had filed an application for CATA. This was filed in the year 2015. But despite sending reminders, because we did not hear from the respondents, we filed a petition, my lord. In the statement of objections that has been filed by respondent number 1 to 3, they have contended that there were 2 endorsements that were issued by the respondents in the year 2013 and 15. These endorsements were neither served on us, and we believe that these documents have been concocted, my lord, which becomes evident on perusal of the documents itself. This is an annexure R2, R6, and R3, my lord.
You should have challenged them.
My lord, these were never served on us to begin with. We got to know about these endorsements only after statement of objection.
On that ground itself, you should challenge them. And what you ask for is mandamus.
No, my lord,
They have produced some documents. If you don't challenge them.
Kindly see R2.
Yes.
Annexure R2 has been filed along with statement of objection.
Additional objection.
The main statement of objection. Page number 9.
Yes.
This is the first endorsement that was issued on, that was alleged to be issued on 13/11/2030. Now, along with the additional statement of objection, R6 has been produced by the respondent, claiming that R6 is also a repetition of R2. R6 is additional statement of objection, and in page number 5. Kindly see the 2 documents below.
R6 with additional statement.
Yes, my lord.
Starts with R8.
R6 along with additional statement of objections in page number 5. R5 and R6 have been produced together.
How many additional statements are
There were
2
three statement of objections included. And this has been produced after we took the contention that endorsements were never served on it. We cannot have it.
Now they have issued these endorsements, you should challenge them.
Kindly see, my lord. I will explain how
It may be a wrong endorsement, we may be with you, but you should challenge. Unless this endorsement is set aside, can that direction be issued?
If this honorable court may just see the 2 documents, I'll explain as to how these were never passed, these orders were never passed.
May be bad in law, it may not have been said, but should not be challenged that endorsement is there. File the amendment, challenge it, and take the order completely, otherwise they'll issue the same endorsement.
My lord, my problem is
Don't go back, just file amendment application here, challenging it. It's not sustainable, but they'll have to challenge it.
I'll only take instructions from my client to that regard, my lord.
Challenge madam, you will have to issue it. How can you say?
Part of the problem, challenge the government proceedings, my lordship. It was held in the year 2007, whereby the government restricted us not to issue khatas in favor of the petitioner, my lord, because the HMT, the earlier owner, was having dues around crores that was not paid. So in a meeting held in the,
You take action. You're not taking action from when?
but that order is coming in our way. We cannot issue khatas to them unless they challenge that order. And other organizations have.
If you have any claim, you ask for that money. Ask for recovery of the money, not restraining the khata.
But I understood my lawyer.
We'll have to use some other word there, which is won't be proper. The government should not be doing that.
Because what has happened is the total 23 applications were given to be for change of khata. 19 applications, the khata was given. But it was prior to the order dated 3/12/2007, before the proceedings. Because of that proceedings,
Let them challenge that.
If I may, the 2007 proceedings that they're referring to.
Madam, challenge.
The
Only we can give you.
That's the instruction.
Otherwise, it's only a mandamus right now, which won't help. Counsel for the petitioner seeks for and is granted 3 weeks time, relist on 30th May.
73, Adjourn 74, Kalyan R.
The petitioner is about Elmangla. You appear for respond number 4?
Respond number 1, my lord.
Respond number 1. Who appears for Mr. Pradeep?
74. 74.
Respond number 4.
File.
Yes.
The petitioner is allowed there. Elmangla municipality. Challenge the order passed by the deputy commissioner in the state commission. But the dispute is in respect of a site. Not classified as reserved for parks. Municipality records. This property site was part of my lord survey number 146/282. Wherein one TR Muttaya had formed a layout in this property. A portion of one site was my lord reserved as park and which are
in the layout plan.
In the layout plan. Though my lord, I have produced layout plan. My lord, subsequently, as per the directions of this honorable court, I was directed to verify and state whether the approved plan is available with the planning authority. My lord, subsequently, my lord, affidavit is filed. My lord, I have verified. But the planning authority copy is not available with me. But the Xerox copy which I have produced along with it. But in the records, my lord.
Where is the photocopy?
My lord, photograph, my lord's annexure G. Page number 38.
What is your site number?
My lord, site number is 3284/663. My lord, which is shown on the right side, my lord, the corner, park antane barte.
3284 ಇಲ್ವೇ ಇಲ್ಲ.
ಅಲ್ಲ ಪಾರ್ಕ್ ಅಂತ ತೋರಿಸಿರೋದು 32. ಪಾರ್ಕ್ ಅಂತ ಬರ್ದಿರೋದು. That's very problem. Otherwise, I am not a private party. It is a municipality interest. Municipality claiming that, my lord, this property was reserved as, my lord, even in the field executed by the personal landowner towards, my lord, southern side of their property site, shown as park.
Yes.
Land reserved for park. Now, my lord, by taking undue advantage, my lord, of these things, my lord, T.R. Muttaya, who formed the layout, he executes a sale deed in the name of his my lord daughter-in-law. The respondent number here. Annexure M, my lord, page 54, the schedule.
Page
54.
Yes.
Last line, my lord, पूर्व के पार्टी के बिटिरवा काली जाट.
Is it sale deed in favor of?
My lord, sale deed in favor of Narayanappa, K. Narayanappa.
And site number?
Site number.
3282.
3282.
26 7-1.
An orientation in the and north is above. Orientation after.
3282 park pakkadalle.
Yes.
And one more side is my lord annexure. Lord, page number 59. Annexure.
3281 now.
This is the page.
3281. Yes.
Annexure N, for sale date of year 1988. Executed by T.R. Muttaya. Relevant portion, my lord, page 52.
62.
62.
3281.
Please. And here in this, my lord, what to check upon the Purva ke Udyanavana shown as a park. My lord, this layout was, my lord, formed in the year 1982.
The relinquishment deed been
relinquishment deed is found. There is no such a document.
This was sanctioned by the planning authority.
Planning.
Thereafter, it is transferred to you.
Thereafter, my lord, in the revenue entries, my lord, in Aadhaar, name of my lord municipalities. But my lord, in collusion with some of the officials, as a layman for a Guerrero, and thereafter, my lord, the respondent, the father-in-law of respondent number 1, approaches the civil court, files a suit not against the municipality, against some association. That association was claiming that, my lord, this particular site which was reserved for park was given to them. Therefore, my lord, T.R. Muttaya filed a suit for bare injunction. And that declaration and injunction. That was decreed, my lord, in favor of T.R. Muttaya. In that suit, my lord, the municipality was not a part. They did not make my lord municipality as a part.
What did you do after that? Did you challenge the decree?
My lord, we did not challenge the decree. Since declaration. So, my lord,
we against that.
I was not a party, therefore the decree would not be binding on the municipality.
The declaration was filed against the society.
Society, my lord, which, my lord, the respondent has produced along with, my lord, the statement of
Election R1.
Dr. Rajkumar Abhimanigala Sangham, independent.
They did not contest.
They did not. There was a proposal from the municipality to award this particular site in favor of this Rajkumar Abhimanigala. The deputy commissioner in turn wrote a letter, my lord, to the municipality saying that reserve, this is a park area, you can't allot it to a Sangha, therefore preserve it as park. Subsequently, it was not allotted to anyone, my lord, it is in the, even till today, my lord, it is in the possession of municipality. My lord, T.R. Muttaya, what is does, after subsequent to this suit, my lord, he executes a sale deed in the name of his daughter-in-law. Daughter-in-law. And thereafter, my lord, an application was submitted for change of khata. Endorsement came to be issued. That was challenged before the Assistant Commissioner. Assistant Commissioner, my lord, relying upon this judgment and held that, my lord, the municipality cannot now come and contest since there is already a declaration decree declared by granted by the civil court. Against which, my lord, an appeal was filed before the Deputy Commissioner. Deputy Commissioner also confirmed the order, my lord. Thereafter, my lord, in the meanwhile, after disposal of the order passed by the AC and Deputy Commissioner, my lord, the respondent number 1 had approached this honorable court seeking writ of mandamus to change the khata. My lord, thereafter, the direction was issued. During pendency of the writ petition, contempt petition was filed. Thereafter, my lord, the municipality had filed writ appeal. The writ appeal, my lord, the order passed by the learned single judge was set aside, holding that, my lord, subject to the result of this present writ. In the meanwhile, my lord, this writ petition was also filed challenging the order passed by the AC and Deputy Commissioner. An interim order was granted in this. Taking in, my lord, noting this, my lord, there is an interim order in this case. Therefore, my lord, writ appeal came to be disposed, and even the contempt proceedings were also closed. Now the question would be, my lord, the mere obtaining a decree in a civil proceedings, my lord, where the municipality was not a party.
First, we'll have to see the layout plan. Yes.
So far as earlier proceedings are concerned, my lord, but there was a
appearing
directive from Honorable Court.
You are appearing for the first respondent.
First respondent.
So your father got the layout plan.
I have purchased this property from the original owner. Of course, relationship is there, my lord. That apart, the original owner is Muttaya. Of course, he happens to be my father-in-law. Yes.
Your father-in-law formed the layout.
Yes, my lord.
Where is the layout plan according to you?
But the layout plan is not available with me, my lord. It is not handed over to me.
You'll have to accept what what he has produced.
No, my lord, it is, the sale deed has been executed by the owner of the property, my lord. I purchased it under a registered sale deed, my lord.
Where is the layout plan where 3284 site number has been formed?
But so for us, layout plan, it is for the municipality who is the
Mr.
custodian of
Kalyan has produced this. Mr. Kalyan has produced
documents. And
Mr. Kalyan has produced the layout plan sanction.
no, he has not produced.
This is that
Even before the authorities, he did not produce. That is
Annexure
not.
G there. What is Annexure G?
Annexure G is only a Xerox copy, my lord. Original is not produced, my lord. At no point of time.
That should be with you because you got it from your father-in-law. You should have produced something.
No, my lord, he is not alive now. He is dead. Even before the authorities, original power, this layout plan was not produced. No documents were produced to show that this particular property is part of the parkland.
If you don't have a plan sanction, then you don't have any right. Without a plan sanction, determining the existence of
municipality, it is the municipality who is asserting that it is a park area.
You are claiming under.
No, earlier to sale in my favor.
Please.
Yes, I'm sorry.
You are claiming that your father-in-law formed a layout.
No, my lord.
In your sale deed.
Yes, no, Mr. T.R. Muttaya, the original owner, formed the layout. Of course, I purchased the property from him, from one of the sites formed by him.
Yes.
And before selling the property in my favor, the khata stood in the name of Muttaya since 1995. And I purchased this property in 2004.
There is no dispute about your father-in-law being the owner of the survey number.
Yes, my lord.
Dispute is that there is a layout sanction which he has taken. It does not have 3284 site number.
No, it was a converted land, my lord.
Converted as no plan sanction bekala.
No.
Bedwa, layout plan bedwa.
Layout plan, Takondu, it is the society, it is the municipality who is having the layout plan, my lord. We also tried to get it. We made an application before the planning. We made an application to the municipality, give the plan. Then they directed me to go to the BMRDA. Then we went to the BMRDA. BMRDA said we don't have any plan. And again, BMRD asked me to go to the Nelamangala Development Authority. We went there. We made an application for copy of the layout plan. They also said we don't have a copy. We don't have the layout plan. Same exercise has been done by the municipality. So at that juncture only, this honorable court may pass an order on the previous occasion, directing the municipality to produce the original layout plan. Then they filed an affidavit before this honorable court on that is 16 to 2023 million. This is the affidavit filed by them. When there was a specific direction to the direction by this honorable court to produce the layout plan to the municipality.
But now, when there are two sale deeds which have been executed.
Yes, sir.
As regards 3281 and 3282, showing that the eastern portion is by a park.
That is, they are different. They are those sites are away from my land, my lord. They have nothing to do with my property.
Where is your site? How do we identify where your site is?
The site is there, my lord.
Where is the location of it?
Location according to the I produced the sale deed also, my lord, along with my statement of objection.
What is the
Statement of objections? I produced an annexer. Annexer R2, my lord.
Yes. ಪೂರ್ವಕ್ಕೆ ನನ್ನ ಉಳಿದ ಭಾಗ.
And annexer R2, my lord. Property. Bengaluru Graman. I'm only reading schedule, my lord. Swattina Vivara. Bengaluru Gramantara Jille, Nelamangala Taluk, Kasaba Hobadi, Nelamangala Taluk, 35 ಗುಂಟೆ ಜಮೀನು ನಾನು ವಾಸದ ಉದ್ದೇಶಕ್ಕಾಗಿ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳಿಂದ 12/6/89 ಮೂಲಕ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿಸಿ ಪ್ಲಾನ್ ಪ್ರಕಾರ ವಿಂಗಡಿಸಿರುವ ಸೈಟುಗಳ ಪೈಕಿ ನಿಮಗೆ ಕ್ರಯಕ್ಕೆ ಕೊಡುತ್ತಿರುವ ನನ್ನ ಖಾತೆಯಾಗಿ ನನ್ನ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿರುವ ಟೌನ್ ಪಟ್ಟಣ ಪಂಚಾಯಿತಿ ಕಾನೇಶ್ಮಾರಿ ನಂಬರ್ ಗಿವನ್ ಬೈ ದೆಮ್ ಟೌನ್ ಪಂಚಾಯಿತಿ ಕಾನೇಶ್ಮಾರಿ ನಂಬರ್ 3284/A 2633/A 3200 ಅಳತೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 50 ಅಡಿ ಉತ್ತರ ದಕ್ಷಿಣ 27 ಅಡಿ ವಸ್ತು ವಿಸ್ತೀರ್ಣ 1300. This is the number given by the municipality. Khata has been made in favor of my vendor and I looked into those documents and purchased it.
Let us see the schedule. Let us see the boundaries.
Boundaries. ಪೂರ್ವಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಭಾಗ, ಪಶ್ಚಿಮಕ್ಕೆ ನಾರಾಯಣಪ್ಪನವರ ಸೊತ್ತು, ಉತ್ತರಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಭಾಗ, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ.
How do we identify this property?
By going to the spot, it can be identified, my lord.
So that is now to the east of 3281 and 3282. Your property is to the east of 3281, 82 na Ilwa.
No, ಪೂರ್ವಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಜಾಗ.
Andre ನಿಮ್ಮ ಪ್ರಕಾರ you are willing
It is the land belong to Muttaya.
So you are willing to make a statement that you are not to the east of site number 3281 and 3282.
ನನ್ನ ಉಳಿಕೆ ಜಾಗ ಅಂತ ಇದೆ ಸರ್.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಕೇಳ್ತಾರೆ. Are you willing to make a statement that your property is not to the east of site number 3281 and 3282?
I'll have to verify and make a submission.
Make that statement. Mr. Kalyan would be very happy with that statement.
I will verify and
ನಿಮ್ಮ ಈ ಪ್ರಾಪರ್ಟಿ ಆದ್ಮೇಲೆ ಉಳಿಕೆ ಏನಿಲ್ಲ, ರೋಡ್ ಇದೆ ಈಸ್ಟ್ಗೆ.
ಉಳಿಕೆ ಜಮೀನು ಅಂತ ಹೇಳಿದ್ದಾರೆ. Because total acre is 35 guntas.
Land ಪ್ರಕಾರ after this property on the east is a road.
ದಕ್ಷಿಣಕ್ಕೆ ರೋಡ್ ಇದೆ.
ದಕ್ಷಿಣಕ್ಕೂ ಇದೆ.
ಅಲ್ಲ, ಪೂರ್ವಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಭಾಗ, ಪಶ್ಚಿಮಕ್ಕೆ ನಾರಾಯಣಪ್ಪನವರ ಸೊತ್ತು, ಉತ್ತರಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಜಾಗ ಮತ್ತು ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ. ಈ ಮಧ್ಯವರ ಸೈಟ್ ನಿಮಗೆ
ನಾರಾಯಣಪ್ಪನ ಸೊತ್ತು. Where those sale deeds that
annexure M and N.
Is one of them Narayanappa's property sale deed? KN Narayanappa, page 51. 3282.
Narayanappa, annexer M Miller.
Annexure M, page 51K, Narayanappa. ಪೂರ್ವಕ್ಕೆ ಇರೋದು ಉದ್ಯಾನವನ.
ಶೆಡ್ಯೂಲ್ ತಪ್ಪಿಸಿಲು.
ಅದನ್ನೆಲ್ಲ want to usurp the
ಟೋಟಲಿ 2 ಸೈಟ್ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ ಸಮಯದಲ್ಲಿ. ನೆಲಮಂಗಲ ಟೋನ್ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಖಾತೆ ಇದ್ದು ನನ್ನ ಸ್ವಾಧೀನಾನುಭವದಲ್ಲಿ ಮುನ್ಸಿಪಲ್ ಕಾನ್ವೇಶ್ವರಿ ನಂಬರ್ 3282/1, 2663/11-1.
2663 is the Kaneshwari number, site number 3282.
ಪೂರ್ವ ಪಶ್ಚಿಮ 915 ಮೀಟರ್ ಸೈಟ್ 1. ಅದೇ ಮತ್ತೆ ಎರಡನೇ ಸೈಟ್ ಡಿಟೋ ನೆಲಮಂಗಲ ಕಾನ್ವೇಶ್ವರಿ ನಂಬರ್ 3382/2, 26 ಪೂರ್ವ ಪಶ್ಚಿಮ ಮತ್ತು ಉತ್ತರ ದಕ್ಷಿಣ 3.5.95 ಮೀಟರ್ ಸೈಟ್ 1. ಒಟ್ಟು ಜುಮ್ಲಾ 2 ಐಟಮ್ ಸ್ವತ್ತುಗಳನ್ನು ಪೂರ್ವ ಪಶ್ಚಿಮ 30 ಅಡಿ, ಉತ್ತರ ದಕ್ಷಿಣ 40 ಅಡಿ ಉಳ್ಳ ಸೈಟಿಗೆ ಚೆಕ್ಕು ಬಂದಿ ಪೂರ್ವಕ್ಕೆ ಪಾರ್ಕಿಗೆ ಬಿಟ್ಟಿರುವ ಜಾಗ. ಪಶ್ಚಿಮ ಭಾಗಕ್ಕೆ ಬೇಗೂರು ನಟರಾಜುರವರ ಸೈಟು, ಉತ್ತರಕ್ಕೆ TR ಮುತ್ತಯ್ಯನವರಿಗೆ 30ನವರ ಸೈಟು, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ. ಈ ಮಧ್ಯೆ ಇರುವ ಸ್ವತ್ತುಗಳೆರಡನ್ನು 2 ಸ್ವತ್ತುಗಳು ಮಾಡ್ತಾರೆ.
ಪಶ್ಚಿಮಕ್ಕೆ ಉದ್ಯಾನವನ
ಇಲ್ಲ, ಪಶ್ಚಿಮಕ್ಕೆ ಬೇಗೂರು ನಟರಾಜುರವರ ಸೈಟ್.
ಪೂರ್ವಕ್ಕೆ ಸರಿ, ಪೂರ್ವಕ್ಕೆ ಉದ್ಯಾನವನ,
ಪೂರ್ವಕ್ಕೆ ಪಾರ್ಕಿಗೆ ಬಿಟ್ಟಿರುವ ಜಮೀನು. ಸೊ ನಮ್ಮ ತಗೊಂಡ್ರೆ ನಮ್ಮ ಪೂರ್ವಕ್ಕೆ ನಾರಾಯಣಪ್ಪ ಇದ್ದಾರೆ. ಇವರ ಪೂರ್ವಕ್ಕೆ ಅಂದ್ರೆ ನಾವು ಪಶ್ಚಿಮಕ್ಕೆ ಇರ್ಬೇಕಾಗ್ತದೆ. ಅದ್ರಲ್ಲಿ ನಮ್ಮ ಪೂರ್ವಕ್ಕೆ ಅವರಿದ್ದಾರೆ.
ನಿಮ್ಮ ಪೂರ್ವಕ್ಕೆ ನಿಮ್ಮ ಸೇರಿರಲ್ಲ. ಪಶ್ಚಿಮಕ್ಕೆ ನಾರಾಯಣಪ್ಪನವರ ಸೊತ್ತು, page 34. He could not have been on his Purva, and he could not have been in your Pashchima.
ಪೂರ್ವಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಜಾಗ, ಪಶ್ಚಿಮಕ್ಕೆ ನನ್ನ ನಾರಾಯಣಪ್ಪನವರ ಸೊತ್ತು, ಉತ್ತರಕ್ಕೆ ನನ್ನ ಉಳಿಕೆ ಜಾಗ.
ಸೊ ನಾರಾಯಣಪ್ಪಕ್ಕೆ ಪೂರ್ವಕ್ಕೆ ಪೂರ್ವಕ್ಕೆ ಇರೋದು ಪಾರ್ಕ್ಗೆ. There appears to be a fraudulent transaction to usurp the park area, that's all.
ಟೋಟಲಿ 35 ಗುಂಟೆ ಇದೆ, ಅದರಲ್ಲಿ ಲೈಟ್ ಸೈಟ್ಗಳು ಮಾರಿ. ಪ್ಲಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದರೆ ಇಟ್ ವಿಲ್ ಬಿ ಕ್ಲಿಯರ್.
Your plan illa and we'll have to look at these sale deeds. We'll look at your sale deeds.
Then I will, as you were last, I will look at this matter and make a submission.
You will file an affidavit saying that you are not to the east of Narayanappa's property, 3281 and 3282.
And make a submission.
If you say that, then Mr. Kalyan would be happy with that, and you will have to find your property. Schedules examine.
Plan produce ಮಾಡಿದ್ರೆ ಇವೆಲ್ಲ ತಾಪತ್ರ ಇರ್ತಿರಲಿಲ್ಲ.
ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕು. You are the one claiming it.
No, now on the basis of the sale deed, I applied for change of kata. If there is any dispute with regard to the ownership of the property, the civil court has decided that this particular site belongs to.
Municipality was not a party. You file against somebody else. That's not binding on them. That could not have been.
They claimed that this site is allotted to them. Therefore, in that context, that suit was filed.
We'll set it aside, remand it back to consider it without reference to the decree passed in the suit, where it will have to be determined. Petitioner is before this court seeking for the following reliefs. One, Muttaya.
ಹಾಗಾದ್ರೆ ಇದು AC ಮತ್ತು DC ಅವರ ಆರ್ಡರ್ಗಳಾಗಿದೆ. Then ಮುನ್ಸಿಪಾಲಿಟಿ, ನಾನು ಒಂದೇ ನಿಮಿಷ ತಗೊಳ್ತೀನಿ, ತಮ್ಮ ಜಾಸ್ತಿ ತೆಗೆದುಕೊಳ್ಳೋದಿಲ್ಲ. ಮುನ್ಸಿಪಾಲಿಟಿ ರಿಜೆಕ್ಟೆಡ್ issued an endorsement rejecting my application representation for change of kata. Then they preferred a revision petition before the Assistant Commissioner. He rejected that. Then he approached the Deputy Commissioner. Thereafter, he has approached the Honorable. Then representation made by me, if your lordships are remanding again to the AC, he has to look into this matter.
Yes, okay.
Yes, that is the original authority.
Yes. Was the owner of the land covered under survey number 156/2A, measuring about 35 inches. Mr. Mutaya is supposed to have obtained a plan sanction for a layout, and thereafter marketed various sites and sold it to third. In the present matter, the site in question is site number 3284-A, stroke 2633-A, which is claimed to be owned by respondent number 1, having purchased the same and a sale deed from Mr. Mutaya. The petitioner, Nelmangala City Municipal Council, who is a successor to the Town Municipal Council Nelmangala, claims that the said area has been reserved for parks and open spaces, and as such, it is the municipal council who is entitled to make use of the said property. An application being filed for transfer of kata by the first respondent to the petitioner having rejected it, an appeal came to be filed before the Assistant Commissioner, who allowed the same and directed the issuance of kata, which was challenged by the petitioner before the Deputy Commissioner, who rejected the said challenge, and it is in that background that the petitioner is before this court. The contention of Sri Kalyan R, the counsel for the petitioner, is that both the Assistant Commissioner and the Deputy Commissioner have not considered the matter in the right perspective, but have taken into consideration the decree passed by the Second Additional Civil Judge Senior Division, Bangalore Rural District, Bangalore, dated 20th October 2003, in OS number 851 of 1996, wherein T.R. Muttaya has been declared as a owner of site bearing Kaneshwari number 3284-A-2633A. And it is on that basis that the direction for issue of kata in favor of respondent number 1 has been issued. His submission is that the said declaration was passed for the defendant therein, namely Dr. Rajkumar Abhiman Sangha, registered, and the municipal council not being a party to the said proceedings, the said decree is not binding on the petitioner. If at all the petitioner had been made a party to the said suit, the petitioner would have placed on record the claim of the petitioner. The Assistant Commissioner and the Deputy Commissioner, not having considered this aspect, have blindly accepted the declaration in OS number 851 of 1996, which is not permissible. And on these grounds, we submit that the said orders is required to be set aside. Per contrast, Sri T.R. Rajeshwarappa, Leonard Counsel appealing for respondent number 1, submit that it is in furtherance of the declaration in favor of T.R. Muttaya in OS number 851 of 1996 that he sold the property to respondent number 1. The fact that the said T.R. Muttaya is the father-in-law of respondent number 1 was only an incidental aspect and has no relevance to the matter. T.R. Muttaya, being the owner of the land, has transferred it to respondent number 1. Thereafter, respondent number 1 is the owner.
Father stood in his name. Father stood in his name since 9.
Owner of the land. The Khata having stood in the name of P.R. Muthaiya. Heard sounds. Various papers. The sole reason given by both the Assistant Commissioner and the Deputy Commissioner to direct the issue of Khata in favor of Respondent number 1 is the decree passed in OS number 851 of 1990. Apart therefrom, there does not appear to be, there is no other reason.
Only they said they did not produce any document to show.
Forthcoming from the said order. A passing reference is made to the town municipal council not having produced any document to establish his right over the property. The right of the town municipal council would have to be considered in respect of plan which is being sanctioned, which plan is being referred to in the sale deeds which have been executed as regards various sites, including site number 3281, 3282, as also in the disputed site 3284.
The disputed site is different number.
3284.
84 bar A.
Bar A.
266.
Hyphen 2633 hyphen A.
2663 bar A ante ಇದೆ.
Site Kaneshwari number 328.
ಕಾನೇಶ್ಮಾರಿ ನಂಬರ್ ಸೇಮ್ ಇದೆ ಸರ್ ಅದು. ಕಾನೇಶ್ಮಾರಿ ನಂಬರ್ ಸೈಟ್ ನಂಬರ್ ಅಂತ ಸೆಪರೇಟ್ ಆಗಿಲ್ಲ
ಅಂತ ಹೇಳ್ತಾ ಇರೋದು. 328.
ಕಾನೇಶ್ಮಾರಿ ನಂಬರ್ ಅದು.
Hyphen 2633 hyphen A. The boundaries relating to various sites have not been properly appreciated by both the Assistant Commissioner and the Deputy Commissioner. Inasmuch as in the sale deeds which have been produced by the petitioner, the sale deeds reflect that on the eastern side, the site number 3281 and 3282 are bounded by a park. Whereas in the sale deed of Respondent number 1, on the western side, the boundaries are shown to be that of the site belonging to Sri K.N. Narayana Park, which is a sale deed produced at Annexure M to the petition. These factual aspects ought to have been properly considered by the Assistant Commissioner and Deputy Commissioner, which have not been so considered. Mere reliance on a judgment in OS number 851 of 96, at which the petitioner is not a party, in my considered opinion, would not be proper. The facts relevant to this matter ought to have been examined. In that view of the matter, I pass the following order. Writ petition is allowed, a certiorari is issued. The order dated 12/2/2014 and so and so passed by Deputy Commissioner at Annexure A, as also the order dated 13/6/2008 and so and so passed by Assistant Commissioner Bulapura, subdivision at Annexure B, are hereby quashed. The matter is remitted to the Assistant Commissioner Bulapura to consider it afresh in light of the observations made above. Yours, the declaratory decree passed in OS number 851 of 1996 within a period of 4 months from the date of receipt of a copy of this order.
Contentions,
All contentions are left.
Also, Assistant Commissioner refers to the writ petition which was filed before this court.
That is only
to consider the representation.
that consider Ashtaji in matter.
Assistant Commissioner refers that in view of the order passed by the Honorable High
No
Court.
direction. We will have to
Consider the representation ಅಂತ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ.
Serial number 75.
For the respondent, not doing. It is relating to 321(3) proceedings.
Yes.
in respect of property number 16/1.
Mohan Kumar, you are appearing for R1 and R2, R3 dismissed, R4. Manian?
He will not be affected in any way if the order is. He is also one of the affected party and he also claim a share in the property in question.
Why you made him a party, Mr.?
He claims to have.
Your husband.
He claims to have purchased.
Is your husband? Husband of petition number 2. Respondent number 3 is the husband.
Respondent number 3 is the husband of petitioner number 2 and father of petitioner number 1.
Yes.
He is the father of petitioner number 1.
And who is respondent number 4?
Respondent number 4 is the claims to have purchased 50% of the property from respondent number 3. Respondent number 3 got the property in 2002 under a gift deed executed by his father. He gifted 50% share in favor of petitioner number 2 in the year 2003. And after gifting 50% share in favor of his wife, there was a dispute between husband and wife.
Let him come. If he doesn't come, we'll take it up. Today also none appears for respondent number 4. If none were, today also none appears for respondent number 4. If none were to appear for respondent number 4 on the next date of hearing, the matter would be taken up for consideration on the basis of submission made by the other counsels. Relist on 2nd June.
As far as respondent number 3 is concerned, by virtue of the earlier order, it stands dismissed.
Yes.
Person who is named the in favor of the Tata is now directed to be transferred. Maybe his presence is required. How do you get? Process was to be paid, it is not paid, another Koskara, it was dismissed. He is the beneficiary.
I came on record later, but Lordship, in this matter,
This file an application for recall.
please.
Counsel for the petitioner seeks for and is granted 2 weeks time. Relist on 2nd June. Without him being on party or on record, your petition will go.
Lordship, the BBM, it is the respondent number 1 who has passed the order.
But he is the affected party, no order can be passed ex parte.
Please,
And it's been dismissed against him.
please, I would take.
Serial number 77, 78, Adjournment, 79. Inutayan.
79.
None
appears for the petitioner today also. If none were to appear for the petitioner on the next date of hearing, petition will be liable to dismiss for non-prosecution released on 2nd June.
Mahesh Aropi.
Open.
None appear.
Same.
81. CH-18.
He is appointed as a respondent corporation after vacation retirement. CH-18 is appointed as a BBMP panel. Yes, ma'am. Vacation.
So, ಬೇರೆ ಯಾರಿಗೆಲ್ಲಾದ್ರೂ ವಕಾಲತ್ ಹಾಕ್ಸ್ತೀರಾ ಏನು?
Recent appointed.
When on behalf of Laurent Counsel for the petitioner, it submitted that the counsel for the petitioner is now on the panel of BBMP and as such would not be able to appear in the matter. And as such, alternate arrangements will be made. Relist on 2nd June.
82. The SN.
None appears for the petition today. Relist on 2nd June.
83 Adjournment, 84. Ballard.
Ballard. Relist on 2nd June.
85 Adjournment, 86. H.C. Shudamu.
Objection by
ಮಾಡ್ಬೇಕಾ?
Yes,
for the petitioner, counsel for respondent number 3. 6 bond is granted 2 weeks time to file a statement of objection. Relist on 2/6.
AG Sridhar.
The request of the counsel for the petitioner released on 2nd June.
Okay. P. Nagaraj and connected matter.
88. E. Nagaraj.
P. Nagaraj.
E. Nagaraj has entered appearance for the petitioner delete Murli BS. Ramanya Gowda is there. Mr. Pawan. So Ramanya Gowda is on the panel. Not on the Shri Pawan Kumar accepts notice for respond number 1 and 2. The registry is type print his name and delete the name of Shri M. N. Ramanya Gowda as that obtained for respond number 1 and 2. Counsel for the petitioner to serve copy of the petition along with annexes on Mr. Pawan Kumar. 88.1. Shri Pawan Kumar accepts notice for responding 1 and 2. Released on 16th June.
89.
Counsel for the petitioner has been designated as senior counsel. Registry is direct delete his name and issue notice, court notice to the petitioner, returnable by 23rd June.
90. R.D. Halesha.
Alesha. The order dated 17/3/2023, none appears for the petitioner today also. Appears that the petition is not implemented.
91.
They appear for the petitioner, my lord.
Mr. Ramesh. Nagarajappa. The counsel for the petitioner is present, none appears for respond number 1 and 2. If none were to appear for respond number 1 and 2 on the next date, matter would be taken up for consideration on the basis of submission made by the counsel for the petition. Released on 16/6.
Much obliged.
92.
Panchayat Elanka, Somyaji, you accept?
I pay for both, first and 1 and 2.
Somyaji, who has entered up his respond number 1, accepts notice for respond number 2 also, registry that print his name as such. Mr. Narayanappa?
No.
Reported that the counsel for the petitioner is no more. Hence, registry is directed to issue court notice to the petitioner, returnable by 26 June.
93.
93. None appears for the petitioner, released on 26 June.
94. Shekhar Shetty.
Shekhar Shetty. None appears, 26.
95. Raghavendra Ravi.
And AGA accepts notice for respond number 1, counsel for the petitioner to serve copy of the petition along with annexes on respond number 1. And learned AGA. None appears for the petitioner, released on 26/6.
96. Jay Kumar K.
96. None appears, released on 26/6.
97.
95.
97. David Prasad Shetty.
I pay for the respondent.
Yes. Video.
Annexure E, F, G, both has to be satisfied.
Pray for the week. Favorably that if time. 97 at the request of Counsel for the petitioner released on 5th June.
98. Yes.
For the petitioner. This is a case of 20 years of lease. Executed by the application of the petitioner. They have initiated proceedings under the Public Nuisance Act. I cited as ruling. Use
Express newspapers.
yes.
Yes.
So in fact, I had handed over the copy of the judgment to my learned friend. Your Lordship directed him to go through it and make submission. Especially para 87 of the
Document where it says that TP and rent control acts will not apply to public premises. From figure 16.
Public premises.
Page 8, my lordship.
To judgment of
2016.
two judge bench. What has been relied upon is a three judge bench.
3 judges. The para 87 is very much clear.
You have to give us a larger bench.
Yes.
We'll have to accept that.
Finally, have it on Monday. But as per me, overruled. It's
Has
fine.
the Express newspaper been considered in this matter?
Para 25.
Not been considered.
Ashok Marketing versus Punjab National Bank. Where
You will have to give us a decision where Express has been considered and overruled. There is
Date may be.
week ಆಗಲ್ಲ.
Monday to start point.
ದಿನ ಪಾಪ ಅವ್ರಿಗೆ ನಮ್ಗೆ ಆನ್ಸರ್ ಮಾಡಿರೋದು ತಪ್ಪ ಹಾಕಿ ರಿಸರ್ಚ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ ಅವ್ರಿಗೆ. That is why we are giving him time. Learned counsel for respondent number 1 and 2 seek for and is granted 2 weeks time, released on 26th May. Vacation on Chennai research.
99 Arjun, number 100.
Scientific use. Not appears for the petitioner, released on 16/6.
The BBMP has also filed its admitting that there is
Narendra Gowda.
I might point out one thing, that BBMP has filed its counter, admitting that there is no such violation.
No such violation.
They don't say it in those words, but they basically, well, the case is that the plot falls in a residential mixed area. The plot is of the dimensions are 369.35 square meters and abuts the road, which is 18 meters wide. So what the BBMP would say in the additional statement of objections, my lord, this was filed on 9th of March 2017. When I read my lord, paragraph. The petitioner scheduled plot size is 369.35 square meters as per the sanction plan obtained from the respondent BBMP during 2008. The scheduled plot falls in residential mixed zone as per zonal regulations, so and so. And so, since the petitioner plot size is 369.35 square meters road, abutting the plot size is 18 meters. It is governed by table 11 and is entitled to use his plot for the auxiliary uses as main use. That is C3I2U4T2. So
you are more than 240 square meters and you are more than
18 square meters, 18 meters roadway.
More than
18 meters roadway.
12 meters.
My road is 18 meters, my lord, so I can use it.
Required to be more than 12 and more than 240.
Yes, yes.
As per table
Have to
7.
use the entire property for the auxiliary use, in this case being ITBT, BPO in a residential mixed, which in my case it does, I am allowed to use it, my lord. In 2017, they issue a notice based on a 2015 notification, which has no retrospective effect as per what the Supreme Court also would say, my lord. in T. Vijayalakshmi versus town planning members, say that as on the date of the sanction plan, it must be considered. Any subsequent notification changing the goalpost may not apply to me. In the counter, there is a new ground saying that no park.
Petitioner is before this court seeking for the following release. Petitioner is aggrieved by the notice dated 17/1/2017 at Annexure A, whereunder the respondent corporation has and the respondent corporation. Oh, this is in furtherance of WP 3676 of 2008. That is that mixed use which was challenged.
Yes, ma'am. So 32622, my lord.
3676 has been mentioned in.
Yes, my lord. The subsequent notification in 2015, and the notice is issued to me in 17.
What happened in 3676 now? So that is where the mixed use was challenged and A was there.
That was in a subsequent matter, my lord, in any case. So what the Supreme Court in the decision that I furnished.
What happened in 3676?
In that there were some directions issued, my lord, which not produced it with this, my lord. I have actually, my lord. Page 172, my lord. Annexure M. But the directions are at page 198.
So this is in personal of this that the 40 feet road this one came about. I mean,
yes, my lord. But in my case, it is an 18-meter road. And as on the date of my sanction plan, this was not in effect. So what Supreme Court would hold is that it must be taken into effect as on the date when the sanction plan was granted.
So 2005 CDP or
2015 revised master plan, my lord, it permits me to carry on I2. I2 is IT BPO. I've produced that as well, my lord. Annexure C.
2017. That has to be under the old 2015 RMP.
2015 RMP, they've issued it. And 2015 RMP, if court were pleased to say page 106, my lord. 106 deals with residential mix.
Why are you invoking Vijayalakshmi?
Say that it has to be dealt with as on the date of the sanction plan. Sanction plan is of 2008, my lord. I've constructed as per sanction plan. At that point in time, it was permitted. Subsequently, they've reduced to 30%. I can use the auxiliary use up to 30% subsequently. 106, my lord. In table 11, above 240 up to 1000.
This residential mixed was challenged before the PIL was filed.
Yes, my lord, in 2012.
What happened to that?
That the order also have produced, my lord. That is it. Page number 155. They were directed to, that was in a different property. They were directed to initiate action as per the KMC Act.
Not this. Citizen Action Forum had filed challenging the mixed use. There was a stay granted. The Russian penalty, you have to show that.
This particular PL, my lord, they were directed to initiate action as per the KMC Act.
That's a complete different matter. The challenge made to the mixed, residential mixed of the RMP.
BBMP has not relied on that in their counter, my lord. They have not raised that aspect.
We are raising. There was a stay granted by the division bench.
I'll verify that.
So the ancillary use for mixed, if it was coming in the mixed, that was stopped. Transformation zone and all were allowed, but not for mixed. But I have to find out what happened to that judgment.
But even in that case, that would be subsequent, that would be a subsequent event. In 2011 itself, I've leased out my property. I've started using
In
it.
the green bench order, we are bound by. You just find out what it is. After arguing, none appears for respond number 1 and 2. Shri Narendra Gowda has entered appearance for respond number 1 and 2. Delete the name of Dr. R. Ramchandran that appearing for respond. None appears for respond 1 and 2. After arguing for some time, Shri Suraj Sampath and counsel for the petitioner seeks for and is granted 2 weeks' time to ascertain the status of the challenge made to residential mixed zone before the division bench of this court. Relist on second.
I am respondents 1 to 3, my lords.
Idaru ille idralla Mr. Jagdish.
Yes.
None appears for the petitioner today also. If none were to appear for the petitioner, administrative hearing, dismissal. Relist on 13th June. The N.R. Jagdishwara has entered appearance for respondents. Delete the
1 to
name
3.
the respond number 1 to 3. Delete the name of Shri Dr. R. Ramchandran as that appearing for R1 to 3.
Fully worker melody. Allotted site melody there, 2000 melody. Site measuring 20 into 30 feet melody. All site melody. Allotment consideration was a piece melody, 20,000 melody. We take the 70% of the site consideration melody. Meaning site consideration melody. 5,000 children ಕಟ್ಟಬೇಕಾಗಿತ್ತು. Poor lady, my lord.
Identical timing or the dimension of the site or the amount which was required to be paid. But the similar matters are pending before the government pursuant to the order of the Honorable Supreme Court. That any order that may be passed in any one of the matters may affect our contention before the government. Wherein the contention was urged that beyond 90 days stipulated under the rules, the authority is not entitled to extend the period of. It was the point urged before the Honorable Supreme Court, and to consider that issue, matters have been remanded to the government. I have produced the Honorable Supreme Court.
Upon one judgment.
R5 page.
All the matters are to be considered by the government.
One judgment.
That is
court melody. Identical circumstances.
ಇಲ್ಲಿ to Mudadu Supreme Court.
ಅದರಲ್ಲಿ ಇವ್ರದ ಲಾಸ್ಟ್ ವೀಕ್ ಇದೆ ತಮ್ಮ ಮುಂದೆ ಒಂದು 32 approach the government under revision jurisdiction.
This case my lord, small site 20-30 site my lord.
ಎಲ್ಲ ಅವೇ
ಕೂಲಿ ಕೆಲಸ ಮಾಡ್ತಾರೆ ಮೇಲೆ.
But the apex court has remanded it to the government consider and to formulate a scheme because there are so many sites like this. ಒಂದು ಎರಡಲ್ಲ
ಒಂದು ಕೇಸ್ ನಲ್ಲಿ ಇದೆ ಸರ್ ಕೇಸ್ ನಲ್ಲಿ
ಇಲ್ಲಿಂದ ಇವಾಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದ್ರೆ ವಿಲ್ ಹ್ಯಾವ್ ಟು ಯು ಕ್ಯಾನ್ ಆಲ್ಸೋ ಅಪ್ರೋಚ್ ದಿ ಎಕ್ಸಾಮ್
fact my lord,
we cannot pass any order contrary to that.
Really the so far as rule is concerned my lord, it was allotted in the 2002.
ಇಲ್ಲೆಲ್ಲ ಆಗಿರೋದು ಅಪೀಲ್ ತಗೊಂಡು ಹೋಗಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅದು ಆರ್ಡರ್ ಆಗಿದೆ.
All these points have been urged and considered.
ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡ್ತಾರೆ, ರೆಸಲ್ಯೂಷನ್ ಪಾಸ್ ಮಾಡಿ ಆ ರೆಸಲ್ಯೂಷನ್ ಪ್ರಕಾರ ಟೈಮ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತಾರೆ ಕೊಡ್ಲಿಕ್ಕೆ. As per that resolution, they have to issue notice to petitioner. No such exercise has been done by the MODA. But even the cancellation letter was also not communicated. Only worker melada.
Cancellation letter was not communicated.
Not communicated.
It was sent to the address furnished by the petitioner. It had come back with a postal shara, no such person in that address. We have discharged our responsibility of not sending the notice to the address which the petitioner has furnished. Not all the earlier notices which were issued, not have been served. Even the letter of allotment was served to the same address.
No.
Not the of recent, not this, the Honorable Supreme Court has held. But insofar as the change of address is concerned, it is the allottee which who has to communicate to the institutions.
But what is the address that 17?
Yes.
Considering the my lord,
Make sure P Milord is cancellation.
petition of the petitioner, my lord. One case, my lord,
This is
amount ready, my lord. Vivekananda ಅವರು appear ಆಗ್ತಾರೆ case ನಲ್ಲಿ. Same similar circumstances.
the direction.
2030 site sunset.
ಅದೇ ಎಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿ ಬಂದಿರೋದು. ಅಲ್ಲೇ ಡೈರೆಕ್ಷನ್ ಆಗಿದೆ.
Where facts and circumstances are different, my lord. Wherein, my lord, ಅಲ್ಲಿ ಸರ್ಕಾರ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿತ್ತು, ಯಾರು ಅಮೌಂಟ್ ಕಟ್ಟಿರ್ಲಿಲ್ಲ. But here, my lord, she paid a substantial amount, my lord. Court can consider, my lord, considering her, my lord, she holy worker, my lord. ಸ್ವಲ್ಪ penalty interest ಹಾಕಿ, my lord, there.
You cancelled it when?
In 2003.
2003.
Which petition is filed in 2003.
And also they passed ಎರಡು ರದ್ದತಿ ಆದೇಶ ಮಾಡ್ತಾರೆ. 2002 ಅಲ್ಲಿ ಒಂದು ಮಾಡ್ತಾರೆ, 2003 ನಲ್ಲಿ ಒಂದು ಮಾಡ್ತಾರೆ. And both cancellation have been not communicated to the petitioner.
You challenged it in 2017.
Educated lady, my lord, our authority keep on requesting authority na ದುಡ್ಡು ಕಟ್ಟಿಸ್ಕೊಳ್ಳಿ. ಸಾವಿರದಲ್ಲಿ 70% ಕಟ್ಟಿದ್ದಾರೆ, my lord.
Honorable Court, even in one case, Milord, the due was only 1,500. But even that petition, Milord, the petitioner was relegated to the revisional authority. It is not the quantum which.
This case is concerned, my lord. This fully worker, this is a small site, my lord, 25. Fully worker direction.
Time bound direction may be issued to the revisional authority.
After vacation, my lord, one chance hold.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಇದ್ದಾಗ ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಕೌನ್ಸಿಲ್
ಕೆಲವೊಂದು ಕೇಸಲ್ಲಿ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದೆ, my lord.
12 June.
Please.
104, PM Siddhamalappa.
None appears for the petitioner. Shri Pawan Kumar is directed to accept notice for respond number 1 and 2. This is direct print his name and delete the name of Dr. R. Ramchandran as that appearing for respond 1 and 2. We list on 13/6.
105.
Your Lordship, serial number 105, I appear for the petitioner.
Yes, madam.
The argument comes unwell, Your Lordship. Your Lordship may have the matter after vacation.
05. The request of counsel.
Interim order may kindly be extended, Your Lordship.
13/6 interim order earlier granted is extended.
Much obliged.
10.
Retire from that.
I have no instruction and written to RPD also.
What happened?
He left without instruction. I'm retrying, but I'm.
Counsel for the petitioner has filed a memo of retirement. It is 10/4/2023 along with the memo of retirement and notice dated 13/3/2023. The address is the petition or no?
The address. In fact, the dispute relates to that story.
Archaeological survey.
The address.
ಪಕ್ಕ ಅಂಗಡಿಗೆ
Client address ನೀವು ಸರಿಯಾಗಿ ತಗೊಂಡಿಲ್ಲ. Notice dated 13/3/2023 issued by the counsel for the petitioner to the petitioner looking for instructions on failure thereof intimating that the counsel would retire from the matter. The postal track record has also been annexed to the said notice, which indicates that the addressee, that the said notice has been returned on account of the addressee having left without instructions. The petition, the counsel not having any instruction cannot prosecute the matter. As such, he is discharged. The notice issued by the petitioner, by the counsel to the petitioner having been returned with the endorsement addressee left, there would be no requirement, no purpose served by this court issuing any notice. That apart, the issue in the present matter being in relation to the petitioner running a business in the near a archaeological site, the petitioner having left the said address, nothing would survive for consideration. For all the above reasons, the petition stands dismissed.
107, SV Prakash.
My lord, serial number 107, I appear for the respondent number 2.
Yes.
In this matter, your lordship, the petitioner has sought for correction of the extent of the land. My lords, I may be permitted, your lordship, to take your lordship to page number 25, your lordship.
First, let us hear the petitioner matter. Who is appearing for the petitioner?
Shri SV Prakash is appearing on behalf of the petitioner.
Madam?
Appear for petitioner, my lordship.
Yes. What do you have to say?
Kindly have it after vacation, my lordship.
At the request of counsel for the petitioner, released on 13/6.
102.
I am for the respondents 1 to 3, my lordship. In serial 108, my lordship.
Ready?
Ready.
Yes.
The petition challenging the order passed by the second respondent. Brief fact of the matter is that the petitioner purchased the scheduled property in the year 2004, and he got issued himself the khata also, and he has been paying taxes from the past several years. Later on, my lords, in the year 2013, another sale deed purportedly is made with respect to the same scheduled property, and the BBMP has issued khata on the said sale deeds also. So on the same scheduled property, my lords, two sale deeds are pending. And when I applied for khata to be transferred in my name, Joint Commissioner, second respondent, BBMP called for a hearing and has rejected our application for transfer of khata in our name state. And challenging that order, this read that order is at page number 160.
What happened to the suit?
Suit is still pending, my lordship.
What is the suit for? Is declaration sought for?
No, it's an injunction, sir.
Injunctions.
They have filed, respondents have filed it against. In fact, they have filed two petitions. When they failed to secure an interim order, my lords, they withdraw one petition and filed another suit, and that is pending. There is no interim order passed, and there is no impediment for the khata.
Two sale deed, you should know what you have to do.
Not my sale deed is prior, is the earlier one. I have purchased it prior to the 2014.
You have to get sufficient declaration for them to act on and get a khata on that basis.
Yes, I've been paying taxes. I've been in possession of the property.
The R4, I am told R4 is in possession of the property as per the orders, my lordship.
The site inspection, R4 is in possession. But
I have constructed sheds and
you give them money under whatever rate they will take it. That won't confer any right. You go and give them some money for the High Court also, they will take it. Hello, Mr. Jagdishwara.
But my lord, chronological order of the sale deeds clearly shows that I am the first owner of the scheduled property.
Two sale deeds that we cannot declare in writ petition. Our jurisdiction.
The petition was only challenging the order passed by the second respondent.
The petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that the application filed by the petitioner for issuance of the khata in the name of the petitioner has been rejected by the second respondent by order dated 16/5/2016 at Annexure V. The contention of the petitioner is that the sale deed that though there are two sale deeds in respect to the same property, sale deed of the petitioner is earlier in point of time, inasmuch as, and that in favor of respondent number 4 is later. And I said the same ought to have been considered by respondent number 2 while considering the application filed for issuance of kata. The perusal of the impugned annexure V indicates that a site inspection was carried out, and at that time, it was respondent number 4 who was found to be in possession of the property. Taking this aspect into account, as also the aspect of pendency of a suit in OS number 5610 of 2013, the application of the petitioner was rejected. Subject to the result of the said suit. In view of the said reservation, I am of the considered opinion that the impugned order does not suffer from any infirmity requiring this court to intercede. On the basis of the result of the suits which are pending in OS number 56.
No, my lord, 10020/14, my lordship.
5610 2013 and
10020/14. There are two suits.
5610 was withdrawn.
Yes.
This is the result of the suit in OS number 10020 of 2015. The petitioner could always approach the corporation for issuance of fresh data. With that observation, the above petitions can be disposed.
109. Yes, Sumati.
For respondents 4 to 6, my lord. Lord, can you give me 1 week's time, my lord? I have to file.
At the request of counsel for respondent number, none appears for the petitioner. At the request of counsel for respondent number 4 to 6, 3 weeks' time is granted to file statement of objection. Relist on 13/6.
Would like.
110. P. Kumar Raju on connected matters.
None appears for the petitioner. 10 only. CH Devendra has entered appearance for respondent 125. Delete R. Ramchandran as that appearing for 125. 110.1. Sri Devendra has entered appearance for 125. Delete K. N. Puttegowda as that appearing for respondent number 125. What are these matters?
We have issued eviction notices. They were owners of the tenants of the shops. We have issued eviction notice in the year 2016.
114. And what is 114? Why the Taluk Panchayat? Sorry, 114.
114 does not have.
No, sorry.
Pertaining to BBMP, my lord.
Relist on 13th.
My lord, 114 can be separated, my lord. It is not.
114 is a different matter.
Yes,
ma'am. It's a continuation. 111. You could get 13.
Serial number 6. 111. Devi Prasad Shetty.
Can you take up the matter after the application?
At the request of both the councils, 13/6 interim order earlier granted is executed.
112. Ramesh P. Kulkarni.
In 112, I appear for the respondent number 1 in this matter, Your Lordship.
Yes.
I appear. I'm the absolute owner of.
You are ready.
Yes, madam.
You are ready, madam.
My lords, I have to seek instructions with respect to whether the extent of the property as claimed by the petitioner, that is encroached by the municipality, belongs to the petitioner itself, or it is a municipality property, Your Lordship.
There is a strange allegation that municipality is encroached. So you better get instructions properly. 112, Learned Counsel for respondent number 1 seeks for and is granted 2 weeks' time to obtain instructions as regards the extent of property owned by the petitioner and that owned by respondent number 1. Relist on 13/6.
Much obliged.
113. Vilaygiri.
The petitioner, by order dated 20th March 2017, this petition was adjourned sine die pending disposal of a writ appeal.
Writ appeal 1528 of 16, that is still pending, Your Lordship.
It must be dated otherwise. Where counsel for the petitioner submitted while order dated 23/20/2017. Writ appeal is still pending.
Pending, Your
The matter is adjourned sine die pending the disposal of WA number 5128 of 2016. Counsel for the petition submitted WA number 5128 of 2016 is still pending.
1528.
1528. ಇಲ್ಲಿ 5128 ಅಂತ ಅದಕ್ಕೆ ಇದೆ ಲಿಸ್ಟ್ 5128 1528 in the order it has been mentioned as 5.
Yes, Your Lordship. Mentioned.
Registry is directed to post the matter after disposal of WA number 5128 of 2003.
Your Lordship, for correction.
1528 of 2003.
Great.
That 158.
114, dear Sanjeev.
The petitioner, my lord, your lordship may call this on Monday, my lord.
He'll have it after vacation, but who are the counsels for R2 and R3?
Oblige, my lord.
R2. MS Devraj accepts notice for respondent 2 and 3. Counsel for the petitioner to furnish copies of the petition along with annexures on the said counsel. In a proposed R6 Tahsildar. Yes. Accepts notice for respondent number 6. Who are 4 and 5?
4 and 5. Will serve copy on them.
Who are 4 and 5? Private, issue
Three
notice.
respondents.
Amendment.
When the pleading application is for government.
4 and 5 we are.
Government.
Yeah. Okay, 4 and 5. Learned AG accepts notice for respondent number 4, 5 and 6. Released on 13/6.
150, MS Nagaraja.
Now, place for the petition released on 13/6.
117, Narayana K.
Same.
119, DN Prakash.
Earlier grounded map.
Grounded. Yes. The petitioner before this court looking for the following reviews. In the present matter is already been decided by judgment of the coordinate bench of this court reported in ILR 2021 Karnataka 3968. Hence I pass the following order. Para A. E to J. Is there any deposit you have made? Refund?
Yes, my lord.
E to J.
Hundred and 20, Hasina J.
Counsel for respondent number 1 seeks for and is granted 3 weeks time to file a statement of objection. And AG accepts notice for.
I will take notice for R2 also.
R2, yeah, Commissioner Revenue.
Commissioner of the.
Say, Counsel, Shri A.V. Gangadharappa accepts. Shri A.V. Gangadharappa, who has entered the appearance for respondent number 1, accepts notice for respondent number 2 also. Registry is direct print his name as such. He seeks for and is granted 3 weeks time to file a statement of objection. Objection is pending by 31st May. We list on 6th June.
122.
And 13th June. Yes, sir. Despite the order dated,
27th March.
none appears to be also not in.
123.
I have the petitioner in this matter, madam.
123.
Yes, madam, 133.
123, Muralidhar action. Muralidhar versus Muralidhar. And appears to the petitioner released on 13th days.
124.
Vinayji?
Yes. It is between petitioner and court.
I appear for respondent number 4, my lord.
Released on 13/6.
126. P. Gangadhara.
13/6.
128.
15/6.
129.
15/6.
130.
15. Interim order already extended.
So, for the impeding applicant, your
So 5 ಗಂಟೆಗೆ ಎಲ್ಲಿ ಪಾಸ್ 15/6.
131.
15/6.
132.
15/6.
33.
I have the petitioner in this.
15/6.
34. Mataji Kulkarni.
15/6.
135.
15/6.
137.
15/6.
Sadly, 135 could it be at the first week of
15/6. 138, 15/6.
139 is absent, my lord, because if the fifth respondent declares election, then my very requisition becomes infructuous. And after to Nadala Nadu on top of this.
Election
Formation of the wards in Bajpet Town Panchayat.
139 who appears for the respondent.
Election Commission.
You are early, Mr. Shafi, will they declare? They are already busy with this election. They won't declare anything. Have it immediately after vacation.
Day after tomorrow on top.
They won't. They are very busy with this. You'll appearance to Barala. 139. Released on 22nd. Liberty is however reserved to the petitioner to move the vacation court in the event of elections being notified by respondent number 5.
22nd.
22nd. The opening day.
22nd May.
Nothing will happen till then.
I pay for petitioner.
Respondent number 4, objections returned.
I pay for objections filed. Happy is also, sir.
In,
We are recording lots of
in office objections.
Legible
Copy
copy.
copy.
Legible copies. Counsel for respondent number 4 seeks and is granted 2 weeks time to comply with the office objection. Released on 16/6.
141.
Madam respondent stood.
I've received, please, my lord, the instructions. I'll have to, my lord, file my objection. My lord, 2 weeks I will pray, please.
And for respondent BDA. Last occasion, not there was a direction not to verify not issuance of TDR not 2012 we execute release date.
Although 2015 year, the ATCP Act amendments have come inside, my lord. I'll have to analyze that, my lord, and I'll file my objections. The amendment ಆಗಿರೋದು ಕನ್ಫ್ಯೂಷನ್ ಆಗ್ತಾ ಇದೆ.
2012 ಲೆಕ್ಕ ತಗೊಂಡ್ಬೇಕು ನೀವು ಅಮೆಂಡ್ಮೆಂಟ್
2015 ಚೇಂಜ್ ಆಗ್ಬಿಟ್ಟಿದೆ ATCP Act.
ಆದ್ರೆ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ 2012 is
applied before that with all the documents and the
if
verification.
you had given it in 2012, Mr. Munish.
So please not now what happens is any of the cases, please not what we are seeing is 2012 apply ಮಾಡಿರ್ತಾರೆ. NOCs ಕೊಟ್ಟಿರೋದಿಲ್ಲ 2017 NOCs ಕೊಟ್ರೆ 2015 ಅಲ್ಲಿ if it changes
If they complied with everything,
if they complied with everything, please not yes we can examine.
If
If complied not
draft
most of the cases
let me make a submission.
now what happens is planning authority, please Millard, will have to issue, please Millard, the validation, please Millard, of the TDR. It is no longer vested with us. So therefore they'll have to go to the BDA. Because BDA has filed objections stating that
If they had complied with everything
yes,
prior to
the amendment.
you have to give it.
Yes, Millard. Not in most cases, Millard, the NOCs they are not secured.
If they have not complied, that's a difference.
Yes, yes.
General statement not at page 228 was submitted the form draft also.
He wants to go through it.
I'll find my,
Your certificate is also there.
not the draft of the form 1. I produced it. I will file my objection. Even the note sheet notes of just now I've received.
Respondent for 2 and 3 seeks fund is in 3 weeks time. File a statement of objection released on 2nd June.
Right, sir. Great.
142.
Bellary Urban Development Authority. You are in this side behind us. Bellary Urban Development Authority. None appears for the petitioner released on 16th June.
143.
If you have to respond.
Appears for the petitioner 16th June.
4. Legal counsel.
147, I am appear for the petition.
None appears 16th June.
45.
I appear for the respondent, my lord, 147.
145.
45 now. Actually, the endorsement.
We should end. ಏನಂತ ಇಶ್ಯೂ ಮಾಡಿದ್ರು ಚೆಕ್ ಮಾಡಿದೀರಾ
ಕ್ರಾಫ್ಟ್ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದೆ
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ
ಇಲ್ಲ
and counsel for respondent filed a memo enclosing a endorsement. The same is taken on record. Copy to be served on the counsel for the petitioner. Released on 2/6.
146.
Petitioner, my lord, for respond number 3, but I was directed to file statement. So I couldn't file it today.
Counsel for respond number 3 submit that he has filed a statement of
Show the copy.
issued the copy. The petitioner seeks for 2 weeks time to go through the same and make a submission. Released on 2nd June. Interim order earlier granted is extended.
47.
I appear for the petitioner, my lord.
I appear for R2, my lords.
Released on
The endorsement is challenging. He is asking to execute the sale deed in favor of the licensing authority. License is approved for put up the construction. For issuing the license, we have to execute the sale deed in favor of the corporation. That is what the endorsement is given at annexure A, page 10, my lord.
why a relinquishment deed, madam?
And it's the appearing counsel is not feeling well, my lords. Kindly adjourn the matter, my lords. We are for R2.
7 at the request of counsel for respond number 2 and 3. Released on 13/4.
Much obliged, my lords.
The respondent number
48. Released on 13/6.
149.
None appears 13/6.
150.
respondent number 3 and 4.
15/6.
151.
Pursued before vacation. 70% of land is released, 30% of land is retail. Not insisting there are extension.
Certificate is not.
Certificate is there. They are insisting extension. Short point.
My lord, already my lord is expired on 2021 itself. My lord is.
Yen expire again.
Era certificate.
But by that time, we have got NOC from all the competent authorities. All the authorities, we got the.
What have you to issue now? What have you applied to them?
Not town and country planning, not the sir. We have developed the land. 70% of land is released. Only 30% of land is to be released. They told us to deposit the amount. We deposit the amount. They told us to get approval from all other authorities. We got the authorities. Now at this stage, they are telling you get extension certificate from RERA.
When you made this is a 2023 matter.
23 madam, the project not detail not the after vacation not the.
This was filed at that time of 21 before RERA applied.
No, endorsement is given at later stage.
When did the RERA?
No, that is 2016 act. We got the.
When did your registration?
Not registration. We had in the year
18.
No. 16 not thereafter in the COVID not that price they got extended.
Is the registration valid as on the date on which you made an application?
Not the as on date, it was a project which has already commenced before RERA.
Was it valid?
No, it was valid, it was, we have concluded the project by that time.
It's valid, my lord, and also he submit the rare certificate.
They are telling as on that date, They want,
As on the date of an application for release, was the RERA registration certificate valid?
no, it was valid. It was valid. Thereafter, they took 6.
It is valid.
But Indian problem.
ಅಲ್ಲ ಅದು ಆ ಟೈಮಲ್ಲಿ ಮಾಡಿಲ್ಲ 2 ವರ್ಷ ಇತ್ತು ಅವ್ರಿಗೆ 2 ವರ್ಷ ಟೈಮ್ ಇತ್ತು ಅದೆಲ್ಲ 2 ವರ್ಷ ಟೈಮ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ.
They will bear their whatever they have to pay, they'll pay. Not
No, that is also paid, my lord.
if you don't issue, they'll have to pay more.
And there's
No, that is also paid. my lord.
section 17(2)(c) very clearly say that, my lord. The RERA certificate should be produced before the authority, my lord.
ಇದೆಯಲ್ಲ valid ಇದೆಯಲ್ಲ.
ಅಲ್ಲ ವ್ಯಾಲಿಡ್ ಇಲ್ಲ ಅದು ಅವರಿಗೆ ಅದನ್ನು
ಅದೇ ಕೇಳ್ತಾರೆ valid ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ.
ಇಲ್ಲ ವ್ಯಾಲಿಡ್ ಇಲ್ಲ ಸಾರಿ
Lord,
ಸಾರಿ
as on the list, lordship, I will take a chance, lord, before vacation.
If the RERA certificate was not in force as on the date on which you made the application, then they can't give. Because in force we can direct it. Not in force, please get it renewed.
Lord, I can't renew because there is a prohibition under the act. Only one extension is there, my lord. But as on date, I have concluded the project.
There is a prohibition for them to issue. So you challenge that act or something. There is a stalemate.
challenge for this honorable court, my lord, is pending.
Town and country plan amendment.
We can give them a mandamus contrary to law.
So I take only a chance, lord, if possible.
Have you challenged it in this?
Yes, lord.
Have you challenged the 17C or have you challenged?
Not 17C because I can't challenge because the amendment came only in the 21-22 minutes.
You take a chance. 151 relist on 17th April.
153.
Let's.
152, my lord. Division of permission, the property. Shumaga urban development.
Counsel for respond number 2 seeks for is granted 2 weeks time to file his wakalatnama and statement of objection. Objection is pending by 25th May, released on 29th May.
My lord, so serial number 152, my lords, they have not informed. But there is an urgency in the.
ಅವರೆಲ್ಲ petitioner move ಮಾಡಿದ್ದು.
ಹೌದು, so ನಾನೇ petitioner 152.
152 petitioner has moved.
So I have not taken any adjournment.
Somebody moved it as petitioner.
No, my lord.
Mr. Jagdishwara will not move for adjournment.
There is
ಯಾವತ್ತಮ್ಮ
30th.
152 date.
day after tomorrow. ಯಾಕಂದ್ರೆ ನಮ್ ಫೆಮಿಲಿ ಮುಂದೆನೆ
17/4.
154.
54 released on 15/6. 15/6.
158.
Adjournment ಬಂದು.
Sorry, 154 is, sorry.
152 ಏನು ಮಾಡಬೇಡಿ. 154 17/4.
158.
16/6.
159.
16/6.
161.
16/6.
Petitioner may kindly have it this week or the next week. If there's an
Objection.
There's an urgency in the.
You got your license anyway.
Not that matter, Your Lordship.
Not that.
Another matter, Your Lordship.
Kind of application.
Your Lordship, there's an urgency for the interim relief. I have got all the permissions from all the authorities. There is only one condition that they have imposed, that I have to relinquish a portion in their signature for the sanction that they've issued. For such reasons, I'm not able to proceed with my establishment.
You can't ask for relinquishment.
Sections ಬರಲಿಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ.
ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್? ನೀವು ಇದು ರೆಲಿಂಕ್ವಿಶ್ಮೆಂಟ್ ಫ್ರೀ ಆಗ್ಬೇಕು. ಯಾರ್ಯಾರು ಕೊಡ್ತಾರೋ ಫ್ರೀ ಆಗಿ ತಗೊಂಡ್ಬಿಡೋದು. ಯಾರು ಇಲ್ಲಿ ಬಂದಾವ ಒಂದು ಆರ್ಡರ್ ಆಗಲ್ಲ. ನಿಮ್ ಪಕ್ಕದವರು ಅದೇ ಮಾಡೋದು.
As per the law, my lord, without challenging the law.
How can you ask for relinquishment to issue a plan?
ಅಲ್ಲ 2023 ಮ್ಯಾಟರ್ ನನಗೆ ಲಾಸ್ಟ್ ವೀಕ್ ಆಗಿರ್ತಕ್ಕಂಥ ಏನ್ ಆಫ್ಟರ್ ಆಕ್ಷನ್ immediately after action immediately ಮ್ಯಾಟರ್
161 22nd May.
Your Lordship, this month, Your Lordship.
This month won't happen, madam. It won't reach.
Next week, Your Lordship, because I'm not able to proceed with my.
Wait for some time. 163.
Manoj, 162, I appear for the respondent.
162, 16/6, 163, 16/6, 165, 16/6.
Second is 1.2 and 1.23.
That's why they have come, is it?
Even the date as 5/4 because it was a holiday, it may have come all the ground rent matters.
Because the 2-day holiday, everything is done.
These two matters,
Give us.
Serial number 159. Just it is a matter for correction of date of birth in the birth certificate.
Again, it being spoken to him.
yes, my lord, sir. Serial number 1.22, my lord, sir. That ground rent amount has to be changed, my lord. Same in serial number 1.2.
1.23.
Six one eight four ಮತ್ತು 6416 ಎರಡು ಮೇಡಮ್ 6184 ಮತ್ತು 6416
Madam, what to do with your matter? Those 2 days holidays, every day now we are getting 150, 160. And next week is again going to be the same. In vacation, we need to have probably 1 or 2 days special sitting and take it up and finish it.
24.
Would that be okay?
Fine.
We'll take it up on 24th and 25th and madam's arguments we can close. So is it to recharge the error kashta? Madboda? Verify if the permission can be granted. We'll just give you a date. If permission is granted on 24th, we can argue the whole day and finish.
Yes, your lordship. Lordship, in case.
New York argument.
Why for that, Shuprabhu Iremit will be Shuprabhu Iremit will be assigned by us.
Shivprabhu Iremit. Dharwad in the Bartar. As the argument, then it won't reach on. And you will argue for 15 days. You won't give.
He's been assigned this matter.
You said the AAG will be appealed.
I got instructions that Shuprabhu Iremit will be assigned the matter.
72, release on 18th. That's it. Occasionally 1 day, special sitting matter.
Serial number 1.22.
Madam, we'll have it on 18/4. By that time, let them find out what is if there is any permission required and to have it to take it up in the vacation. On that basis, we'll give you a date and you can take it up. In the early part only, the first week only we'll take it. Yes.
Serial number 1.2, interim order ಅಲ್ಲಿ in the table, the amount mentioned, the ground rent GST has to become 3,84,72,269 plus 2,16,68,459.
Write it down in a piece of paper.
Very well, my lords, I'll write it down.
Petitioner submits that in serial number 2, in the table under para 4, the amount has been wrongly shown. And the same needs to be corrected to so and so. This submission is accepted, registry to carry out necessary correction. Akella same.
1.2, in 1.23, my lords, the stay on labor cess is missing, my lords. Labor cess stayed and subjected to the condition that the said demand would be met as and when obligation to make said payment arises in terms of building and other construction.
That is not there in the earlier orders.
It is there.
Same thing.
May I just pass on? The memo
Where's the order copy?
The order copy notes as this. My lords, may kindly see point 16. Point 16 of the earlier serial number 16 of the earlier labor says
So this is in 2058.
it is all connected matters. I've produced all the connected matters.
We have taken 4849 into account. 4849.
That is also produced, my lords, in that 4849 with that.
And counsel for the petitioner submit that the by inadvertence, the order of stay as regards labor cess has not been mentioned. Hence, the following shall be inserted at serial number 13 to table under para 3. Labor cess relieved under serial number 13. Demanded labor cess. Leave granted. State subject to condition that the said demand would be met as and when obligation to make said payment arises in terms of the building and other construction workers welfare cess rules 1998. Registry to issue a corrected copy of the order.
Number 159. Urgency.
Order date.
Submission, my
Dates.
lord. Second list 1.15, my lord. The cop has not served, my
.15.
lord. 1.5.
Siddhartha is not here. You can direct him. We list on 2nd June.
Serial number 159.
Uh,
To admit the petitioner daughter to school, the birth certificate is to be corrected. Wherever there is an urgency.
159, where is it?
BBMP.
159 reads on 13.
My lordship,
School admission.
School
ಇವಾಗಲೇ ಮಾಡಬೇಕು.
birth certificate ಅಲ್ಲಿ correction.
ಇನ್ನೇನು ಸ್ಕೂಲ್ ಇವಾಗಲೇ ಮಾಡಬೇಕಲ್ಲ ವೆಕೇಶನ್.
My lordship, serial number 132. Serial number 132 to show my name in the registry, my lordship. Respondent.
So the name source.
Court officer? Court officer?
Madam, 132 after the case.
Sir, ಹೇಳಿ.
148.
Sir, 148 to 13-6.
Oh, ಧನ್ಯವಾದ.
The one about
161, madam.
22-5.
Thank you.
Ma'am, list to 1.1.
ಅದು 2-6.
Okay, thank you, ma'am.